Hello, everyone. It is nice to meet you in this remote online conference, and I want to welcome everyone. Today, we're gonna talk the whole day on building laws and codes in Europe, past, present, and future. And we're gonna have 24 presenters from 20 different jurisdictions of EU. So welcome everyone who joined us in this remote conference. And first of all, I want to invite the Minister of Ministry of Environment of the Republic of Lithuania, Minister Simonas Gentvilas, who will give us a welcome speech.
Thank you, Evaldas. Dear ladies and gentlemen, despite the fact that we will be 10 hours almost in distant connection, I hope the attention will be very attentive, and I know we are good at multitasking nowadays, but this is a special conference for us because we as a Ministry of Environment, who is in charge of both construction and spatial planning, are reorganizing our view on building codes in Lithuania. So I'm very happy to introduce myself as a ministry and Mykolas Romeris University and WALLESS law consultants in this conference. What we are trying to achieve in upcoming years is to divert our legal basis towards building code, which has been developed and used in many Western European countries, and much of your practical knowledge will be very interesting for us in order to take the best examples in upcoming half year, where we will discuss our legislation changes. What we are trying to achieve is one window service, one legal act, where all the building codes will be synthesized instead of nowadays, where we have increasing amount of technical regulations which sometimes contradict each other. We would like also to change our perspective and look at building codes as more as a performance-based regulation rather than descriptive-based regulation, which is currently the case in Lithuania. In order to facilitate innovation, we are seeing building codes as something which could foster different choices of technical solutions by competent market actors and professionals. So once we set the performance-based approach, we could foster also innovation. We also look at building codes as something which could increase the easiness of application for professionals and practitioners, and especially for clients both in construction industry and policymakers. I don't know, we are looking also forward for examples how Western building codes could reduce administrative burden, but seen from our perspective, it's something which we would like to achieve with our current change. Of course, the IT solutions are to be applied much more in a broader sense, and currently when we talk about blockchains, artificial intelligence, and how it could be introduced in construction and designing industry, this is also a matter of discussion in this conference. Finally, we would like to develop a feedback procedure for our building codes, and we would be extremely thankful if you could make a practical examples of how building codes have been implemented and revised yearly, annually, or maybe monthly, with feedback from practitioners, construction industry, and academia sectors. Finally, Lithuania is a small country with small capacity of professionals working in construction industry. And we would like also to synchronize our building codes with European codes in order to both have a know-how of European standards and both to be an open market for foreign professionals to work in Lithuania. Those are the key expectations for this really exceptional conference, and thank you. And if you could touch those subjects, we would be extremely happy. So thank you, Evaldas, for giving a word. Best luck with the conference.
Thank you, Minister. And yeah, I think we're gonna touch all those questions, and we're gonna have a whole day of various presenters who will touch different topics. And I'm extremely happy that among the presenters will be not only practitioners who are acknowledged by the main directorates such as Legal 500 and Chambers Europe, and the best attorneys at law from the whole Europe, but also we're going to have professors from various universities. And therefore, I inviting now the Professor Inga Žalėnienė, who's the director of Mykolas Romeris University, who's also one of the organizers of this conference, to give us a welcome speech.
Thank you, Evaldas. Good morning, dear partners, dear colleagues. On behalf of Mykolas Romeris University academic community, it is my honor and pleasure to welcome all of you at this international online conference, Building Laws and Codes in Europe, Past, Present, Future, organized together with Lithuanian Ministry of Environment and Law firm WALLESS, which is devoted to the analysis of regulatory frameworks, recent changes and future trends of construction law in different EU jurisdictions. It is delightful to see that today's conference managed to assemble such a great number of legal scholars and practitioners of the highest competence, recognized by Legal 500 and Chambers Europe international directories from almost all European Union countries, which agreed to share their valuable time, thoughts, experiences, and insights. While facing COVID-19 pandemic and recent technological developments, we are all witnessing a rapid evolution of legal relations. And of course, our legal systems are facing even greater challenges, both to standardize the new relations that are emerging and to adapt to the changing legal relations. This is a challenge not only for legislators, but also for the executive power, also judges, other institutions working in law enforcement and application. Recent changes are particularly evident in the field of real estate, which is currently experiencing a very high level of activity in many countries. This is caused by increased investment in the real estate and construction sectors. At the same time, the construction sector is facing the challenges of broken chains, changes in labor market, constant lack of workers, and application of new technologies. This is not the result of overnight phenomena, but is a long-term process to which the legislature cannot fail to react, nor can legal science, especially if we see legal science as one of the engines that help to overcome the challenges faced by those involved in relevant legal relations. Our university is the place where new ideas and new solutions are constantly born and revisited. That's our purpose, and that is our daily work. We need a strategic mindset to build green, smart, and comfortable houses and cities. And I am sure we will, as long as we all collaborate and join forces of those who are the best in the field. Construction regulation in the European Union that suits interests of business, countries and citizens is in high demand. That's why it is so important to explore the intersectional approach to this matter. I wish you all a productive session, which will contribute to the successful adaptations to the challenges of today's world. Thank you.
Thank you, Professor Ilze, and for this warm welcome speech, and also thanks for once again for Minister Simonas Gentvilas for also warm welcoming speech. And as we see all the presenters and speakers today, we're going to have a lot of work to do. And the whole conference is divided in 5 different sections because we have presenters from various EU countries. So the first section will be regulations in the Baltics, the second one, regulations in the Nordic jurisdictions. The third section will be regulations in Central and Eastern EU jurisdictions. The fourth section will be regulations in Northwest EU jurisdictions, and the final, the fifth one, regulation across South EU jurisdictions. I already wanted to start the first hour section. It's regulations in the Baltics, and here we're gonna have 5 presenters. I will present the Lithuanian case. Then we have 2 presenters from Estonia, Siim, Vahtrus, and Kaido, Loor. Also 2 presenters from Latvia, Ilze, Kramina, and Lelde, Lavina. After each presenter will present their specifics in their jurisdictions, we're gonna have a small discussion on the Baltic situation, because as far as I know, the regulations, construction regulations in all Baltic states are very, very different. So I want to start with my presentation, construction law development in Lithuania, and what are the trends and what the historical issues we should talk about. So law on construction was enacted back into 1996 on the 19th of March, and this law is establishing the essential requirements for all construction works which are being built, reconstructed, and repaired with the territory of the Republic of Lithuania. And it settles all the procedures for technical regulations of construction, construction investigation, design and construction works, construction, reconstruction, repair, and so on. The law was enacted, as I mentioned, in 1996. Since then, the law was changed more than 46 times. It means it is changed almost twice a year. So we see that this law on construction is changing really rapidly, and Lithuania, when we talk about construction law, is living on all the time on some changes in the law itself. The other big law is the law on territorial planning, which regulates zoning and planning issues, and was enacted back to 1995 and went into force in 1996. And this law regulates territorial planning of the territory of the Republic of Lithuania, its continental shelf, an exclusive economic zone in the Baltic Sea, and establishes the rights and duties of persons involved in this zoning and planning process. And the same situation as we had with the law on construction, the same is with the zoning and planning law. And what we see since 1996, there were made 45 amendments of this law. And I'm already not talking to essential reforms, which, for example, were made back in 2013, when the whole wording of the law was changed. Besides these 2 main laws, law on construction and law on territorial planning, we in Lithuania have other laws as well. As I already mentioned, we had a big reform back in 2013 on zoning and planning. And together with that reform, a new law was enacted on territorial planning and construction state supervision. So this law is devoted only to territorial planning and construction inspectorate. What inspectorates can do, how to find those who are not obliged by not taking right undertakings under the law, and so on. Despite that law, we also have a new law which was enacted back to 2017, law on architecture, which indicates what is the public interest in architecture, how architects should communicate with the clients, with the communities, that the architect is the central figure who creates the surrounding environment. And totally, absolutely new law, which was enacted last year and came into force this year, is law on infrastructure development. To be more precise, on municipal infrastructure development, which also tries to fight with the challenges which we have in zoning and planning and construction, because every construction faces the public infrastructure and public a need to renew the public infrastructure it touches. So to sum up, we have large amount of national laws. As I mentioned, law on construction, law on zoning and planning, or only on territorial planning, law on territorial planning and construction supervision, law on architecture, law on municipal infrastructure development. And despite these 5 main laws which directly touches construction, we also have different other laws, such kind as a law on environmental impact assessment, law on environmental protection, law on immovable cultural heritage protection, law on renewable energy, where we have different sections in this law which regulate construction processes and makes a huge impact in construction processes and regulations. So as we see that construction regulations are split between different laws in Lithuania. Despite that, we have even larger number of national bylaws. And for example, at the moment, we have 60 bylaws, which are named as construction technical regulations. And we try to put all these construction technical regulations, normative rules in one document. And we received a document of more than 6,000 pages. So as you see, Lithuania is a considerably small country, but there are a huge amount of regulation. And I'm not talking about other regulations for construction industry, such as Eurocodes, which are also should be used in Lithuania, but also Lithuanian standards, which are real technical documents saying how engineers should and designers should work and perform their duties. And you see in the picture the beginning of the 60 construction technical regulations, which we have a considerable amount of. Therefore, there is a question, maybe there is a necessity and demand for codification, because those frequent amendments of the acts, and especially its procedural provisions, are so frequent, and the market participants are really tired of that. For example, if we would take the order of the Minister of Environment, which regulates construction permits issuing and acceptance to use. So totally new wording was issued in 2016, and since then it was amended for 10 times. So it means that every year this construction technical regulation is changed at least twice, and it doesn't create any stability in the construction market. And the designers and other construction industry players, they always have to be up to date and follow all those changes in regulations. If we take other very important construction technical regulation, construction design and design expertise, it was also issued in a new wording back in 2016. And since then, it was changed 7 times. And the last, that regulation, construction technical regulation, construction design is composed of 155 pages of wording. And you see the picture, at least a half of it, it's 70 pages. And there are so many rules, and it all lists what should be written down in design documentation. So as we see, all those regulations, they are well structured, but there's a question, isn't it too large? And isn't it too large scale regulations we already have in Lithuania? And the conflicts between provisions of different legislation occurs because of that. There's a huge amount of this legislation. And there are plenty of formalities concerning design proposal and building permits. And it takes unreasonable time to thoroughly process all the requirements for construction. And what are the frequent issues we are facing at the moment? So it is quite difficult for ordinary consumers to really understand construction process and implement it without breaching the law. And construction between contradiction between those laws and bylaws, they are creating a lot of conflicts. And bylaws, they are trying to detailize the wording of the law, but then it creates new rules. And this scrutiny in structure and requirement from the law, it shows us that those requirements are not well implemented. So when we look at the long-lasting procedures in the construction process, they are really very long. So possible solution is maybe less is more, or one concentrated construction in our building codes, which could introduce all those new rules, could help for us. And the Ministry of Environment is talking about this at the moment. And what are the regulative trends? So if we look at the regulative trends in Lithuania, there are, of course, clarifications on clarifications to clarify already the clarifications we have. And this casuistic legislation creates a lot of problems. Then other regulative trend is that technical regulations are frequently changed by a requirement of public institutions. And there are a lot of rules who are made by bureaucrats, and they make their life easier. Then what we see the fluctuation of increase of administration burden, and then from time to time some easements in different laws, and then again administrative burden is rising. And when we look at other regulative norms, so we see that there is given more freedom to municipalities. As I already mentioned, there is enacted a law on municipal infrastructure development, which gave a lot of rights to municipal institutions to enact their bylaws and to regulate this municipal infrastructure development rules. Also, we see a trend to give more power to self-government institutions. It's, for example, my mentioned law on architecture. It gave a lot of powers to Architects Chamber of Lithuania, which makes the certification of the designers and planners. It also solves the dispute between the architects and looks whether the ethics of architect is breached or not. Also, they do certification, educational courses, and so on. So maybe that self-regulation is the future trend as well in Lithuania. And despite what is given by law from the central government, there are a lot of initiatives from municipalities itself, and for example, Vilnius municipality is adopting to climate change and introduces new greenery initiatives, which in public are distributed lately, whether it's follows the environmental laws and so on. So what's next? To sum up everything, I believe that construction regulation in Lithuania are in need of structured and explicit procedural regulations, and less legislation and more integrity would be much more welcomed. And municipalities should be allowed to set technical requirements on their own if they are in need of that, but those technical requirements from central institutions should be a little bit reduced. Meanwhile, procedures must be regulated by the central government, not to create various and different regulations in various municipalities, and the responsibility of those involved in the construction processes must be encouraged. And if we want to have less regulation, if we want to have more freedom in construction, then someone has to take a responsibility for that. And as the central figure of the whole design and construction process are the designers, certified designers. So maybe that would be a good move to give more responsibility for them, more liability, but then we have to talk about the liability insurance and other questions. But I'm already running out of time, and really I am willing to hear what my colleagues from Latvia and Estonia prepared. And therefore I'm inviting Kaido Loor to share his presentation, because as I was informed, Kaido, it was not seen my presentation at the very beginning, but yes, your presentation is seen. And Kaido Loor is managing partner at law firm Loor. He has considerable experience in real estate transactions, finance and development, including asset and share deals, advising major institutional and private investors on sales and acquisitions on development land and all types of commercial and residential real estate transactions, taxation, and many other. Kaido is and has been recommended practitioner in many publications, including Legal 500 and Chamber Europe Directory. So, Kaido, the stage is yours.
Thank you, Evaldas. Can you hear me?
Yes, we can hear you perfectly.
Super. Yeah, when it comes to the number of pages that various land laws take, and the frequency of amendments that Evaldas, you said that is mind-blowing, then actually the frequency of amendments shows that you are a very agile country. I would not want to be a businessman in a country where the laws do not change at all. So I would say that if there is if I can select between having 46 amendments and having 4.6 amendments, I would take the 46 amendments, and I would try to live with that. So maybe there is some good sides also to this. So, but going to my slides, I have a question about what is the structure of the laws in Estonia, and we have some historical background, and we actually also people from Lithuania share the same background, that up until Soviet times, all land was owned by the communists, so to say, and this is very interesting thing because at that time, giving building rights to somebody by the government effectively meant that the government lost the right to the land. So it was very important for the government to restrict the building, because government's land ownership basically terminated when somebody was able to lawfully build something. So at that time, it was really, really important for the government to control what is being built. But now all of the land is privately owned, and we do not have such worry for the government anymore. But maybe this explains still why the government wants so much to control the building. It's just a legal heritage that we have not been able to set behind us. So maybe there is a historical element that we should consider, and we should move more towards giving more rights to the landowner instead of the government. So So we have also had many sets of reforms in relation to building and construction and planning, and now we have a most recent one is from 2015, and it's two separate laws, the Building Code and the Planning Act, and we have then additional pieces of legislation that relates to more of the land, and we have many more pieces of legislation, and they are really kind of fragmented in some sense, but they are more or less kept in sync, so the quality of the text is pretty okay. We have also, what relates to construction, we have a funny document called Best Practices of the Construction, which was adopted by people who didn't have any authority to adopt it somewhere in 1991. The courts always cite that best practice of the construction is this and this. They disregard this funny document, and the funny document is really funny. And they tried to redraft it in 2020, it was a year ago, and I saw a draft document of that, and after my comments, the people withdrew their initiative. So we were able to avoid this sort of trouble happening there. What is interesting about the 2015 codification attempt is that it was really thoroughly prepared. The preparation was for 4 or 5 years. They were going through a lot of laws in Europe, and I believe maybe even in New Zealand. So there was a 900 pages preparatory analysis made before the laws were started to be drafted, and that is really interesting reading. It is, unfortunately, it is in Estonian. Maybe you can Google translate it or something like that. It's publicly available. Just email and ask, or make a search in internet, and you will find it. And the laws were also adopted together with very good explanatory notes. So let's say as to the quality of the text, it's pretty high, but it actually does not address all the problems we had. And as in any political situation, you will have interesting outcomes. And there were people who tried to reverse the Planning Act to the previous law a year ago, but luckily the government fell and the new government came into power, and this was taken off from the table. So basically, the 2015 improvement that we now see is that the general legal order was a bit more, in a better way put into the laws. It is more now in sync with the general principles of administrative law, and the roles of various players are a bit more clearer. But and there was some amount of more rights to build either without building permits or without detailed plans. But still, the process is very restrictive. In the cities, you still usually the process goes so that for 5 years you handle the detailed plan, and then for half a year you handle the building permit, and then the building itself takes only a year. So most of the time actually is spent on paperwork, which actually I'm not sure it benefits anybody in the end of the day, because usually what happens with the detailed plans is that they get outdated pretty quickly, because sometimes the shifts in the market are so that the demand of the buyers changes very rapidly, and kind of administrating a detailed plan and building permit for 5-6 years, that is loss of value, and we will come to the value question very soon. So we started with basically the problems. The local governments who are administering the detailed plans, building permits for use, they are very slow, and there are a few things that kind of come to our mind here. Estonian situation is that a lot of private housing, especially kind of single family housing, is without permits of use. It is, of course, the law prohibits it, but there is a very many buildings without permits of use. It's okay for the insurance companies. It is sometimes okay also for the banks. So life goes on, but we are en masse, we are breaching the law. So life goes on. Why should we have this sort of permit then at all? To bring you a funny example, we had a center in Tallinn, Solaris. A center was built about 10 years ago, and it was fully permitted together with a permit for use. But lo and behold, about 2 weeks after the permit for use, the suspended ceiling of the cinema in the Solaris Center fell down from the ceiling to the chairs of the cinema. So nobody was in the building, in this room at that point of time, so nobody was hurt. But my question is that obviously the permit for use didn't prevent the ceiling from falling down. So we really should ask the question, what is the benefit of this sort of permitting? Does it benefit anybody at all? Why do we have it? So, and now in addition to governments being slow, they start to be very greedy. Whenever there is a question that somebody wants to build an industrial site or a wind park, there is a lot of local opposition at the local residents level, at the local neighbors level, and also in the local government level. And this greediness has now actually expanded not only to industrial developments but also residential developments. It used to be more the case in the municipalities that are neighboring cities. The municipalities say that if you want to develop let's say 50 units of residential, we do not have the money for the kindergartens, we do not have money for the schools, we do not have money for the buses. They don't have money for anything, and they just refused from permitting and planning these residential areas. And this is a major problem, because there is, of course, it restricts the supply in the housing market, and this drives up prices. And now it's not only a question in the municipalities, now it starts to be a question also in Tallinn. So I'm currently in a situation with one developer where Tallinn city requires quite a bit for unlocking the rights that are already in the detailed plan. And the same applies to these wind parks. And we have this legal initiative now about the local benefits payment. And it is really funny that the politicians think that if a wind park developer pays something to the local government, then it makes neighbors happy. I mean, if you are a neighbor and you have a wind park next to your housing 24/7, then how does it help that the developer pays something to the local government? It doesn't help the neighbor at all. So the question, the answer to this situation where you have to tolerate an industrial site next to you or a wind park next to you, the answer is not in paying money to the local government. The answer is somewhere else. Maybe it is selling my land and buying something in addition. The local benefit law, as we said, if it is really enacted so, and the various developers need to start paying some sort of cash to the local governments, it creates a huge question of equal treatment. Let's say somebody is developing just one single house with 20 units, somebody is developing an area with 1,000 units. how do you treat them equally if the developers have to pay local benefits or some sort of taxes locally. And we have some trends that enable more submission, a better, simpler submission of digital material for the permitting process. There is less requirements for detailed plan, meaning that more and more buildings can be built with design conditions, which is a simpler process when compared to the detailed plan. So that the attempt is to move away from the heavy detailed planning procedures to the more simpler design conditions procedure. And that is, I think that is even, the trend should be stronger. I think that a lot of buildings in the city should be built only with building permit, and setting aside the detailed plans, setting aside the design conditions. It is enough if the local legislator can adopt the general urban plan for the let's say the city part of the city, and rules and conditions from there will be transformed to the building permit. So you do not have to have first the city plan, then the detailed plan, then the design conditions, then the building permit. You can really actually live with two of them, with the city plan and with the building permit. So it's even as it currently is and is planned, it is too restrictive. And then we have our own story with all sorts of parking ratios. For a good number of years, one set of parking ratios was really necessary for the city. Then wind started blowing from the other direction, and all of a sudden these parking ratios are not good anymore. So we have been building a lot of parking which are now basically empty. Let's say under high buildings, underground parking. We have spent a lot of CO2 really for nothing. And the biggest challenges for the industry is the slowness of the process, which basically means there is too much government involvement. And it's just a regular complaint or just something that you can something we should accept. We should not accept it, because the problem is that this basically, in the end of the day, it translates into the square meter price of residential or of non-residential. And square meter price of residential and non-residential, we know what is the effect of poverty. We know that people have to take 30, maybe 40-year loans to finance these purchase of homes. Basically, it's a modern-day slavery to take a home loan, and the rules we create affect basically the lives of the people for tens of years. And to lessen the financial burden and the square meter price, we have to increase the supply, and the supply can only be increased if the regulative restrictions are eased. And there is also another angle to this. It is actually the most important thing in today's discussion and for your goals of the new reform, is that you have to look where is the value created in this land business, land development. And the value is created with permitting and building and selling quality assets to people and businesses. And if the value cannot be created, or the value creation is very slow, then the value is locked. People will be poorer as a result. So you have to look at not to the number of laws, not to the number of amendments, not to the number of pages in the laws. That is we as lawyers, we can complain about it, but it's not we have to focus where the value is, and we have to eliminate basically all restrictions possible from the value creation. And the value creation is quick and effective property development. Of course, complying with all the environmental goals and CO2 emissions and whatever. But if you want that Lithuania is even more prosperous in 20 years than it is today, then you have to ease up the construction business and permitting by quite a bit. And I think that's it. If there are any questions, I'm happy to take them.
Thank you, Kaido. I really enjoyed your presentation, and I wrote to myself 5 questions, so we'll see if we have more of them. And but I totally agree with you that the value is the core of everything. If value is not created, then we should have a question whether we need that regulation or not. So thank you, Kaido, and we're going to have a small discussion after all presenters in this panel. And now I'm inviting Siim Vahtrus, who is an associate at law firm WALLESS, who specializes in environmental, territorial planning, construction law, and EU law. And Siim is one of the authors of the annotated edition of the general part of the Environmental Code Act and the Handbook of Strategic Environmental Assessment. He has also trained local authorities, officials of the Environmental Board, and entrepreneurs on environmental law. So thank you, Siim, for joining with us. We already heard from Kaido about general overview on the reform of 2015 when you Estonians already introduced the construction code, but you expand this topic a little bit further from the Estonian perspective. So we see your slides, and please go ahead.
Thank you very much for this introduction. So yes, as mentioned, I would like to talk about basically 3 issues, and I will try to refer back to the experience already shared by the Lithuanian colleagues, so maybe to provide some context. So yes, I will talk about codification aspects of the 2015 law, some more challenges in practice and how to overcome them, and as sort of a wrap up from the Estonian side, to highlight what you should expect from any codification efforts and what not to expect from it. So sort of challenges that can be overcome and challenges that cannot be overcome. So as already briefly mentioned by my colleague Kaido, the 2015 law, one of the basic reasons why it was created or why this rather massive project was started, as mentioned, it was based on a very lengthy analysis of different countries and existing Supreme Court practice in Estonia. I will talk about that a bit more later on. And the reason why this huge process was started was that we did have a building act as such, which covered a lot of, let's say, regular buildings, office buildings, shopping malls, residential housing, etc. However, we had separate laws with a separate terminology, separate principles, separate procedures, etc. for a number of special types of construction works, such as roads, railroads, elevators, pressurized pipelines. And yes, as mentioned, it did create this sort of a situation where one set of rules applied to a residential building and sometimes very different types of rules applied to roads or railroads. Or even you might have like general rules on how to build a high-rise office building, but then the elevators inside that office building were regulated under a different act. So it created a bit of a confusion also as regards terms. Just as an example, one of the the new law is not perfect, but one of the things that they have tried to do is to make a clear distinction between different types of construction works and making some of the construction works a bit less burdensome to carry out than the others. mostly it relates to what is considered, for example, a demolition of a building and building a new building that is very similar to the old one at the same spot. So quite often, as you might guess, you have, like, let's say, a very simple 5-story apartment building, basically a box, right? just a rectangular box, just a very simple residential building. What do you call it if you demolish it and build a new one, which is very similar on the outside, of course, more modern in its technical solutions, etc. What do you call it? Is it a demolition or is it reconstruction of the building? What if you, let's say, demolish only upper floors of it and build new upper floors? So sort of trying to distinguish all these terms and also make it applicable across the field. Also as regards, road construction, what do you call it if you remove the upper layers of a road and rebuild them? Is it building a new road? Is it demolition? So sort of trying to create some clarity in definitions was one of the aims of this process, and it definitely succeeded. Also, the new law contains a number of general principles and general rules. For example, I guess the most obvious and the most important rule or principle is the principle of safety. So buildings must be safe. I think this is pretty obvious. They must be safe for all the users. They must be safe for anyone around them. They should also be not environmentally hazardous, etc., etc. But also there's, for example, the principle of professionalism. That something that you already mentioned, Evaldas, I think, was that one of the trends or one of the lines of thinking is that more responsibility should be put on the professionals, and more should be expected from self-regulation. I mean, that's basically what the principle of professionalism is trying to establish in Estonia. And all those general requirements and principles, they're of course not directly applicable, but then again, any law has room for interpretation, and all of these abstract rules need to be interpreted somehow, and this is where these general rules and principles come into play, basically enabling decision makers, whether they be municipalities or even the courts, to decide what is the correct interpretation of this law. So yeah, so that's where we were coming from, and what the 2015 Building Code really does, I'd say rather well, is that it does have this general part with principles, terms, and procedural rules that apply to, and here I have to put a small clause, almost all of construction works. For some reason, maybe Kaido knows better because he's been in the field even longer than I have been. For some reason, land improvement systems. Estonia, such as all the Baltic countries, is a really wet country, meaning that in order to use a lot of the agricultural land, you need to drain it. You need to have all these drainage systems, ditches and dams and what have you. So all of the drainage construction works are still regulated under a different law. I don't know why that is, but that set aside, most of the most of the things that you would call construction works are now regulated under one code, and yeah, there's a general part with which applies across the board, and then there's the special part with specific requirements for some types of construction works. For example, you have district heating pipelines, electric cables, all sorts of underground communications which have protection zones around them and rules on what you need to take into account, who you need to contact if you want to build something within those zones, etc. And there's also, sometimes you have different, the general approach is that all the building decisions are made by municipalities, but that does not apply to, for example, roads and railroads. So you have, this is then also regulated in the separate part. One thing to note, though, is that although everything related directly to building is now in the Building Code, everything related to spatial planning directly is now in the Spatial Planning Act, which was revised at the same time, and those two were also put together better than they were. you still have some areas which are really important for building and construction, which are regulated in different acts. And I think this is very hard to change, and I'm not sure you should. For example, we still have a separate law on environmental impact assessments. We have a whole separate law on law enforcement. So it's sort of we have a law enforcement act, which is sort of a law enforcement code that was also codified. And this law enforcement code, for example, deals with all things related to supervision of constructions and buildings. So that sort of what the municipality can and cannot do, what sort of prescriptions they might write out, how they can apply pressure to the owners of houses. This is still regulated in a different law, which also regulates all the rest of state supervision and coercion methods. Okay, so as I promised, some additional challenges that we have identified. The main thing to bear in mind is that public authorities and their capacities matter a lot. The new law, with all good intentions, set some very, you might say, strict deadlines to issuing different sorts of permits. For example, there's a 30-day deadline for issuing the building permit. You should only give up to 10 days to all other authorities and neighbors for issuing their approvals or opinions on the permit. So the idea was to make it fast. In reality, these deadlines are often disregarded, and the reasons are manifold. For example, one issue is the lack of qualified staff at local governments. So if you have people who have very little idea about the technical side of construction, this can lead to rather formal procedures. If the people don't have a technical background, but rather public administration background, they will apply procedures and they will ask questions that a professional might not. Secondly, administrative systems in Estonia, and I think everywhere, they often punish decisions that are controversial, whereas indecision can go without any retributions, right? So it's easier for a state official to not make a decision rather than make one. And sometimes it's also a lack or poor cooperation between different authorities on state and local level. For example, we have the health board, who is in charge of everything related to environmental noise. They can be quite slow in providing their input, which might be necessary for construction permits. Then there's also the issue of courts that you have to consider. We, for example, have a very progressive Supreme Court. Estonia doesn't have a case law system. We're a normal continental Europe system, but still Supreme Court gives a lot of interpretations that must be followed in practice. And our court is very progressive in that sense that it expects that each individual case, each individual building permit should be looked at very carefully, very thoroughly, and then different rights and interests should be balanced. I mean, that's general administrative law theory, which is very good in theory, but if you combine it with this rather weak administration at local levels, this is one of the reasons for indecision, because if you have someone who wants to build a house, neighbors opposing it, it's very uncomfortable to make the decision one way or the other, especially nowadays when people have more money and time available to go to court if they don't like your decisions. So yeah, that's an issue. So basically, the only possible solution, aside from dropping the idea that building law should balance different rights and interests, is to increase the capacity of authorities and sort of embolden them to make those decisions faster. What the secret sauce is, if I knew it, I would not sit here, I would be in the parliament. But yeah, that's the general idea. So to wrap up, so what should one expect from codification efforts and what one shouldn't? Number one, codification does not solve your existing issues with administrative competence and capacities. So if municipalities, for example, are weak compared to the central government, don't expect giving them more freedom don't expect that if you give them more freedom, they will have better and quicker decisions. Comparative legal analysis, which was done in our case, it works fine, if you factor in the questions of land ownership and overall legal approach. For example, we were looking a lot when we were putting together our building code, looking a lot at Finland, Germany, and also sometimes at New Zealand. But the problem with Finland and Germany, when you compare it to Estonia, is well, especially if you compare, for example, Germany and Estonia, the land ownership is different. A lot more land in Germany nowadays, especially in cities, and buildings in cities are owned by the municipality or the government. We have, and the whole legal approach is a bit different. Whereas in more Western countries, there is stronger precedence for public interest. Estonia, as well as the other Baltics, tend to be more liberal. What codification still can provide is greater legal clarity, provide specialists and publics with a common vocabulary. So that's what, basic terms would be the same all across the board, and also avoid unjustified discrepancies in different fields when it comes to procedures, especially. And just as an additional note, it definitely would make sense to codify not only those issues related directly to construction, but look at also the spatial planning law, requirements to experts, environmental impact assessments, etc., and remove discrepancies in these areas as well. Just a final note, which was not on the slides. I know I'm already 1 minute past my time, but just one more note was that I really liked the idea that your Minister of Environment set out in the beginning, that you want to move more towards performance-based regulation, less than descriptive. If you look at the Estonian construction law and its bylaws, I think we have sort of went the hybrid way. I'm not sure if it's the best way, but for example, if you look at the specific regulations on, for example, fire proofing of buildings, or accessibility for disabled people, or accessibility in general, then those regulations usually set out by setting up these general terms, and then they have very detailed descriptions on how to fulfill this wider goal of, for example, ensuring accessibility of public buildings. So I guess this is one way. I'm not sure if it's the best way. Might be that the best way would be to set out the goal where you want to, the sort of level of performance that you're expecting, and then those technical descriptions could be sort of one way to reach it. Say that if these are fulfilled, then we presume that you reach the goal set out in the first chapters or first provisions. But that's not the only way. I think that would be one way to sort of balance this dilemma of being flexible and at the same time also clear enough. Thanks.
Thanks a lot for your presentation, and I totally agree with you that if administrative capacities would be increased at municipal level, we would have much better situation. But I think it goes to every country that the municipal authorities, other authorities, they have so much work and the load is so huge that you can increase all the time that capacities, but with the time you need more and more and more. So it's not a solution, and we have to look for the best solutions, and maybe some mix of various instruments could help us. Okay, so let's move from Estonia to Latvia, and I want to introduce Ilze Kramina. And Ilze Kramina is a head of real estate and construction practice group of Eversheds, Sutherland in Latvia. Ilze has been named as the recommended lawyer by Legal 500 and Chambers and Partners. She has over 16 years of professional experience in advising clients on the sale and lease of real estate, construction agreements, land use restrictions, and environmental protection concerns. Ilze has lectured on construction law at Turku University. She is the long-standing head of spatial planning and construction work group at the Foreign Investor Council in Latvia. So, Ilze, we see your presentation perfectly, and the stage is yours.
Thank you very much, Evaldas. Good morning to everyone. It's really a pleasure and a great honor to speak at this conference to you all today. And I must admit, real estate construction, also related disputes, have been my professional passion for over 20 years now. So based on that, I hope to give you insight into how construction is regulated in Latvia. And the topics I plan to discuss today is really to show you the structure of regulation, how we did it in Latvia, also the interaction with the territorial planning law, and also a little insight into a standard construction process, how you go from A to Z here in Latvia, and a little bit about construction disputes. And as you can see from this slide, in Latvia we do not have one unified building code, but we have several regulations existing in parallel. The most important of them being the construction law, which is a law which regulates the main principles, like a small, constitution in construction regulation. And besides that, we have several subordinated regulations approved by the Cabinet of Ministers, general construction regulations, like for, administrative proceedings, and special construction regulations, eight of them, for each type of buildings. And then on a more technical level, we also have those building standards and Latvian state standards. And I have prepared slides describing each of them a little bit more in detail. And in respect of the construction law, we have been living with it, I think, about 7 years now. And actually, Latvia is also quite an agile country because we have had already 12 amendments during those 7 years. Even if the law itself is quite, principal and not too detailed, it just gives you the main key procedures, participants, liability, and such important aspects. About the law itself, it's interesting that the legislator has said clearly in this law that it does not apply only to, classical construction where you go to the site and construct. It also applies to placing ready-made buildings, because there was an interesting discussion and debate a few years ago in Latvia, also in the courts, whether construction procedures and construction permit applies if you just want to put a ready-made building on your land plot. And, to avoid those discussions, the legislator said yes, also if you want to, locate and place a ready-made building, small building, you have to do all the construction processes. About key institutions, the most important ones are local municipalities. They are in charge of, permits, making all the necessary decisions, controlling, participating in commissioning, etc. I think it's quite similar in all Baltic states, at least in this regard. What else interesting about this law and the system in Latvia is that we have gone digital. We have a so-called building information system, which is basically a large database containing a lot of information about construction specialists, about their qualifications, certification, about construction inspectors, and also about all the construction procedure. Basically, now you can submit your construction project, your technical design, into this system in a digital way. So you don't have to go with the paper form big projects to the construction board. You really can use this system, and within the system the project is approved, coordinated, and similar. So that's about the law. If we look at the general construction regulations, the good thing, what I find is a good thing, is that the legislator has divided all structures in three main groups. The first group being the simpler buildings, smaller ones, but the second and third group being more complicated buildings, the buildings which have larger impact on the environment. And why it was divided in three groups? Because for each group, you have a different administrative procedure. If you want to build a building of the first group, you will have more simplified and quicker procedures. If you want to build a building from the second or third group, it will be, of course, more documents, more requirements, more decisions, and a longer process. Then, as I mentioned, we have also special construction regulations, 8 of them. This means that if you want to build a small house, you will be opening construction regulations for buildings. If you want to build a bridge, you will be opening like construction regulations for engineering structures. So depending on what you want to build, what kind of structure, you will have to open another regulation just to look what are the detailed administrative processes and documents you have to submit for this specific type of building. And construction standards and Latvian state standards are rather very technical documents, lawyers dealing less with them, usually designers, architects, and engineers opening them to work and to prepare the construction projects. Construction standards are legislative instruments. They are also issued like regulations by the Cabinet of Ministers, whereas Latvian state standards is purely technical regulation, not legislative ones, very technical, and in general they are voluntarily applicable, and only if law or regulations make reference to them, then they become mandatory. And what's interesting about them is that they are available for purchase only. So basically, you know, you have to, in some cases, you may have a mandatory standards to be applied, but you cannot find them publicly available. You have to purchase them. That's probably interesting aspect here in Latvia. If we look at the conclusions in respect of the structure of the regulation, is that yes, there are several parallel regulations. They are often amended, and of course inconsistencies may occur. They amend one piece of legislation, they do not amend the second, and then you may get confused, you may get not sure about which regulation applies, and probably they are not too user-friendly, because in order to get from A to Z, you basically have to open at least 3 or 4 procedural regulations. At the same time, I conclude that somehow all construction participants have got used to it, because I have not observed like strict demand for codification or making it as one big building code here. Probably the difference from Lithuania, Evaldas, as you told, is that you have to look in very different laws for the construction regulations. Here in Latvia, we have at least, a package where we know that we have to look, and we will find the answers. Yes, it's kind of somehow identified set of regulations, and therefore there's no strong demand for codification. At least I have not observed one. A little bit about territorial planning. We have also here one umbrella law, territorial development planning law, regulating more the process. If we look at zoning itself and use restrictions, we have 2 regulations. One is at the level of cabinet, at the level meaning that for the whole Latvian territory applies one regulation who defines unified principles for zoning and use restrictions, so that when the investor goes into each separate municipality, he can, be sure that in each separate municipality, unified principles will be applied in terms of zoning and use restrictions. And then at the local level, each municipality usually approves its territorial plan with those binding regulations for zoning layout and use restrictions. And of course, also as in Lithuania, and I assume also in Estonia, there are some other regulations for historical territories, etc., with specific regulations. In respect of planning documents and the system here, it's similar, I think, also as in other Baltic states. We have for each municipality the big territorial plan or spatial plan, how you call it. Then we have the local plan, which is for a smaller territory, which is more specified. And the trick here in Latvia is that with a local plan, you can change the territorial plan. For example, if an investor comes, he wants to build some objects, but he sees that according to the territorial plan, unfortunately, it's not allowed or it's, you know, not satisfactory. So he can develop a local plan. Of course, there is a public discussion. These are binding regulations, but anyway, it's more flexible. You can change the territorial plan with the local plan. And in some cases, before you start the construction, a detailed plan may also be required. And the conclusion here in territorial planning is that it's quite understandable. Of course, it has its flaws, and investors are never happy also with the territorial planning regulations. But from the user point of view, they are more friendly, I think, to use because there are not so many. Yeah, but of course, they are also changed and amended from time to time because different, you know, also investors wanting to be simplified and more quick. And then, of course, the legislator has to react to that. And here on this slide, you can see a very simplified, of course, construction process in Latvia for second and third group buildings, where you have to prepare the full technical design. And usually it may start also with environmental impact assessment if necessary. This is also regulated in a separate law, and also if necessary, the detailed plan. After that, the investor must prepare, or the developer must prepare the construction design already in minimum composition. And then public discussion can be applied if necessary. And then you receive the construction permit, which does not allow you to go and, you know, start construction, but it only allows you to start making the full design. You make the full design, you approve it by the municipality, and then you submit some additional documents. You may start the construction. Afterwards, you must officially commission the building, and only then you can start to use it. Without commissioning, you cannot use the building. It's basically illegal also in Latvia. In my last slide, I just wanted to give you the insight into construction disputes in Latvia. I must admit that it quite often happens that construction permits and other decisions are disputed by third parties. And the third parties usually are the neighbors or green organizations. And in Latvia, but I also assume it's the same in Lithuania and in Estonia. We have in environmental cases, we have this actio popularis, which basically means that everyone who uses environmental arguments may dispute construction permits. And the negative side in Latvia here is that basically when somebody disputes the construction permit, it's automatically suspended, which means you can't go on with the construction until, you know, the dispute has been resolved. Of course, we have exceptions to this principle. We have a possibility to ask the court to, you know, to give these interim measures. But anyway, this is something where the investors are getting very upset in respect of Latvian regulations. And also the court processes take a long time to go through all the 3 levels of court instances. It won't be quicker than 4 or 5 years, even sometimes more, depending on your case. What we also observe is that sometimes the purpose of the neighbor or the purpose of the organization is not really to protect their rights, but just to, just to somehow hinder the process of construction, unfortunately. And the arguments in all cases are basically repeating. They are very similar. They say that it's not compliant with the zoning, its environmental impact has not been assessed to the level necessary, noise and air pollution, and detailed plan was not in place. I think, Evaldas, I see you are already smiling. I think it repeats everywhere. So I just wanted to show you that also it's the same things happening here in Latvia. And if we talk about trends, about legislative trends and topics right now, one of the hot topics in Latvia is liability. We are now discussing, also Ministry of Economy is discussing and producing new draft laws about liability. Because what the legislator wants to do is put kind of strict liability on the developer, which means that regardless who was guilty, if something happens on the construction site, and we had some very bad examples few years ago in Latvia with a big shopping mall, just collapsing. They want to put the whole liability on the developer so that the neighbor, if something happens, the victims may just, directly claim all the damages from the developer and not from the directly guilty person. Of course, there is a big discussion, but I somehow feel that it's unfortunately going towards putting the direct liability on the shoulders of the developer. So that was quick insights. I hope I managed to show you at least something, and thank you very much for your attention.
Thank you, Ilze, for your presentation and all the insights from the Latvian perspective. And yeah, again, lots of questions, but we still have one more presenter from Latvia. It's Lelde Lavina, and I already see, Lelde, your presentation on screen. So Lelde is a partner and the head of the real estate and construction practice group of Sorainen in Latvia, and Lelde has been ranked as leading individual by Legal 500. She specializes in real estate and construction and has notable strengths in handling FIDI contracts, sale and leaseback transactions, property acquisitions. Lelde has contributed to drafting regulatory enactments on the prevention of divided ownership of real estate and property expropriation, liability and insurance in construction. So Lelde, the stage is yours. Yes, unmute yourself, because you're still muted. Yes, you are unmuted and we hear you perfectly.
Yeah? Perfect. Wonderful morning, everybody. It was a real pleasure to hear you all and to see that we have so much in common and so many construction enthusiasts are here. So excellent. The insights that we have already shared that are brilliant and so well understood also from our side. And Ilze, you gave just the perfect basis for me to expand a little bit further on Latvian few aspects. So we go. And I guess we deserve in this not so light morning, small. So this is a small greeting. And just to illustrate my feelings, and by my genes, I'm optimist, but I must admit that Latvian construction law has much in common with this famous historical drama movie, Latvian drama movie, where the Lithuanian actor is starring. It is the movie Long Road in the Dunes, and my generation remembers it from childhood, at least by its heartfelt music. To me, it sounds like tragedy, tension, passion, longing for fair, and at the same time flexible regulation also in the construction law. It has so much in common with our construction legislative developments and practices which we have faced. So what do we need a construction law for? What are the expectations or even demands in society? Kaido already told that there should be a purpose under all and any legislative regulation. If it does not serve purpose, we do not need it. And for me, the sole purpose lies in safety. And I believe for everybody of us, because the construction is increased danger process, and this is what we are looking for, that it is safe for third parties and also for construction participants themselves. Current law came into force 7 years ago, shortly after Ozoliņš tragedy, collapse of a shopping center in our capital Riga, resulting in the death of more than 50 people. And what was striking, public interviews of all involved parties were really striking. Everybody was brilliant in presenting why they are not liable. It was just unbelievable that how good all of them were in saying that they have done everything perfectly. And despite highly regulated certification, standards, expertises, construction supervision, and all controlling systems, it still collapsed and it was put into operation. It had a permit of use, all designs, everything. And it means that it doesn't serve the purpose. Therefore, public pressure after this, fear of failure, massive lobbying for different angles, and demand for a legal environment that attracts foreign investments, all of this set the tone for the new law. And the new law came into force in 2014, and it had two major tasks. First one was a clear liability mechanism because of this tragedy. Actually, the law came into force, delay coming into force was, it was delayed because of the tragedy. So it already had some amendments before it came into force to address this issue. So the clear liability was the first one, especially towards victims, third parties, but including also between construction participants. And the second was that legal certainty for developers that their construction project is legally permissible. Previously, all investors, as Ilze rightly mentioned, were frustrated that they need to invest so many resources, underground researches, different technical researches, prepare the full design, invest so much, maybe even buy a plot, and only then they receive an answer whether their construction intention is permitted or not. And therefore, the idea was of the new regulations that at early stage, on the basis of territorial planning documents and first sketch what the building is, the legal developers get a legal certainty by acquiring so-called preliminary building permit or building permit on the basis of the sketch that says, yes, in principle, you can build it, and only this document is challenged by third parties. Later on, only technical issues are coming. You need to design as it's supposed to be, and that's it. So this was the main idea of the law. But the outcome that, yes, we have a relatively brand new law, 12 amendments since then, not so many. And courts have canceled the expected legal certainty. Really, this slide scheme, it is very close to the one which was presented by Ilze, the whole process, how construction is to be taken. The green part was meant when this developer gets complete legal certainty. He has minimum efforts invested. Everybody sees what he wants to do. So within 1 month, third parties can challenge the building permit. If they do, there is a process, but if they don't, he is completely safe. But in fact, courts told that because after this building permit, design works take place and some changes may be implemented, and those changes may affect again third parties, then this building permit can be challenged by third parties. And also the final design note when everything has been completed. So the process ended up in 2 legal documents to be challenged, first and the second. So it's complete mess, and this idea of the legislator did not go through. So the courts canceled this legislative idea, but the law is still the same. Just the interpretation is such that it does not ensure. And liability rules changed multiple times. It's huge lobbying on that. And now, therefore, we have fragmentation. Something is in the building law, something is in civil law, something is uncertain, conflicting, and so. And also new draft law under strong debates, as Ilze mentioned, about strict liability, and I will touch upon a little bit later. This we went through. And this is just an illustrative process. If somebody wants to go into detail, how the developer must face the real situation when he gets a building permit and when he gets a legal certainty. If any third party, even is without grounded reason, just to check out maybe there's something wrong, challenges the note, then in the worst case scenario, it is up to 10 years. 3 up to 10 years. If really no ground, then it could be that law gives the court gives preliminary ruling and renews the force of the building permit. But in general, the process is very complex, and this is the result of kind of legal certainty to be created. So actually failed, 2 big fails on liability and on this idea of attractive environment for investors. But also Kaido mentioned about this over-regulation without serving the core purpose, safety. We have, I'm sorry, as a result of this over-regulation, we have ended up in high administrative burdens, unpredictable appeal procedures, unjustified certification. In Latvia, there is certification procedure. If any foreigner wants to do works in Latvia, both they need to register in construction merchant register and employ certified Latvian certified specialists. We do not recognize directly foreign experience and qualifications. So it is protectionism, which is still in Latvia quite strong. And as Ilze mentioned, even small buildings such like kiosks, where you take renewable like for the waste system where you deliver items, it's a small spot and it needs a building permit, and Lithuanian or Estonian companies cannot do it. Only Latvians know how to put a ready-made kiosk on the plot. So it's quite funny, but yes, we do have it, unfortunately. And lack of protection for third parties, like innocent third parties, victims, if anybody is hurt by some construction accident. So instead of overruling, simplicity and flexibility should be the leading principles, as we all agreed. Where professionals, really professionals, that's why it makes sense that there is certification. when they take the main liability, and the more mature we will become, and the more mature the industry itself, designers, construction companies, supervisors, everybody, when they will understand that it's their child, those all constructions are their child, then this situation and legal environment also will evolve, because trust into their industry will raise. So about strict liability, I see that it is the most important issue because of this tragedy which we have seen in our country, and this is a demand from society at all. And here is my vision. Actually, we have discussed also with Ilze and many other Latvian specialists that the most natural would be that contractor who is on the site, who holds this increased danger object, because employer even cannot enter the site without contractor's permission. The one who controls, the one who employs specialists, the one who has experience, that he should bear the primary liability. Should it be strict or liability or otherwise, he should be the one and the main. But because they claim that employers engage not so qualified, and maybe employers do not pay for so many researches or for so many detailed drawings or for something, they have persuaded the legislator that the employer should be the one who should take the risk. So there is some reasoning, and it could be, there is no big fight about it. So if employer has a strict liability towards third parties, then still employer is not a professional. Further on, employer's liability for the sake of third parties should be secured by mandatory insurance. I guess in Lithuania have something for this in place. We have very symbolic and fake insurance. It doesn't work in material cases. But when the employer is responsible towards third parties, contractor should have the same type of strict liability towards the employer and the right of recourse to other construction participants, so that the main disputes will be only between industry professionals and specialists. Then there is a justified certification system, reason for its justification, and everything. The industry cleans up itself. So this is a basic idea that they deal themselves who did what. Neither third parties nor employers should be involved unless there is some really direct link to that. And the most important, that third parties must not bear any burden of proof on fault of either construction participant, especially in the event of personal injury. They are not in fault of being victims of the accident. And it's not so dark as it seems from my presentation. To conclude, there are also good news. Still, the good faith actions and projects are in majority, and therefore, despite not so good laws, very good developments take place. And with the blessing of UNESCO protected Riga Towers Cox, that obviously supervise all the city, our Riga, and all country, becomes more and more beautiful every day. So really, welcome to Riga. And despite the laws, everything is getting better and better. So thank you very much.
Thank you,
and thank you,
Lelde.
Evaldas, for this beautiful conference.
Okay, thank you, Lelde, for your presentation. And we heard everyone from the Baltic section already. We also have one participant for our discussion, Andis Ozoliņš, who is a senior associate at law firm WALLESS. He's also from Latvia. But I want, first of all, to go back to Estonian case, as Estonians codified already their construction law, as we learned back in 2015. And I want to ask, Kaido, maybe you could answer, why it was chosen not to include zoning and planning into construction code?
Can you repeat the question? Why not include both laws?
Why it was chosen to codify only construction issues and leave aside the zoning and planning issues? Because you have two laws.
Yeah, we have two laws, and can I say that what are the practical? I think it is because let's say the audience for both of the laws is different. So while the planning law is mostly directed at local governments and some central government officials, then the construction issues more or less are let's say issues to take into account more between private players. Of course, there are public law elements involved, but I think that the audience is different, and it doesn't. Maybe this explains. Maybe this is the explanation. I might be able. Maybe Siim knows from the top of his head. Maybe it was answered also in the explanatory notes, but I do not recall any other reason why it should be so.
Yeah, I think it's the idea. I think you already mentioned one of the aspects that sort of very broadly put, the planning law is more driven by public interest and is more about, if you look at also for example, just the principles of laws, the planning law has a lot of, public interest driven principles, whereas construction law is more dealing with private interests, and whereas planning law sort of gives the state the power and authority to sort of lead development, then construction law has a different starting point. It should regulate, it should keep the government and authorities out of the way and only regulate those areas which are really necessary for reaching safety as the main goal and other goals. So that's the main difference, I'd say.
It was also mentioned that in Estonia, you don't need a permission for the buildings until 20 square meters, and then you just give a notice to if you want to build a building until 60 square meters, and only then the construction permission procedure starts if the building is more than 60 square meters. But how the society is reflecting to this legislation, and how public municipal authorities are reflecting to it? Because what we hear in Lithuania, that we also want to have such kind of easements, but then you still have to have a permit if you're in cultural heritage protected area or environmentally protected area, or you are in a city and you're building a garage for a car. So it's like visually not very good not to regulate this small building and construction, but how does it work in Estonia?
Well, it actually works quite well. There are no big complaints. Before these rules, there were really kind of silly questions that if I build put a small house for the kids to play, or I put my bath tube or I put a fire pit on my land, should I have a building permit, or what sort of permit should I have for that? So this bit of legislation solved a lot of these small buildings that everybody normally has in their private yards. So actually there have not been major problems in that regard.
And just to add, you still have some restrictions, most notably if you want to build even a small house in a nature protection area, you still need to get the authorization from the Environmental Protection Authority. And it's still, you can't, there are zones around seashore and shores of lakes and rivers, which are where you're forbidden to build unless you again get an exceptional permit for that. So I would say, yeah, like these sensitive areas are covered by other legislation, and outside these specific areas, I agree with Kaido, it has not been a problem. And generally, authorities cannot forbid you to build a house based on argumentation that we don't like the architectural vision. So at least in most places, I mean, you might have like, yes, the UNESCO heritage areas there, they might have some more leeway, but generally, if I want to build an ugly house, that's my right.
Okay, yeah, everyone has their rights, broad as it's allowed by zoning laws, and therefore we see that territorial planning and zoning issues, they're not so far from construction regulations. And when it comes to that architectural side and the visuality, the architect is the main figure in Lithuania who forms the visual surrounding and during the design stage, but then contractor is the main figure who takes the whole responsibility. I'm reflecting to Lelde's presentation, what we have in Lithuania. So the contractor is the main one who is responsible, and only then the liability is. Is it the same in Estonia? What do you feel? What's your experience? Who are the main players of the industry who takes the responsibility from one or other in one or another stage?
If the building is in a critical location, which is basically made clear during the detail planning process, then and the city government has some ambitions in relation to the design, then what they usually do is they say in the detail plan that the architectural design should be preceded by a architectural competition between different architects, and then the committee who will select the winning architectural design, this will usually involve then also the local government officials, so that the outcome is controlled by this sort of competition between architects, and the selection process involves local government, so that they get some sort of best outcome, but it would not be monopolized to one particular architect.
Yeah, we also have a new law, which I mentioned, the law on architecture, which introduced imperative requirements for architectural competitions if the buildings are of certain size in certain areas of the city. Going back to Latvia, yeah, we saw that change in your legislation back to 2014, when construction permit is issued when you submit only the basic information. But it's still strange for me. So what is the real construction permit? When do you really can construct? Because it sounds very good if we talk about those international rankings like doing business and so on. It looks like you have a very short time to receive a construction permit, but in reality, you can't perform the construction. So what are maybe, Ilze, will you elaborate more? What are those technical documents which are required by law to be presented to the local authorities? Those imperative documents which designers should prepare, because in Lithuania now we had a recent reform that we require only architectural part, land plot part, general part of technical design, and cultural heritage if it's a heritage area. So what about you? What about Latvia?
Evaldas, you got it completely right. We have this first initial decision called construction permit, but actually it does not permit anything. Yes, it's just like a name of it. And to get it, as Lelde mentioned, you basically need to submit sketch documents. Yes, but this will be a general plan with the layout, a description about, you know, what the building, and then some kind of drawings where you see how many floors it will have, what's the inner planning, and how it looks from the outside in different angles. That's basically it. You do not submit like technical part, structural part, engineering, communication part, fire safety, whatever. You submit only a smaller package of documents showing the idea of the building, the location of the building, and volume of the building. And based on that, the construction board can check whether this kind of building is corresponding to the zoning requirements, to the height, to whatever other requirements apply. And they say, yes, it's okay, we approve this idea, it can be built here in general. And then they give you the construction permit, which is actually a very long paper, with also detailing what else you must do now, you know, what technical requirements you basically need to receive, or with whom you need to coordinate your technical project, and other requirements. And only after getting this so-called permit, the designers start the real work, and the engineers, they start, you know, receiving the technical requirements and making the big project. If that answers the question, and after this technical project is ready, you get another approval, and this is already you know, more real approval. Then they approve your technical project, and then you submit insurance policies of the, you know, construction specialist, construction company, and then they give you the final permit where you can go and start actual construction works.
Before smaller reform in Lithuania, there were 16 institutions who were participating in construction permit issue. How many institutions do you have in Estonia and Latvia? Now we reduced the amount, but what about you guys?
Lelde, please.
It could be the same. It depends on the huge list listed in the building permit. But Ilze just didn't mention functionality. Also of the building is something, so the third parties may know whether it will have some noise or pollution or something. So everything is designed to check whether it may affect third parties for this. But maybe I can supplement that legislator is trying to reduce the list of prepared documents for the final design. As you, Evaldas, mentioned, that you have very few, which is very reasonable sounds. We still have, the law defines how many sections of the complete technical design you need to submit. Huge, nobody checks it. Nobody undertakes liability for it from authorities. It's just you, before electronic submission system, huge tracks were going for logistics center with a design to the construction board, and loading and unloading. Can you imagine? With no reason, absolutely with no reason. So yeah, but still authorities are many to go for. But actually authorities are getting better and better. They really go down to the point. There are not so many unreasonable requests anymore. Really, developers who go with good faith and show all possible scenarios how to develop, they get the trust and authorities come forward. So
but may I say that we all agree that there's a trend which is going on, that there's put more and more liability on the professionals of construction industry and participants, and it's all common to the whole 3 Baltic states, because we see it in Lithuania at the moment, and as I heard from your all presentations, it's the same in all jurisdictions.
It should be so, but our construction industry, construction companies are hugely against it, actually. Maybe in public they say that we want to be responsible for our projects, but in contracts, in real projects, in everything, they do mostly the opposite. I'm sorry to say, but they are also getting better. But yes, it should be for in all world. That's why they are professionals. That's why they have certificates, experience, and education, everything.
Siim, you wanted to add?
Yeah, I agree that this seems to be sort of a trend, but just one note of caution there is that in Estonia, at least, more and more residential developments and I think also office buildings, they're built by SPVs. So they set up, the developers set up a separate company for only this development. Which means that once the development is completed, handed over to the new owners, this legal entity becomes basically a shell. So that's a word of caution, that if you want to put a lot of liability on those companies in charge of constructing the actual buildings, they might, as legal entities, they might not have assets to be liable with.
Okay, and final remarks from everyone. What do you see, what we have in common, and where we can improve our regulations? What would be your insights in a few sentences? Because we already over time. Kaido.
Okay, I would really focus on the value creation chain, starting from how the land gets formed. This also includes splitting of the land, merging with adjacent land plots, and not so that this would be really efficient for the developers, and also then the whole chain of permitting. That do we really need all the layers of the plans, like city plan, city area plan, detail plan, design conditions, and then only the building permit, or we can kind of somehow manage only with two sets of documents, for example, a area plan and building permit, and that's it. So and really to reduce the time involved, to put a time requirement clearly in the law, that would be practical time requirement, saying that if the practical time requirement is not met, then the law needs to be revisited and something needs to be changed. I would put also a sanction on the, if the process takes more than X days, they start to pay a penalty to the state government, the budget, so that they are really focused on delivering on time and with good tempo and speed.
Thank you, Kaido. Siim?
I would just add to this that one thing that's missing in, I guess, all of the Baltic states, and at least with us, it's might be some sort of an unfortunate outcome of codification, is lack of priorities. I mean, we, as mentioned at the start by the Minister of Environment in Lithuania, we have a lot of challenges ahead of us. Let's just take, for example, the current energy crisis, which is directly linked to the consumption of energy by buildings. In order to meet the climate goals and avoid energy poverty, we need to really rapidly insulate our houses, to reconstruct them to be less energy intensive. And this is just an example of an area that really should be prioritized. Those processes to reconstruct buildings to be more energy efficient, these processes should be streamlined both in the public authority, and it also might be that there need to be some exemptions in laws that take these priorities into account. So that's something to keep in mind. If you codify and if you want to make the rules very similar to all different fields, you might miss out on chances to prioritize, or you shouldn't miss out those chances to prioritize certain fields, whether it's infrastructure construction, whether it's insulation of houses, or whatever priority you might have. Thanks.
Thank you, Siim. Ilze?
It seems to me that in all three Baltic states, the regulation is very, detailed and descriptive. But I think probably the legislator should think more about the aim and goals for what this regulation is created. And if we think about more about goals and values, what we want to achieve, probably we will quickly see which regulation can be just deleted as redundant. And what else in Latvia we see, regulation is one thing, but the capacity and understanding of the institutions and especially of the local levels is another thing. So everybody should work also for increasing of the capacity and understanding and the quality of the decisions of the competent institutions. Thank you, Evaldas.
Thank you, Ilze. Lelde?
I would add that I see excellent trend, at least from Riga municipality, that there is a hotline between developers and authority, and also green corridor for the projects with creating value for the city. And this dialogue and this direct access to authority gives insight to the authority where are the problems and whether it can be done at the local level at administrative level, or it needs also legislative changes. It really helps. They get to know what is under developer's view, which is precluding him quickly, efficiently to proceed on. So I guess this will help if it will continue more and more. Thank you.
And Andis?
Yes, I think the impression from all the speakers is that the problems are similar, but at the same time, I think that these codification changes that have been made in Latvia some 5 years ago produced a reasonable result. And as some of the lecturers already mentioned, that Latvian construction industry is not confused about what standards to apply. However, at the margins, there may be some issues when, for example, building permits require to comply with some regulations issued by other institutions, and which comes into a gray zone what is really required from construction industry. At the same time, I understand that there is always a balance between the simplicity of procedures and also some regulatory oversight. And I agree that construction industry needs to take more responsibility about these technical issues, because authorities, they are not able to check technical details, and what they check there and that what they are getting better at all the time are procedural requirements, which are, of course, not unimportant as well, but of course they cannot really check all the aspects of construction design. And also what is naturally happening, I think that's as we experienced in Latvia, that our construction law has been already changed some 12 or 15 times, and the same applies to other subordinated regulations. And it means that construction authorities and general authorities are sort of looking into the problems and trying to simplify these procedures, but at the same time, it results in a proliferation of different rules that are applied to different types of construction works. And it may happen, it does happen that there is some good idea what to simplify in one type of construction works, and these specific regulations are changed, and this is not done for the other types of works. And for this reason, we can see that since the adoption of these relatively new regulations, they are increasingly diverging between themselves, because for different reasons there have been changes in different regulations, and of course from time to time some kind of codification is required, and I think this is a natural process. But I can agree that generally we are moving to better administrative procedures and more understanding from public authorities, and I think this is a general trend, in at least we can say for Latvia for sure. Thank you.
Okay, thank you, Andis, and thank you for all the speakers today. It was a great pleasure to talk to you, but we have to finish Baltic section already, because the other participants from Nordic jurisdiction already is waiting. And thank you once more time, and see you soon, all of you. thank you for the all Baltic section participants. And we had a really good discussion and good insights. And now we're moving to Nordic jurisdiction section. And we have the speakers from Denmark, Sweden, Finland, and also we had a speaker from Netherlands, because the schedule is very tight. So well, we just thought that, well, Netherlands also can go up to north a little bit. And maybe I will also already want to start from Professor Chris Jansen, that he would start our Nordic section. And Chris, are you ready to share your presentation? And Chris Jansen is a full-time professor at the Center of Public Contract Law and Vrije Universiteit Amsterdam. He is a leading expert and advisor to the construction sector in the Netherlands and on construction contracts and public procurement law and practice. So, Chris, the stage is yours, and waiting for your insights on Dutch law and recent changes there. Yes, Chris, we see your presentation, and please unmute yourself and you can start talking. You still muted? Yes.
So there we are.
Yes, now we hear you.
I'm
yes.
sorry about the short break, Evalda. Thank you very much for your introduction. And thank you very much for inviting me to take part in this, this conference. I will say a few words on issues and trends in the Netherlands, and I will particularly focus on construction law that is of a private law origin. I noticed that many of the other speakers already spoke about construction law that has a public law origin. I will say something about that in the Netherlands, but my focus will be on private law construction law. I will take this slide as a starting point for my presentation, because I think this is the essence of a construction process, and I think it's the essence that unites us all. If we look at a construction process from a non-legal perspective, we can see that the focus of the process is always on the design stage and the construction stage. That's what I will talk about this afternoon. I will not speak about all other kinds of functions relevant in the construction process, such as finance or maintenance or operate. In order to get things right, we have several actors participating in the construction process. Many of them have already been mentioned this morning: client, employer, whatever the name you want to give him, architects and engineers and contractors, and of course, many others. What these actors have to do in order to get the construction process going and to achieve the goals you want to achieve, they have to take all sorts of decisions in the construction process. And with these decisions, they want to achieve various objectives. These can be individual objectives or common objectives on the one hand. And on the other hand, we can see that all these decisions of these employers and contractors and architects will have an impact on both public as well as private interests. And I've heard many of these interests already this morning, including in the opening speech of your minister. And this impact can either be a positive impact as well as a negative impact. We can all understand and imagine the examples that occur in practice where quality is insufficient, planning is not being taken into account, budget is overrun, too many transaction costs, etc., etc. So what is then the role of construction law in all of this? In my perspective, the function of construction law is to both encourage the actors in a construction process to take all kinds of decisions that will enable them to achieve these common objectives and these public and private interests. And on the other hand, the law should not only encourage people, the law should also facilitate the actors in a construction process to actually come to effective decision-making. So, like in many other countries, in the Netherlands, we make a distinction between construction law of a public law nature and construction law of a private law nature. Again, on the slide, many examples we've already heard this morning. Yes, in the Netherlands, indeed, we have a lot of laws and acts that try to influence the decision-making process by all these actors in the construction process from the perspective of various public and private interests. For instance, planning law and environmental law, health and safety laws, but also public procurement law, in order to encourage clients, particularly public clients, to organize the construction process in such a way that market participants actually have access to contracts. So that's law from a public law nature. Not many developments going on in the Netherlands right now, but to name a few important ones, we have experienced the situation that a lot of our regulation is diffused and scattered in a lot of separate acts, etc. And we're now waiting for the new Environment and Planning Act, which will be enacted as of the 1st of June next year. And that will aggregate and simplify all these laws that belong to public construction law. I've put a link on the side to a website where you can find more information about this development. And that first link is actually in English, so that will be accessible to all of you, I think. And another development relates to the enactment of a new Construction Quality Assurance Act, also on the 1st of June 22. An act that tries to improve quality of construction project through better quality assurance and control. Because also there we had some slight issues in the past, which we tried to solve via construction law of a public law nature. Again, a link to a website of the government. Unfortunately, that one is not in English, but I think you can come a long way with Google Translate if you try to. So that's public law. Construction law of a private law nature deals with all the contracts that are being entered into by all the participants to a construction process. Basically, all these contracts are being governed by provisions of our Dutch Civil Code, but this is all very basic. More important are the rules to be found in all kinds of standard forms of contracts we have in the Netherlands. We have a bit the same tradition as they have in the UK, where joint committees draft large standard forms of contracts that are being widely used in practice on top of the provisions that are to be found in Dutch Civil Code. So what are issues and trends in the Netherlands if we look to this slide, the contract law slide? In order to explain that, I take you back to the past, how construction projects were being put out to tender in the Netherlands. And for 200 years, we used the model you can see on the slide. And we inherited this model from the French occupation in 1800. Actually, Napoleon introduced this model in our country at that time, where the client first enters into a contract with an architect or engineer. This architect or engineer takes all the steps in the design process. When the design is final, the contract for construction is being procured on the basis of a fixed price, and then the contractor, on the basis of the design already prepared, will carry out the project and finalize and complete the construction project. We've done this for 200 years. It works fine, not much problems, but at the time of the turn of the century, we considered that we might do things better. And that explains the introduction of the integrated model of tendering. We started with this in the 90s of the last century, And this model of integrated tendering slowly but surely gained much more importance in the Netherlands. In this model, as you can see, the client first drafts a very preliminary design, possibly with the help of an architect or engineer, and then puts out to tender a design and construct contract on the basis of a fixed price, on the basis of which a contractor will then carry on the rest of the design process and eventually construct a project on the basis of his own design. The involvement of the contractor in the design process, it was thought, may contribute to all kinds of interests, both of a public as well as a private nature. A better quality, shorter period of time of construction process, innovation, etc., etc. And we've seen that it works. So yes, indeed, we managed to achieve actually this improvement of public and private interests. But we also experienced problems with this model of integrated tendering. And the problem is that the parties to the contract, the client and the contractor, will enter into a contract at a very early stage of the process. They will enter into a contract on the basis of a fixed price at a time when the design still has to be prepared. So that means that a lot of information on risks surrounding the project is unknown at that stage. And that means it is very difficult for a contractor to actually offer a fixed price for a project with many uncertainties. This problem is becoming even bigger given the fact that information exchange on all these project risks is often lacking. So in the pre-contractual stage, a lot of information is still lacking. So that's very difficult for the builder, for the contractor to come with a well-informed decision as to how to offer in the pre-contractual stage. On top of that, these contracts are being put out to tender via competitive tendering procedures. Often we see race to the bottom. So contracts are concluded at a time where many risks are unknown. Risks become manifest in the phase of the contract performance, and then risk allocation has to take place on the basis of the contract that is being concluded. Parties are in the lock-in of a contract, and we often see that in order to get out of that lock-in, parties show non-cooperative, very adversarial behavior, often leading to a lot of conflicts. We're now considering how to solve this problem, because going back to the traditional model of tendering is no option. We want to move ahead in the Netherlands with this integrated model. We want to have involvement of the contractor in the design process. But at the same time, we see that a solution should at least take into account a couple of criteria that you can see on the slide. One of the criteria we now have discovered is that we should only have parties' commitment to a fixed price when this information risk is under control. So not too soon in the process. Then, even if risks will occur in the phase of the contract, of the construction contract, we need a balanced allocation of risks. And what we also need is a governance that actually stimulates parties to behave in a cooperative manner, both at the pre-contractual stage as well as at the contract stage. And last but not least, all of this should be possible within the framework of the European public procurement law rules, which, as we all know, are rather strict and don't offer a lot of space to do things that might be better from the perspective of goals you want to achieve with your construction process, other than giving market parties equal access to contracts. So what are possible solutions under consideration right now to deal with this problem? One model we are considering now is to keep the traditional model, but give the contractor first a contract of advice, where he can actually give advice towards the architect engineer in the design stage. And once that design has been finished, we give the contractor a second contract on the basis of which he can actually construct the project. That is a model under consideration. Another model is this one. We call it the two-stage integrated tendering with opt-out model. So the client first procures a complete design and construct contract, enters into a contract with one contractor, and halfway at the end of the design process, we allow the parties to determine the price for the construction phase. And if they are not able to determine that price, we give them the possibility to exit the process and to opt out. We also have this one with an opt-in variant, where firstly, parties enter into a contract that is only for the design of the project. The contractor then designs all the stages of the project. And at that stage, parties consider whether they will be able to determine a price for the construction and enter into a second contract that is particularly focused on the construction phase. And if they are not able to determine that price, they exit the project. Another one is a combination of all the above. That's where the parties first conclude a contract to give advice, where the contractor, and possibly with the architect engineer in close cooperation, they advise the client to take certain steps in the design process. So this phase ends then when the basic design is ready. Then the determination of the price for the construction phase takes place. All parties exit. Then parties conclude a second contract, which is a design and construct contract, and the contractor designs the last stages of the project and subsequently constructs the project. These various solutions, recent research has shown that these solutions, they score positive on a few of the criteria mentioned earlier on. So you have this involvement of the contractor in the design process, commitment to a fixed price at a later stage in the process when information risks are sufficiently under control. But then on the other hand, we see a lot of risks from the perspective of public procurement law. It's very difficult to squeeze all the solutions shown to you just right now within the framework of European public procurement regulation. How about the third and the fourth criterion? We think, and we experiment with that right now. We think that balanced allocation of risks in a contract should not per se be a system that we all have in all our countries, that divides risks between the parties. You could also think of, at least for some risks, which are not easy to control for either party, to think of systems where you share risks. What we have seen in some countries, particularly in Australia, for instance, and in the United States, where you use principles underlying the so-called alliancing contracts. So we try to experiment with that, putting alliancing systems in our contracts. And secondly, we think that if you put into your contracts, not for all the risks, but for some risks, risk sharing systems, that this might encourage the parties to the contract, both in the pre-contractual stage as well as in the contract stage, to actually exchange important information, to communicate with one another, to cooperate, and to also, in that way, score positive on that fourth criterion of the framework of criteria. So who's doing all this? Who's working on the solutions of the problem? In the Netherlands, we don't have, at least not in the construction sector, the government hovering above the sector and giving instructions to everyone, including how the law should be. In the Netherlands, it's putting together sensible rules for governing construction contracts is the result of a joint process with participants and contributors from both the government, private clients, market parties, but also academia, other research institutes, and last but not least, law firms. So all these participants from these organizations are currently taking part in the process to rethink our construction contract law system as a system to actually encourage the parties to construction contracts to do the right things and to take effective decisions in the construction process. That's it, Evaldas. Thank you for having me in this conference. And if people would like to have more information, they know where to reach me.
Yeah, thank you, Chris, for a perfect presentation with small insights on public law and then expanded insights on the private contracting, construction contracting. And thank you a lot. It was really professional. I have nothing to add to that, as usual, as far as I know from other occasions. That's the perfect academic level. And now we're moving to Denmark, and we have a next speaker, Steffen Hebsgaard Muff. He's an attorney at law and strategic lead for international construction at law firm Muff. Steffen has been ranked in real estate sector by Legal 500 directory. He has in-depth knowledge of the conditions within the offshore sector, the construction industry, the energy sector, and the insurance industry. So, Steffen, we already see you, and are you sharing some slides? If you do, yes, if you're sharing, so share your screen, and you are unmuted, and we hear you perfectly. So, stage is yours.
Okay, and you can hear me just fine, I assume. Okay. Well, this presentation is focused more on the public law aspect. I'll come into a bit on the private law aspect, because the Danish sector is actually very reminiscent of the Dutch. So we would have different regulations as to whether you have a public building or you have a private building. I've already been introduced, so let's just move on here. Okay. Well, these are the relevant acts, and as you can see, there's quite a few acts which are relevant in this regard. You have the building code, which applies to all buildings. That's really regulatory, and then you have the Planning Act, which again involves local and regional plans. So these are regulations for a geographical area. Normally, the main regulation of the planning is how does a building look from the outside, and does it fit into the environment where it's placed. Then you have a particular one. We have an administrative act on the use of information technology in building processes. This is an interesting one, but it only regards public works. As in the Netherlands and in the UK, we are relying heavily on what you would call standard terms for the construction industry as well. They do have a little bit of regulation, not only on how to build, but also on what to build. So we'll be going a little bit into that. That's called the AB 18 standard terms. When we're getting to my Scandinavian colleagues, they will also be, at least in Sweden, they will also be referring to the AB system, but it's two different systems. It's just we call it the same thing, but it's two very different systems actually. And then of course we have industry standards, which are drafted up by various associations. What's in the building code? Well, the building code is mainly concerned with some of these issues. Of course, it's statics. How do you ensure that buildings don't fall down, and how do you control this? Independent control of the statics of any building. It's fire safety, and then you have provisions on energy consumption, sound insulation, and also some on indoor environment, making sure that buildings are healthy in more ways than one. They don't know, it's not only what you would say physical health. They also need to be good for the mental health. So there's also requirements in relation to how much lighting are you getting, window spacing, etc. So that you don't only live there and are healthy in a physical way, but also there's a focus also on issues which are good for mental health. And I think actually that part is quite unique, that's also ensured. So if we sum that up, well, the aim of the building code is to ensure that we have safe, healthy buildings that provide a high quality of life. So it goes a little bit beyond what you're normally seeing in a building code, I think, because you also have the quality of life aspect included in this. Then you're saying, what about BIM? What about building information modeling? What about all of this data? Do we have any regulations on that? And the short answer is no. There's not really, there's no requirement or official guideline for using BIM. And a topic you might have touched upon on the IC 19650 or already, that's not broadly implemented or even widely used in Denmark. And if you go into private contracts, there's actually no requirements at all. You can essentially do what you want to do. You don't actually need to have any data beyond a certain amount of quality assurance material, which can actually still be provided in a binder if the parties find that that's the best way. You have to provide a few drawings to the authorities electronically, but that's more or less it. There is no agreed or dominant digital classification system. Essentially what you often have is, and sometimes you even have several classification systems which are local and are implemented for the same project. So that's the short version of this is it's quite often a mess. And I put it in, it's the ICT Act, because it's actually so old that at the point in time when they implemented the requirement for using IT in building and construction, it was called Information and Communication Technology. So it's called the ICT Act. If anybody in Denmark talks about ICT, it's because they're working with IT in the construction industry. This act only applies for public works, but it includes a requirement to use electronic communication, and indeed also a requirement to use classification for data, but it doesn't specify how you are to classify this. So again, we end up sometimes that you have very different formats. We just checked up a few months ago, and I think the top project had 6 different standards for classification of data included into the contract. So there's quite an issue on this, where we could be further ahead. So essentially, I'm putting this very, very shortly. If we go into this, I think some of the pros on the, in particular the building regulation in Denmark is you do have something that's focusing on the ensuring the quality of life for all new constructions. But if we go into digitalization, historically, Denmark started out in the digitalization process in the 1980s. So it was really early out. It started out really early. But then the country got a bit ahead, and now I think it's getting a little bit behind, because nothing, sometimes a leading position can become a bit of a sleeping pill. So what's actually happening, in particular in relation to BIM, is that we say, BIM, what is BIM? There's a lot of talk about BIM. Some people actually call it something else. There's a lot of talk about it and how nice it is and all of these benefits that we're able to reap from it. But if you go down into details on BIM, what you really need in order to actually get this exchange is a proper method of classifying data in order to exchange and use this data. And what we really don't have in Denmark is any uniform method of doing this. And as there's no uniform method, you end up having several methods employed and nobody actually getting good at any of this. And then the data you have in the other end, which you're supposed to use in the, when you're running the construction, when you have the building up and running, you might not even be able to read or use for anything. So you create a lot of data. You don't, the data is created. You create a lot of data. You have nice 3D models, but actually using all of this data in the other end is often very difficult. It's also very difficult to use during the phase because the exchange of information doesn't have a set code. So all of the value that could be added is actually quite often lost. And that's a real issue on BIM, and the lack of action on part of the state in order to actually, at least for public buildings, say, well, now we're going with a single data exchange format or data classification system, or at least now we'll go with the ISO regulations. That doesn't help. So I would say in relation to BIM and how to implement BIM, I think there's a lot to be learned. In Denmark, there's a really long way to go. Of course, the private sector can do something because there's freedom of contract, there's the AB system, but there's really freedom of contract. So there's something to do here. Maybe the private sector could be the driver. And if you're coming from the outside, from, let's just say from the UK or Spain, where they are much better at handling BIM, Italy, there's actually something that's that you can really contribute when coming to Denmark. And luckily, I would say we have a large number of huge infrastructure projects coming on. All of these infrastructure investments that had been decided during COVID-19, because the economy was slowing down, we're coming into effectuation now where the economy is booming, which also means there's no capacity in the Danish construction sector. So it's a really open market, and if you can really perform on BIM, there's really something that you can come into the market and contribute with in these days. There's also one other thing I'd like to mention here. You have sustainability. I've actually mentioned two types of sustainability. One is sustainability in the environmental sense, which we can say there's also no public regulation on this. We're still relying on the DNV-GL standards and voluntary implementation of that. But we're seeing it coming up more and more. That sustainability also becomes a factor, not only on the energy usage, which has been for years this requirement on how much energy a building is to use, but a lifetime sustainability is becoming very, very becoming more and more important. It's becoming conditions for tenders, both private and public, that that you comply to certain sustainability standards. So I think that's an interesting development. Also, I think a topic, again, we're speaking from a regulatory point of view, is social sustainability. How in relation to the employment market, how is this for an investment? If that's a foreign investment, if it's a foreign contractor, what is the effect of the construction works in the local market? Do you see what you're calling social, what's been called social dumping here, where wages are dumped for foreign contractors? And what effect does this have? Do contractors have an obligation to ensure that they are using a number of apprentices, thus contributing to the long-term social sustainability also of the sector? This is something that we've actually also seen coming in, again, not as part of the building code, but as a factor that is gaining increased increased visibility and importance in these construction industries. I was very happy with the presentation we just saw. Again, with this integrated process is also one of the new hot things in Denmark. So, yeah, thank you.
Thank you, Steffen. Thank you so much. And yeah, I saw that what you regulate in your building code, statics, fire safety, energy consumption, and all other things. And I think we all regulate in our countries the same stuff, and we are obliged by doing it by regulation 305/2011 here, and which gives the basics for us, and then we go further with our national regulations, that we create more and more rules. But you touched BIM. I liked it a lot, because we also have a discussion in Lithuania whether we should introduce more regulations for BIM in Lithuania. And what I hear from you, we don't need any regulations. BIM can live by itself. And I want to thank you, Steffen, one more time. And I want to move further north to Sweden. And from Sweden, we have Olof Johansson. He's chairman of the Swedish Society of Construction and Consulting Law and the former vice president of the Construction Committee. He has published a larger number of articles regarding construction consulting and insurance law issues. He regularly teaches contractors, clients, consultants, and lawyers in construction and consulting law, public procurement, and insurance law. Olof also teaches law students in construction and insurance law at Stockholm University, and Olof is a co-author of Studies in European Construction Law, Dutch Institute for Construction Law. So, Olof, thank you so much for joining us today. I see you already unmuted. Are you having a presentation? Are you sharing the screen? Yes, we already see your slides, and we perfectly hear you. So, Olof, the stage is yours.
Okay, first, Evaldas, is the presentation in presentation mode? It looks nice for you. Okay. Fine, thank you. First of all, as I said, we talked yesterday, Evaldas, it's like feeling I'm in the Eurovision Song Contest and delivering the votes from the jury in Stockholm, Sweden. But now we're talking about building laws and codes, past, present, and future. And it has been very interesting to listen to Professor Jansen's description of the situation in the Netherlands and the history behind the building law and how employers purchase construction contracts, because we have also some experience of the French Napoleonic era, because in 1814 we imported one of Napoleon's generals to Sweden as king. So maybe that's why we have the same history as the Netherlands when it comes to construction. So anyway, the situation in Sweden for the moment, as you can see on this slide, construction is big business in Sweden, as in every country in Europe. And actually what people forget in the debate is that construction is also the biggest supplier to the public sector, as you can see, and it's billions and billions of euros every year, not only in Sweden but in every country in European Union. But and after listening to Professor Jansen and also to Steffen in Denmark, you can see the similarities between our countries, because in Denmark and in the Netherlands, there is no actual construction act or construction law, we can say. But that doesn't mean that there aren't laws that impact construction contracts, because there are many laws, public laws, that have impact. And one of the basic laws, actually, which is the kind of foundation in every construction contract, is the land code that we have in Sweden, and as in every country, I presume, because without the land code there and the kind of division of the real property in Sweden, it couldn't be able to actually build anything. So it's kind of a baseline in all construction contracts. And then we have, as in Denmark, the Plan and Building Act, which focus on zoning and planning, and that it couldn't even not be building anything without the Plan and Building Act, but it actually address the building proprietor or the employer, the client, not the contractor in any way. And then, of course, we have a Contract Act, which is quite old. It's from 1915, but it still applies today in every construction contract, in every contract, but it doesn't specifically mention construction contracts at all, because it's a framework law when it comes to contracting. And then, of course, also a Purchase Act, which every country has. And in the Nordic countries, the Purchase Act is quite similar. But it isn't applicable on construction contracts. But what we can see through the courts, for example, the Supreme Court in Sweden, it kind of always look a little bit on the Purchase Act to find some guidance when there are situations when the standard form contracts doesn't have all the answers on construction disputes. One other public law which is very important is, of course, the environmental code, which applies in every construction contract in Sweden. And then, as one of also kind of big act here is of course the different procurement laws that we have in Sweden, as in every country in the European Union. But there is one exception which is quite interesting. There is actually one law in Sweden which is mandatory and which focus directly on construction, and that's a law which is called the Consumer Services Act, and but it only applies when contractors build to consumer, as when you talk business to consumer, and those provisions, sections in that act is mandatory and cannot be changed by the contractor in any way. So that's the only example in law which is a direct example for the construction law, so to speak. So if we don't have any constructions act, what do we have? Yeah, as you can see, the same situation as in Denmark and in the Netherlands. We have standard form construction contracts, and that's a long tradition. It started in the late 1800, I think it was 1880, when a major in the army made up the first standard form contract in Sweden. And now we have a red book, we have a yellow book, and a blue book that is widely used in Sweden. I would say not in 100% of every procurement, but say at least 90% of all procurement contracts. And to add, there are some add-ons also, of course, because a lot of purchase doing in the construction sector is subcontracting, and there are some general conditions of subcontracting also, both for performance contract that we say the red book, and for design and build contracts, as we call the yellow book. And then, of course, for purchase of goods, we have also a standard form agreement. But that's one thing. To actually make a procurement based on the red book, for example, or the yellow book, you have to have general administrative instructions, and those we have guidance for the preparation of particular conditions for building and civil engineering works and building services contracts, which is called AMA AF 12, and it's very widely used. I would say in 100% of every procurement you have to use them, because it's impossible to the Swedish model of procuring construction contracts not using this AMA AF 12. And then, of course, we have the National Board of Housing, Building and Planning, which is called Boverket in Sweden, who are responsible for building regulations, mandatory provisions, and recommendations. And I will come back to that in a moment. And of course, we have the Eurocodes, and we have rules for making the different construction documents, drawings, etc. This is how the document looks. You can easily order them from Sweden. The red book and the yellow book is the construction contracts, and the blue book is for procuring consultancy services. And there you have the green and white guidance, which I talked, which is a kind of help when you procure construction contracts. So will there be a codification in the future, a certain construction act? Well, I could say the fast answer is probably no, because the tradition is strong in Sweden. The contracts committee, which I was vice chairman for many years, is still the entity who actually decides and the maker behind the standard form contracts in Sweden. And for the moment, we have a revision of the standard form contracts. It has been pending since June 2015, and the documents should be ready next year, and that's 7 years. And as a close follower to the process in Denmark, which took only 3 years, I'm a little bit disappointed for the moment, but we'll see. We will probably get new standard form contracts next year, maybe in the autumn. But the interesting question is, what happens if they fail? Well, the discussion or the debate is that maybe some of the parties, which are the members of the construction contracts committee, may address the question to the Department of Justice. It has never been done before, but if we fail, because we cannot live with the old documents so much longer, it could probably be the first time when we address the government. And what will they do with such a petition? It's hard to say, because the Department of Justice has very many different things on their desk. So probably this is not the most important, but if the sector demands it, they will probably take it serious, and there will be probably a bill of a new construction act in the future. But I will think that we will solve this as we have done before. There will be, my guess when I look forward, is that we will have a new construction standard form contracts in the autumn next year. So before I end this presentation, what is the frequent issues for the moment in Sweden? As Steffen was discussing, of course, the digitalization is this buzzword in Sweden for the moment, and we have come quite long when it comes to BIM in Sweden. I think we have it in maybe 30% of our construction contracts, but there's still a long way to go, and you can see that the people are not using BIM as it should be used. I mean, of course, in the construction phase, but it's the phase after the construction phase which is most interesting, and we are not there yet in Sweden. What we can also see is that the housing department, they are have several different lawmaking projects for the moment, and that is actually a big problem for us. I think it's about 20 or 30 parallel projects in the Department of Housing in Sweden, but it's just to live with that. Of course, we have the sustainability questions. That's very important and discussed for the moment, but also the environment questions. Shore protection, for example, is a big question now. We have the flooding problems also in Sweden. But the most important question for the whole construction sector is actually the lack of concrete. That is actually a problem today and will be a larger problem maybe in 2 or 3 months, because we have only one quarrying place in Sweden where they quarry limestone, which is, you know, it's a very important part of cement and concrete. So Heidelberg Cement's permission is actually ended this 31st of October this year, and the government of Sweden has given them well, a short period to keep on the quarrying, but we don't know how long they will be able to do it. So that's the biggest question for the moment in Sweden, because then there will be totally stop in the construction sector in Sweden if this question is not solved. Of course, we have a problem with escalating material prices. We have all the competition issues, of course, discussion on minimum wages, very sensitive, and the standardization question. Finally, what can we see? What is happening and what disturbing the construction business? Well, I would say that the problem is the frequent changes in the Boverk's building regulations. Also, when it comes to many other laws that impacts construction. And in Sweden, you can see on this slide, you can see that we actually legislate for building a Rolls-Royce, but who should pay for it in the end? Because that's the problem of the increasing building cost, is all this kind of regulomania, as I say in Sweden, and there is no serious measures taken to kind of lighten the burden of all the regulations. That's sorry to say, but the trend is going the other direction. And last, what has been the biggest impact on the construction sector when we come to actually the law or the contracts on the construction sector? Well, I can say that the standard for construction contracts has been, if you look 100 years back and today, probably the biggest change for the construction sector, the red book and the yellow book and the blue book, and also the other contracts to this. And last, if you're interested to kind of see a little bit more of the conditions in Sweden, don't hesitate to look in this book, Studies in the European Construction Law, which was a joint project we did a couple of years ago with the European Society Construction Law. End of my presentation.
Yeah, thank you all so much for your presentation. And I see we're sharing a lot of in common those frequent changes in legislation. They are really tiring, but sometimes maybe it's good because you adapt to new changes in the market and so on. So yeah, it's a huge challenge for all market participants. And the studies course you have, it was really good to hear about them more, because in Lithuania, what if we have Swedish or Finnish investors, they really like to use user form, and but they are more common in Finland, and we're moving up to Finland. Thank you all so much. And Rosa Lang is already waiting, and Rosa,
yes.
Yes, we perfectly hear you. If you're sharing your presentation screen, you can prepare it. And she's a senior associate at law firm Marketal Attorneys, and Rosa Lang specializes in construction law, project management, and various contracts. She also advises clients on employment law issues, and she is an experienced negotiator both in contract negotiation phase and dispute resolution situations. Rosa has worked for several years in International Construction Corporation as a group lawyer for the Nordic and Baltic companies. She also has been ranked for Legal 500 directory. So, Rosa, the stage is yours.
Thank you, Evaldas, and hi everyone. So my name is Rosa Lang, and I work as a senior associate at Mäkitalo Attorneys. And I also want to thank you, Evaldas, for this opportunity to participate in this conference and to share some information regarding the latest trends we have in Finland at the moment in the construction field, and also some background of the regulative framework we have in place in Finland. When hearing the other colleagues that was previously talking, I could see that there are some similarities, but also some differences in Nordics, how things are regulated. And I know that time is on the essence, so I'll try to be short so that we have time for the discussion as well. The first questions, is there a building code or construction law? There is no code as such in Finland. What we have is this Land Use and Building Act, and that is the primary piece of legislation. And underneath that, there are several subordinated regulations and decrees, which regulate in more detail these technical requirements of building. And these are partly based on the Euro codes, of course. Then the Land Use and Building Act itself, it includes provisions for town planning, plot division, some general requirements on building, and then it covers the whole process of building permits and supervision by municipality authorities. But it does not have any terms or any rules regarding the private construction law. So it does not regulate the relationship between the different actors in the construction project or processes. All these regulations, so the Land Use and Building Act and the subordinated regulations, are issued by the government and the relevant ministries, and they're all pursuant to this Land Use and Building Act. In addition, certain matters like energy efficiency and some requirements for construction materials are regulated in separate laws. Then, however, for example, for myself, being a lawyer who works in the construction industry and more with the parties that are actually acting in these construction projects, it's not so often that I need to go to see the actual act. But the same as in Sweden, we have a set of standard agreements in place that are being widely in use in all the construction projects. Here we have 3 main industry standards. We have YSE 98, which is covering the general terms and conditions for construction works. Then we have Ryhti 2000, which is covering the conditions and terms for procurement of construction products. And then we have the KSE 2013, which is covering the conditions for consulting and design. And all of these standard agreements are applied throughout the contract chains in the construction projects in Finland. And as in Sweden, I can say that these are very widely in use, almost 100% of all the projects, at least 95, I would say. However, as you can see from the years, they are quite old. So some of the terms are already a bit outdated, and they do not take into account, for example, digitalization. There's no terms related to BIM, for example. And on that regards, we don't have any laws that would regulate BIM either. So it's the same situation here in Finland as it is in Denmark. Maybe because of these terms are quite old. So during the time, the parties that are acting in the construction industry have also prepared their own standard agreements. So currently there are many deviations agreed between the different parties. And this is, of course, affecting the whole balance for the risk allocation. The whole system is based on the idea that the same terms are used as such throughout the whole subcontracting chain. And when parties are using their negotiation power to agree deviations, so this will affect the whole balance. Then the question whether there's a demand for codification, I would not say so, but we have definitely a demand for reform. The current Land Use and Building Act is already from the year 2000. So as I said, also regarding the standard agreements, the act itself is also quite old. And actually at the moment there is a undergoing reform work stream for the new Land Use and Construction Act in Finland. There naturally has been some minor changes during the years. On average, we have 1 to 2 amendments per year for the Land Use and Building Act, but there has not been any comprehensive reforms before now. The reform work is in very early stage at the moment. The plan is that the new act would come into effect only 2024 at the earliest. So we will see what happens with that. Also, there are quite frequent updates to these subordinated decrees and regulations. And one thing worth to mention is that in 2018, there was Finnish regulations amended to enable this formation of 3-dimensional real property units. So these 3D property units. Well, then what we have for regulative trends at the moment, well, the biggest, of course, is the reform of the Land Use and Building Act. And there we have 3 driving objectives or targets which the legislature would like to achieve with this reform. One is related to climate change and decarbonization. And here the aim is, of course, to minimize the carbon footprint caused by this whole construction sector. And the way to do this is that in the future, the authorities should also, or already in the planning and permitting processes, consider all the impacts that these projects will have, and especially the carbon emissions of the projects. Then the second objective of the new reform is to streamline the permit and land use processes. And here we aim to minimize the workload for the authorities and also ease the process for the applicant. Then the third one is ensuring the participation rights for all the affected parties and their rights to appeal against these decisions that are affecting them. And as you might understand, the balance between this target and the above mentioned streamlining goal is very delicate. Then one important matter regarding this new reform is the legislator's will to actually include a liability rule in the new law. They have identified that we would need to improve the quality of construction work. And for this, they are now introducing a statutory liability period of 5 years for all the contractors. And as it is now, the liability and the relationship between the parties is heavily covered by these standard agreements. And there we have a liability period for 10 years. But that is still under the freedom to contract. We do have, in different acts, we do have some regulations that are governing the liability for developers. There we have also the 10 years liability period. But this would be the first time that we would have the liability period stated in the Building Act. And regarding this, it's very problematic for many participants or many actors who are active in the discussions, and a joint understanding on how these liability matters should be regulated has already been proven very difficult to achieve. So whether this actually will be in the final act remains to be seen. Then in addition to this reform, we have several digitalization reforms. And there the aim is to improve the management and use of information. And through these reforms, information that is now located in the various central and local registers would be in line with the international standards, and it would also be more interoperable and usable. Those are the main targets. And now we're ready for discussion, at least.
Yeah, thank you, Rosa, for a perfect presentation. Yeah, it's interesting to hear that Finland is also going into reform on the land use and building regulations, and that climate change is one of the, those ideas which also should be regulated in this law, because Lithuania just this year enacted amendments to territorial planning law, where this carbon footprint issue is also broadly covered, and this, I think, trending all over EU countries. So thank you thanks for all participants of this panel, and I really like the idea set by Chris Jansen that the law should encourage the participants to agree on and to find that solution to make that final work done. And Rosa, you mentioned that the 5-year liability term should be introduced in the law. So who's the main performer of the works? Who's the main person to be liable, the main actor of the construction field under Finnish law at the moment, and what the reform is saying?
So currently the whole liability is regulated under these standard agreements. And there we have the 10 years liability period, which I think it's the same as in Sweden, if I'm not mistaken. And then in addition to that, we have some other laws, for example, that are regulating the liability for the developer of the project. And there we have a 10 years liability period. But at this moment, we don't have any general liability rules under the Building Act.
And Olof, are there any changes upcoming to Sweden regarding this?
No, I don't think so. This liability, when it comes to the liability period question, it's a foundation in the standard form agreements, this 10-year, and which of course starts with a 5-year warranty period for the contractor, but the liability period is 10 years. And we have also laws dealing with these kind of questions. For example, I mentioned the Consumer Services Act, which is mandatory when it's business to consumer construction works performed. There's also a liability period of 10 years for the contractor in that law. So there will be no changes.
And one more question. If all Nordic countries have those standard forms and they live by those standard forms, but when it comes to real technical issues, how the construction should be designed and so on, how those standards are implemented, who enacts them? Are they imperative, or you just use Euro codes, or you have also national standards there?
I can start.
Yes, so.
Of course, we use the Euro codes for the construction parts, but I mentioned this Swedish entity, what we call Boverket, which every year presents rules on housing, and that they are widely used, and they're also you're obliged as contractor to follow those in every aspect when it comes to fire or whatever. So because there's a connection between these rules that Boverket hands out every year to the Plan and Building Act, they are connected. the Planning Building Act is the actual framework for every housing project in Sweden.
Steffen, would you add from Danish perspective?
Well, certainly, I don't think we are not experiencing the same issues. If we go back to the issue of liability period, that's 10 years for consumers and 5 years for non-consumer construction. I think and you have 2-year warranty period for some items, and I think the only thing that's being considered right now is to extend the 2-year to a 5-year period, and that's also for sustainability issues. On regulations, we just got the building regulation 2018. We don't see major amendments coming up soon. There's a large overhaul work done to the 2018 regulation. We've had a small update, but overall we don't see into large scale changes on that side, not at the moment. And I just got back from being disconnected earlier.
Okay. I also heard from Olof that tradition is very strong in Sweden, and I felt from all the speakers from this section that tradition is really very important. And if there's a newly introduced, some new legislation is introduced, so it's done very softly and quietly. Am I right, or I got a bad impression that tradition rules there?
I can, yes, it really does. And I have actually studied the standard form agreements in both Norway, Sweden, Finland, and Denmark. And as Steffen was in, they are different, but there are a lot of things that are similar, you can say. And it's actually interesting that the Supreme Court in Sweden actually quoted a Supreme Court verdict from Norway in one case, and another case in the Supreme Court quoted a Supreme Court decision from the Supreme Court in Denmark. So it kind of, you can see a lot of common things in the Scandinavian and Nordic countries.
And also I can add that when it comes to Finland, it will be interesting to see what happens now after Sweden will change their standard agreements, because usually the trend is that if Sweden does something, we in Finland we usually follow. So, but how many years it will take, we're quite careful when it comes to changes regarding these standard terms.
Do your benchmark to Denmark. 3 years. Yes.
Let's see. I think there's still a lot of work to be done on the new Danish model for standard contracts, which came out in 2018, along with the new building regulations. I think there's still some work to be done. Prerogatively, we said that it's about it was outdated by the time it was done. So we are expecting some amendments on that as well.
Okay, so thank you. Thanks for everyone. And the final remarks from each of you in a few sentences from this section. Chris, let's start from your side. What would be your final words and final insights from hearing back from colleagues? And unmute yourself. I see that you are muted.
I think that for all systems it goes that you really have to consider thoroughly the connection between the public law, which is mandatory, and how you give it a place in the self-regulation and the standard forms of contract, the interaction between the two. That's particularly in my country, and I think also in many other countries, that's something really to consider thoroughly.
Thanks. Olof?
Yes. I have thought a lot during the years on the digitalization issues and this with building information modeling, and is it a legal question or is it a technical question? And I have ended up that it's more a technical question than a legal question, because our old standard form agreements are applicable on these new technical issues, I think. But you never know.
Totally agree with you. And what when we had talks with the Ministry of Environment, they also are saying that we need to digitalize more and make it more consumer friendly. And maybe IT solutions would help to do that without making a considerable change at present regulations. Steffen, what's your final words? Steffen,
did you say my name, Evaldas?
Rosa, then you, go you.
Okay, yes, okay, sorry. Yes, I just want to thank you for this opportunity to also hear about other Nordic countries and how these regulations are formulated there. I think it would be, at least for my position, it would be good to have even more cooperation and understanding of how things are regulated in other Nordic countries, as our clients, they also have international projects that could be cross Nordics. And it would ease up if the standard terms would be similar. So let's hope that that will be in the future the case.
And Steffen?
Well, I think one thing here is, at least now the Danish terms are available for free and in English, so you can always read up on that. So, I think that's actually the only ones that are available for free. I'd also say on BIM, this is mostly a technical matter because you come into a very technical language. So I'm agreeing with Olof there. I think you need at least one provision in the contract, and we have the FIDIC BIM protocol to be inspired by. I would not recommend being inspired by the Danish standard terms on that regard. I would probably look to the FIDIC protocol instead.
Okay, so thanks everyone, and we are leaving for a 15 minutes break now, and we'll meet you soon in another section in Central and Eastern EU jurisdictions. Thank you one more time, and see you. Welcome back, everyone, from the short time break, 15 minutes time break we had after the Nordic jurisdiction section. And now we are already on the third section, regulations, construction regulations in Central and Eastern EU jurisdictions. And we have the speakers from Hungary, Romania, Slovenia, and Poland. And we'll start with the first in our line is Dr. Tamas Balázs. And Tamas, you start your presentation if you have. You just can share your screen, and I already see you turned on your headphones. All good. And Tamas is the managing partner of Balázs and Kovács legal partnership, and a honorary professor of law at Evaldas University Faculty of Law. He has published over 70 professional publications, and he is the representative of Hungary in the European Society of Construction Law. And thank you for joining us today, and the stage is yours.
Yeah, thank you very much. Good afternoon. My name is Balázs Tamás. I'm the managing partner of Balázs and Kovács legal partnership. We are engaged in, generally speaking, in business law, construction law, real property law are our special areas. We have more than 30 years experience in these fields of law. And this afternoon, I would like to give you a review on the construction law regulation in Hungary.
Tamas, share your
yeah,
screen.
at the moment,
Yeah.
Okay. We have a small technical problem.
Technical problems, sometimes it happens. Yeah.
Of course.
Yeah, now we see your screen sharing.
Yes. Yeah. Yes. This afternoon, I would like to give you a brief review of the most important regulation of Hungarian construction law. Actually, Hungary doesn't have a special unified code of construction law. We have a lot of legal rules, and in this slide you can see the most important construction legal rules of Hungary. The basis is the Hungarian Civil Code, but the Hungarian Civil Code you can find only some paragraphs, special paragraphs which concern the construction law contracts. The two most important legal rules are the Act number 78 of 1997 on the development and protection of the built environment, and other very important Hungarian construction legal rule, the government decree 191 of 2009, and in the Act 150 of 2016 is practically the administrative procedure law, but we have a lot of other legal rules. You can see some of them in the next slide. There is a government decree on the integration of necessary construction law procedures in case of high-value construction project. There are some special rules in connection with the chief architect, on the supervision procedures, construction fine, etc., etc. As I have mentioned, there is not a unified code of construction law in Hungary, but there are two legal rules which have great importance. As I have mentioned, this Act 128 of 1997 and this government decree 191 of 2009. The Act contains practically the most important principles and general requirements of the law in connection with the construction projects. And this Act defines the task of the Hungarian state, of the central government and the local government. But in this Act, you can find, first of all, general rules. The decree 191 of 2009 regulates the execution activity. This government decree may be the code of the construction execution activity, because in this legal rule you can find the most important rules of this execution activity. This decree regulates the conditions, personal requirements in connection with the participators of the construction execution activity. In this decree, you can find the minimum content of the construction contract, the rules of keeping of a construction log, etc., etc. Generally speaking, as I have mentioned, there is not a building or construction law code nowadays in Hungary. The regulation is very casuistic. There are more than 40 important legal rules in field of construction law, and it is very different for the participators of a construction projects to realize the hierarchical relationship between these legal rules. It is the hierarchical relationship between lex generalis, lex specialis. This actual situation has a lot of reasons. Unfortunately, there are not textbooks, case books which could comprehensively manage construction law, and there are some books which contains contains some partial questions in Hungarian construction law, and unfortunately there is not a separated independent studium at the law faculties and the technical faculties and construction law. In the majority of cases, construction law is a part of real property, real estate law at these universities. This actual situation is a challenge for us, for Hungarian construction lawyers, because we have a lot of tax in the near future, and because this actual casuistic situation should be cancelled, and deregulation procedure should be begun. And construction law should be introduced at law faculties as an independent studium. In technical universities, the same situation, because in technical universities there are practically only informative construction law courses, seminars, and of course the Hungarian government should organize the construction law, postgraduate construction law courses for participators, for participators of current construction law projects, and publication of comprehensive construction law textbooks should be promoted by the competent ministry of the Hungarian government. And finally, I would like to give you outlook on the application of international construction law in Hungary. First of all, application of so-called FIDIC contracts, because it is a very important challenge for us, for Hungarian lawyers. If a FIDIC contract should be applied in Hungary in connection with the high value construction projects on territory of Hungary. Generally speaking, I can tell you that FIDIC contracts and international construction law can be applied in Hungary, but not automatically, because the Hungarian construction law has some so-called Hogan provisions, and this Hogan construction law rules should be taken into consideration if foreign company, foreign investor would like to make a Hungarian construction investment on territory of Hungary. Of course, there is the opportunity to choose choose a law of another state, but in this case, even in this case, some construction rules, Hungarian construction rules, should be applied. For instance, regarding issuing building permits, and the paths of international construction project in Hungary should take into consideration that Hungarian construction law has not only Hogan provisions, but some dispositive rules which should be applied if the parties doesn't make in the construction contract other provisions, other sections. In case of application of a FIDIC contract in Hungary, it's expedient to prepare a contract documentation that also takes into account Hungarian construction law. It is a very significant challenge for us, for Hungarian construction lawyers.
Yeah. Thank you for your presentation, and because I know you have to leave soon, and unfortunately you will not participate in our discussion.
Unfortunately, two of my colleagues became unfortunately COVID positive yesterday, and I must substitute one of them at court trial in some minutes, and unfortunately I cannot participate in this panel discussion.
But we heard from you good insights from Hungarian law that it's not codified. It's the regulations are quite scattered, and it was really good to hear your insights on the FIDIC implementation, because we also use them in Lithuania, and always before you use a FIDIC contract agreement, you always make some adjustments and amendments related to national regulations, which relates to construction permit issue or acceptance to use. So thank you, Thomas, for your insights, and we're moving to Romania, and we have Lavina Rasmussen, who is a partner in real estate practice and one of the law firm. And she has been ranked as and recommended by Legal 500 and Chambers Europe for many years now. And she has over 15 years of professional experience, which covers all specific matters related to the construction and real estate industry. Lavina is also specialized in FIDE contracts, and I think it's trendy in all our region that opposite to the Nordics, which we had in previous section, they have their standards agreements, so they don't usually use FIDIC, yeah. But we here, we don't have the standards, or at least they are national standards are very poor. Therefore, we using FIDIC. But Lavina, you are encouraged to share your screen and start your presentation.
One second.
Yes,
everybody.
Yes, we see it and hear you perfectly.
Thank you very much for the introduction, Evaldas, and thank you very much for the opportunity to be part of such a great gathering today. We followed your conference, and I must say that it's a success so far. Just one sentence about the company that I represent. So Nestor Diculescu Kingston Peterson is one of the largest law firms in Romania. We are covering all practice areas. We have over 120 lawyers, so I'm just one of them. And one of our areas of expertise relates to construction and urbanism law. The presentation of today is meant to give you a general overview over the Romanian construction law, and also a few particularities on aspects that we saw as being more challenging in the context of the advice that we offer to our clients. Just like in Hungary, we do not have construction and urbanism code. However, the legislation in the construction field is quite diverse, and we have quite a large number of pieces of legislation that are regulating this field. I have presented on this slide only the main ones to which we refer on the everyday advice. So it's Law 50, which is regulating the authorization and the permitting process underdone in relation to the execution of a certain project. We have a special government decision that is regulating the reception procedure in case of the construction works. Even though it looks like it's enacted in 1994, it was further supplemented and amended, just like all other pieces of legislation referred to in this screen. We have a special law, which is Law 10 on 1995, that is regulating the quality in construction and is providing for quite a large number of provisions concerning the liability undergone by the various experts participating in the process, and is setting also the rules and the principles that have to be observed in connection with the quality of the construction works and the safety thereof. We of course have provisions in the Romanian Civil Code. The Romanian legal system followed the Napoleon Code from 1865, but now we have a new civil code inspired from the same code, which was enacted in 2011. We are calling it the new civil code, but it's 10 years, so it's no longer as new. And then we have the Law 350, which is regulating urban planning, meaning what sort of urban planning rules and urban planning documents you need as part of the construction process. In addition to these pieces of legislation, there are quite extensive other regulations that become applicable, starting with environmental law related procedures, especially for projects that have an environmental impact. Construction projects, we have special provisions that are regulating the construction fields when we refer to historical monument and protection of historical heritage and so on. In terms of contract forms, the Romanian legal system does not acknowledge standard construction forms. So there are no standard construction forms imposed by law. We are quite flexible when drafting the construction contract, the FIDIC-based contracts remain a source of inspiration for both the legal and the technical advisors. Just like you mentioned, Evaldas, we have the opportunity here to use a FIDIC standard form and through the particular conditions or through integrated condition, to amend such a FIDIC standard form and to adapt it to our legislation. In the public segment, the FIDIC forms were used for a very long period of time. And in the private segment, they are being used as a result of the fact that we do not have a standard form. So they are well drafted and we like to get inspired from them. However, irrespective of the contract form that we are using, just like in the other jurisdictions, we need to follow some mandatory legal provisions that are applicable. For example, some of them refer to the warranty terms. The contractors, the designers, the architect, all the specialists participating in the construction process in line with their liability undertaken by contract or by law. They are liable, for example, for a period of 10 years as of the reception date for hidden flaws. And in terms of the structure of the building, their liability is provided by Law 10 to exist for the entire duration of the construction. Also, the procedure regarding the reception upon the completion of the construction works is expressly regulated by law, and we cannot amend it in the contract. However, in the context of the taking over procedure of the FIDIC contract that you have mentioned, we have the opportunity to have two parallel reception, being the knowledge that the contractual reception is more detailed and is following some more special rules that the party wish to acknowledge in between them for determining that a certain construction was finalized as per the contract and not only as per the law and the building permit. In addition to these mandatory legal provisions, we also need to observe some fundamental requirements. We're referring to construction works, and these are considering quality and safety, mechanic resistance, fire safety, noise protection. So these are basically general rules and technical rules that should be considered for the purpose of construction projects in general. In terms of the urbanist code, which is also the fact that originated this conference, to my understanding, Romania does not have a construction code, but just like your country, we are working on getting one. And this is a project that is being initiated by the ministry committees for quite some years. In this year, in March, there have been voted by the government the thesis that will stand as basis for drafting such a construction and urbanist code. So this is a very ambitious task. We don't expect to see a draft code soon. However, the thesis that are being announced seems to take into consideration the current challenges of the market. So obviously the necessity of such a code is coming from the insufficient correlation of the various pieces of legislation, and also from the fact that the urbanist matter remains a matter of public interest, the only one which could basically allow a coherent development. The improvement claimed by the public authorities when discussing about such an urbanist code refer to the items that I have put on this slide, and one of them is reducing the timing and the costs of the permitting process, adapting the permitting process to the complexity of a certain project. In the moment, less complex projects go through the same procedure as a very complex development, mitigating the risk of disputes and litigation, increasing the number of specialists in the public segment, and a very important aspect which I have seen mentioned in this thesis is referring to the regulation of the manner in which the private and the public segment could collaborate in order to access more expertise available for the public authorities when drawing their decision on a more economic and efficient basis. I'm pointing out on this particular aspect due to the fact that very often our clients are interested in supporting the public authorities in more public projects and segments, but we do not have the legal background available in order, for example, to privately subsidize certain expertise that would be necessary for the authority to make a documented decision in a certain aspect. So the current practical challenges, I have split them in three, and I will discuss in particular about one of them. So the timing for permitting a project in Romania is between 3 to 6 or more months are necessary. It could be up to 1 year or more in case urban planning documents are necessary to be obtained. The permitting project starts with an urban certificate, with an information and endorsement from the environmental authorities, and then it continues with maybe the necessity to have urban planning regulations, new urban planning regulations, such as a detailed urban plan or zonal urban plan, if the existing urban parameters are not allowing for the construction to be directly permitting. Then another challenge that we see is the risk of challenging the permitting documents, which is leading to the risk of having construction works suspended or demolished. This is a matter of particular interest for the clients that we are representing when investing, when acquiring a construction that is already receptioned, or when looking on how to develop a certain project that was maybe initiated of a less sophisticated person that did not follow by the book all the rules. I have to mention here that, for example, a building permit can be challenged within, which is considered to be an administrative deed, can be challenged within a time frame of 30 days as of the day the interested party took knowledge of the respective deed. But at the same time, the law is saying that for serious reasons, this can be up to 6 months. This is the preliminary contentious procedure, then the litigation procedure. And then based on so-called exception of illegality, such challenges could be brought up at any point in time. So also in terms of the zonal plans, certain deeds in the permitting process can be challenged at any point in time. And this is bringing instability and lack of prediction as to the legality of a certain construction. Then I refer to another practical challenge refers to the fact that illegal constructions and entering into legality is insufficiently regulated under our legislation. And this is one of the topics that I will develop just a little bit more than the others. So execution of a construction without a building permit or without observing the provisions of a certain building permit represents a minor offense. And it can lead to the suspension of the works, the demolition of the works, and so on. Of course, from an economic perspective, it's very important to know what can be done in order to save the respective project, to make it compliant with the law, and to save the finances that have been invested in it, without prejudice to potential liability of the parties that have failed to observe the law when performing the respective construction works. There is one general condition acknowledged by law, and it's provided under the urbanism law, which prohibits the initiation and the approval of urban planning documentations that have as purpose the entering into legality. In other words, the constructions that were illegally constructed, which do not observe the urban parameters in place, cannot enter into legality. So you cannot apply for a zonal urban plan post factum, which on the one side we can understand, on another side we are standing with constructions that are there for a long time, and we would like to make them marketable for the interest of all parties, again without prejudice to sanctioning those that fail to observe the law. So the entering into legality in Romania, in Romanian legislation is scarcely regulated. There are two scenarios which are mentioned by law but insufficiently detailed. One of them is the entering into legality before the expiry of the statutes of limitation for sanctioning this minor offense, which is the statute of limitation is of 3 years as of the reception of works, and then the entering into legality after the expiry of the statutes of limitation for sanctioning the minor offense. Basically, if the construction is there after 3 years and nobody noticed that it's illegal, then we have a provision in the law on how to do it. I must say I have not tested in practice this, but I would be happy to see more norms regulating this manner. I would like to indicate that by the word of the law, none of these scenarios takes into consideration a case when somebody is saying, I want to enter into legality. How do I do it? Of course, it's not prohibited, but also you don't have it expressly mentioned, which is quite interesting. So in the case of scenario 1, so when we are during the sanctioning procedure, the authorities that are ordering the suspension of the construction works or have the chance to indicate the adoption of certain measures necessary for accommodating such works within the provision of the building permit. The term in which the investor is compelled to enter into legality and obtain the permit for entering into legality should be the ones provided by the authorities that are issuing the minutes attesting this minor offense. So basically, when the public authorities are noticing that a construction is illegal and they are applying the fine, they are coming and they are mentioning, you need this expertise, you need this endorsement, and so on. However, this process is not sufficiently regulated, so there is a lot of freedom on the side of the public authorities, but there is also a lot of fear on their side, because while they cannot ground their decision on certain legal provisions, sometimes it's uncertain what do you have to do to enter into legality. And then the second scenario, which I have mentioned, is basically legal provisions in the construction law, which mentions the deeds based on which you can register a certain construction in the land book. And through these deeds, it is mentioned the certificate attesting the construction of certain building that can be issued based on a technical expertise meant to determine the observance of the applicable fundamental requirements by taking into consideration compliance with urban planning regulations and the observance of relevant legal provision and cadastral documentation. What I put on the screen is basically the translation of the provision of the law, so you can see how little information it is about what this technical expertise should really determine. Of course, in case the technical expertise determines that the fundamental requirements and those related to compliance with urban planning were not observed, this type of attestation certificate cannot be issued, and then basically you cannot enter into legality. So after 3 years, when the minor offense can also not be observed, you don't know how to enter into legality. At the same time, you are hoping that most of the statutes of limitations for being challenged or demolished and so on have lapsed, and then you find comfort in certain mitigations that you can invoke. So just to conclude on my presentation, the essential changes that we see as being necessary in the new urbanist code would be a simplified procedure for the permitting process, more clear procedure regarding the entry into legality, and shorter terms allowing for challenges of the building permits and of the urban planning documentations.
I just have nothing to add, Lavina. It was a pleasure to hear your presentation and to see that you had very similar challenges in your country, because you're also working on new building codes, which what market players are saying that we need new regulations. So it's common almost to every country. It was really interesting to hear those principles of upcoming legislation, and I think they are all clear and very helpful even for us. Entering the legality, That's a very sensitive topic, and that limitation of 3 years, isn't it too short? I don't know, but you know, if you look from the public
we see it as an opportunity, not a limitation. But I think Hungary has more, but Tamas has more clear regulations about entering into legality. So we may get inspired from there.
Okay. Okay, it was very interesting. Maybe we have more time for discussion later on. And now I want to present one more person from Romania. It's Alexandra Perez, and she is a managing associate with Tuca Zvartea and Associates in Bucharest, Romania, and is one of the most reputed member of the real estate team with a strong expertise in construction law. As part of experience, she has been involved in major projects of Romanian market, advising in retail, office, logistics, and energy sector on the real estate related matters. So, Alexandra, I see you already unmuted. Hi, we hear you perfectly. And if you're showing us your presentations, you may share the screen. And yes, we see the presentation. So. The stage is yours.
Hello to any of you. Nice to meet you. So since the surprise was spoiled by Lavina, we are not codified as well in Romania. Not yet, and not soon, my opinion, but never know. So I also presented a slide with the main pieces of legislation governing for the construction process. Starting with a deed from 1996, almost forgotten. It's the General Urbanism Rules. After that, we have the law on urban development. We have the construction law, law number 10 for building standards, and the government decision 273 on the reception upon the completion of the works. These are the main legal enactments governing for the construction process. And each of this legal deed regards a certain step of the construction process. So as a general idea, in Romania, it's not easy to get a building permit. It's one of the most complex procedures these days, especially. In order for a developer to, let's say, assess on the conditions under which he may develop a certain investment, he has the obligation to request from the public authority a document called urbanism certificate. This is an administrative deed. It has only an informative character, doesn't allow you to perform construction works, but provides information on the legal, economic, and technical regime of the relevant land plot. As well, through the urban planning certificate, the public authorities usually informs the developers on the conditions to be fulfilled in order to get the building permit. In most of the cases, the development of an investment requires the prior approval of a urbanism documentation. Unfortunately, we are not at that stage when the existing urbanism documentation allows the direct development of certain investments. So this is the first step to elaborate an urbanism documentation. We have three categories of urbanism documentation: the general urbanism plan, which is the tool of the public authorities. We have the zonal urbanism plan and the detailed urbanism plan, which usually stays with the investors. General urbanism plan applies to administrative territorial units, communes, cities. Zonal urbanism plan applies to a certain plot of land within the boundary of a locality. The most, let's say, common urbanism documentation for an investor is the zonal urbanism plan. So prior to get a building permit, you need to prepare such a urbanist documentation, which takes 6 to 12 months in best cases. We need to mention that currently in Bucharest, it's a deadlock as regard to the possibility of any development. In the beginning of this year, the new public administration suspended all the zonal urbanist plan applicable to each of Bucharest districts. So currently we are not having the basis of developing certain investments, and it's a deadlock lasting for more than 1 year. No one can predict the future. Hopefully this situation shall be mitigated as soon as possible. As discussed in the previous slide, the PUG, the General Urbanist Plan, stays with the authority. The public investor is not allowed to interfere there. Unfortunately, at the level of the entire country, the urban planning, the general urban documentation, it's quite outdated. Bucharest Urban General Plan was entered into force in 2000, was updated several times, and up to 2021, we were not able to produce a new general urban plan. So yes, the legal background does not keep the same track with the actual development on the market. PUZ and PUD, the zonal and the detail, stays with the investors, but it's not, they are not so easy steps to be taken, because we don't have, for example, a single office to which an investor should address the request. The investor requires the urban planning certificate, and after that, he's obliged to submit documentation to 10 or 15 or 20 authorities in order to get prior approvals. And since we don't have a precedent law case in Romania, we don't have also the same approach from the authorities. So yes, the length of the permitting process, it's not that one provided under the law. 30 days to get the permit, 30 days to get the urbanist documentation. It's about months or even years. The documents that entitles to actually perform construction works is the building permit, document for which, again, you need to resume the permitting, asking an urban planning certificate, collecting all the prior endorsements, and after that, waiting for the authority to issue this document. The building permits, we need to mention, I don't know how it's in other jurisdictions, should be issued only to that investor who holds a real right, a right in rem over the land, like property, concessions, superficies. So you need to have a right that allows you to build and become the owner of the construction developed on the land. So when you need to fulfill this quality in order to maybe able to get the building permit. Of course, we need to pay some taxes. In case of residential, it's 0.5 from the estimated value. But in case of major investments like retail, office, logistics, it's 1% of the value of the construction works. In addition to elaborating prior urbanist documentation, an investor should know that also other conditions needs to be fulfilled prior to obtain a building permit. For example, in case the land plot whereby you want to build something, it's not located in the intramuros area, you need to fulfill a certain prerequisite, including the land in the intramuros, of course, paying some taxes and after that, obtaining the use category of constructible land. The building permit, again, not an easy step. Another 6 or 11 months should be considered for each investor if they want to obtain a building permit, especially in Bucharest or in the main cities in Romania. Requires to obtain the urban planning certificate, the relevant endorsements indicated by the certificate, and of course the preparation of the technical documentation, which is a separate item. So if you are lucky, you get the building permit, you execute the construction works, you need to fulfill another different procedure, completion of the works. Here we have, I believe it's the newest legal enactment regarding the completion of the construction work. We have a new regulation, quite comprehensive, and I would say that it's the last piece of legislation that give headaches to the investors. If prior to this document, we can have a reception with some reserves, receptions with some flows. Now, if you are not completing the construction works and if you are not observing the requirements that lays down in the building permit, you can face the reality of not having your building assessed as completed. If not having this document, you are not able to commission to use the construction. After having this certificate for testing the completion of the construction work, in order to use the construction, you need to register with a land book. So you need to get a certificate ascertaining the completion of the construction. And once you registered the building with the land book, you may assess that the construction process is completed and you can market your construction. Here I make a chart of the steps to be followed. So you need to get the urban planning certificate, get a urbanism documentation, get a building permit, have signed the reception minutes, obtaining the certificate attesting the completion of the construction. Not an easy step, but the investor who fulfills all this means that should be a happy owner of a building in Romania. Yes, there is a demand to codify construction legislation. As Lavina already told, we are in an incipient stage of having a construction code. Maybe it will take a couple of years to have it finalized. In my opinion, one of the needs for this construction code is the frequent and not correlated alteration of the legislation. We have here the habit to amend, for example, the construction law, but not updating also the subsidiary legislation, updated the urbanist law, but not considering the ancillary legislation. So we are facing the situation where we have the same legal topic discussed differently under pieces of legislation which are enforceable for a construction process. As well, one of other needs for a construction code is the fact that the public administration authorities have different approach as regards the actual implementation of the construction regulation. Also in Romania, construction law, it's, let's say, a new topic to be learned by the students in the law university. When I followed the university, construction law wasn't one of the topics to be discussed there. When I started to work in that field, I know the general principle from the civil code and get in front of me some pieces of legislation for which I learned how to apply from practice and from together with my clients. We were technical and so on, because we hadn't been able to discuss with professors or something. Now I understand there is a course in the law faculty regarding the construction law. Construction code mainly should ensure the development a certain level of predictability as regards the course of their developments in Romania. If you have the legislation gathered in one document, all the steps should be, let's say, correlated, updated, and you have a clear overview, not searching through 10 or 20 legal enactments to see which is the relevant legal provisions. The problems that the industry frequently face in Romania are the main one is the unjustified delays in getting the building permits or the urbanist documentation. As discussed under the law, we have a general term of 30 days. 30 days of the date when you submit the documentation. Well, these 30 days usually it's 3 months, 6 months, 9 months, or 1 year. And no, you don't get, let's say, arguments from the authority why it's delayed the approval of your request. Deadlocks generated by the change of the urban planning policies at local levels is another problem. Discussing in Bucharest, we have such deadlock for almost 1 year. And to be frank, there are cases when I don't know what to answer to my clients when they ask me, what's the status of my documentation? What should we do? No one wants to enter a fight with the public authorities to stay in court and so on. Urbanist documentation and building permits are quite frequently challenged in court. This is another problem facing the developers. And the grounds on this challenge mainly stays in the lack of clarity of different pieces of legislation. And this entitles third parties to challenge your construction permit, which means suspension of construction works, delays in completion, and actually loss of money. As well, we need to say that either we don't have, or if we have outdated transitory norms, which helps us to better understand the main legal provisions stipulated under the construction law of the urbanist law. So yes, we need to update, we need to correlate the legislation, and hopefully this shall be done by the envisaged construction code. What are the, let's say, the reasons triggering the problem faced by the industry? It's that from my point of view, there is no focus for the construction regulations currently. Also, or even a very important topic, the authority didn't pay the necessary attention. Political instability, which is a problem that we are facing in Romania for the last years. Economic instability in the last 2 years, also due to the pandemic. And again, the outdated and not correlated legislation. So these are the main problems which triggers the insecurity for the developers project. As remedies to introduce clarification and integrity, it's the simplification of the permitting process by common regulation under the Urbanism and Construction Code. And as told you, this unique office where you should submit the documentation instead of taking walks sometimes to the different authorities. Another remedy should stay in the obligation of the authorities to update the general urbanist plan applies for their territory. So to address the social and economic requirements up to date. if we should have, let's say, general urbanist documentation updated, the investors shall not be need to elaborate a PUZ or PUD to deviate or just to update the technical regime with the parameters of their investments. So yes, if these two remedies shall apply, for sure the permitting process would be less lengthy and much smoother than currently. And I believe this was.
Thank you, Alexandra, for your presentation. It was really nice to hear the other little bit different approach from the Romania. Still, I'm so happy that in Lithuania we have those good IT systems, and everything, all coordination with these institutions is done in distance. We just put the whole documentation in the system, which is called Infostativa, Info Construction, and that's it, and it's done. And you don't need to meet people face to face and go from one institution to another. Sometimes some architects are still doing, you know, to get those approvals earlier, but I totally understand what you are talking about, and that situation is not the best for the good foreign investments environment. And I hope that your government will understand sooner or later that if they want to attract foreign investments, the anti-corruption system and all anti-corruption measures should be applied in the country. And this is the only way how we should and can go on. And I now want to move to another country, to Slovenia, which is always mentioned with good words in Lithuania, as they are doing a lot to attract foreign investments, and they are all, sometimes introduced as a good example how the forms should be made. So we have Sasha Yovchis. He's a partner at law firm Podjed and Andris, and he focuses on real estate and construction law. And Sasha, yes, we see you. Are you sharing your presentation?
Right.
Yes, we hear you perfectly. And your presentation.
Okay. Is it working?
No, we don't see it yet.
How about now?
Yes, now we see it. Yes, perfect.
All right.
So Sasha, the stage is yours.
Okay, well, thank you for having me. Thank you for the invitation, and hello to all my colleagues. The situation in Slovenia is, in some respects, very similar to Romania or to Lithuania. I listened to the conference all day, and I gathered that we have similar problems here. But there is a distinction. In Slovenia, the development of construction law has been somewhat difficult, as Slovenia inherited most of its construction law related regulations from the previous legal system, from Yugoslavia, which had a pretty different legal system than the one that Slovenia has today. So that is why in 2003, the first attempt was made to codify uniform construction and spatial management legal system. And this was done with the introduction of two acts, the Building Construction Act and the Spatial Management Act. These two acts were seeking to enact basic fundamental framework for the investor to assess whether or not to initiate a real estate development project, the conditions for the construction and the process of obtaining a construction permit, and at the end, also the fit for use permit. But soon thereafter, more regulations were adopted, leading to the segmentation of the construction related regulations, which made it difficult for investors to assess whether or not the intended investment is going to go through. Most notably was the Spatial Planning Act in 2007 that defined in greater detail the process necessary for the preparation and adoption of legal instruments of the state and of individual municipalities that would be binding on all potential investors. These instruments are known as zoning plans, state and municipal, and
as it turned out, in practice, they were sometimes too specific or even internally contradictory, or even contradictory to, let's say, municipal plan was contravening the state zoning plan, and the administrative authorities did not know which zoning plan to take into account when deciding on whether or not to issue a construction permit. So the state acknowledged also the need for consistent development of land with public utilities such as electrical power grid, telecommunications network, water distribution system, etc., which was for the first time explicitly stated to be the obligation of the state and of individual municipalities in order to stimulate investors to invest in more real estate development projects. So in the years to follow, the legislation experienced further amendments and even more segmentation as these construction-related requirements were introduced in individual sector-based statutes. Instead of one code, we had several. We still have several, such as the Environment Protection Act, the Nature Preservation Act, the Cultural Heritage Protection Act, the Waters Act, the Forests Act, Agricultural Land Act, several different acts, and each of them contained different restrictions to construction. So the investor had to, of course, take this into account when making his decisions. So taking this into account, and accompanied also by the fact that most of these laws were provisional in nature, as well as the fact that that Slovenia had to implement certain directives of the European Union after acceding to it, there was a need for a more unified legal framework in order to enable investors to assess their investment more clearly, even in the initiation stage. So at that time, the authorities as well as the investors experienced many problems in projects, as due to the binding nature of European legal instruments, particularly in the field of environmental protection, more and more parallel administrative decisions had to be obtained in order to obtain a final construction permit. This meant that the investor had to potentially obtain a permit or administrative decision from the Cultural Heritage Protection Agency, and then he had to go to the Nature Preservation Agency, and all these procedures, of course, took their time, and it slowed down the process of obtaining the construction permit significantly. So as you can imagine, the obtainment of these consents represented separate separate administrative decisions, slow down the process to such an extent that investors were reluctant to engage in any investments before they had, let's say, 100% confirmation that the investment is going to go through, because that meant a lot of costs to cover in advance before even knowing whether or not the investment is going to go through. So another prominent complaint of the investors at that time was the fact that in 1995, the jurisdiction for issuing construction permits was transferred from municipalities to administrative units, which, according to investors, did not have the right staff or the staff qualified for land development, construction, engineering issues or questions, but instead focused solely on formalities, such as whether or not the right documentation was produced or not. And that was all they were checking, all they were reviewing, while they kind of ignored the content of this documentation, whether or not the construction documentation is in line with technical guidelines and with zoning plans, etc. So municipalities, on the other hand, at that time complained that their zoning plans were interpreted wrongly by administrative units, while the administrative units complained that the zoning plans were contradictory, as I said, and at times too complex or too detailed to even have any space to maneuver or to decide on anything. They just had to check the check boxes and then issue the construction permit or not. So the old legislation therefore tried to solve this problem by prescribing in as much detail as possible the conditions for the issue of a construction permit in order to make the decision of the administrative unit as automated and easy as possible, instead of educating, training the staff at administrative units in order to be better qualified to decide on these technically complex matters. So another big issue in Slovenia at that time were the so-called illegal constructions, as I heard also in Romania, meaning buildings that were constructed either without a construction permit or contrary to the conditions of the construction permit that was issued. And in principle, this building would have to be removed if they were not legalized or brought in line with the construction permit. However, this would represent a big logistical issue as well as a financial burden to the state that would have to cover all the costs of such removal in advance itself. So the state was not too fond of that idea. So due to all of the above, there was a need to legalize all constructions made in the past, or at least the majority of them, in order to mitigate this problem for the state. And that led to the adoption of two new legal acts in 2018, the New Construction Act and the New Spatial Management Act, that basically covered the same topics, but taking into account all the problems that we experienced since our independence. So at that time, Slovenia was also ranked very low by the World Bank in terms of competitiveness and friendliness to investors. So the legislator acknowledged this, let's say, bad result for Slovenia, and the intention of these two new legal instruments was to eliminate unnecessary administrative obstacles and expedite the real estate development process by eliminating the need for obtaining administrative decisions based on sectoral statutes such as the Cultural Heritage Act and so on. And in these cases, these procedures were in effect grouped together in order to only issue one construction act, and the other administrative decisions were reduced to only being opinions or consents that were not binding on the administrative units that actually decided on whether or not to issue a construction permit to the investor. So this change in 2018 also provided for the participation of more qualified personnel in the issue of construction permits, which meant that investors actually now have more persons or counterparts to speak to or to discuss issues of technical or expert nature that were previously impossible to discuss because the people employed at administrative units just did not have the right training or qualifications. So it has to be mentioned that these two acts do not interfere with relationship or do not regulate relationships between investors and contractors. This is done by the Code of Obligations and partially also by the Public Procurement Act in the public sector. There are standards for contracts that are being used. Also FIDIC, yellow, red, and blue book are being widely used as inspiration or foundation. However, the parties are free to derogate from them and to agree on anything that is not contrary to mandatory provisions of Slovenian Code of Obligations. However, those provisions are very scarce, and basically the contractor and the investor can agree to anything they want. So the 2018 legislation really helped and reduced the risk and cost of the investment and implemented a more digitalized procedure through the use of appropriate electronic information systems. But this cannot be compared to BIM, because BIM is an upgrade and a step above what we have now. However, it did simplify the procedure for the issue of a construction permit, and it also shortened it by shortening deadlines and eliminating certain bottlenecks in the procedure that caused the procedure to last longer than prescribed by law. As Alexandra said, there is a statutorily prescribed deadline within which the administrative unit has to issue or at least decide on the construction permit. However, these deadlines are in practice, in majority of cases, are not met, and the investor has to wait a couple of months. But it is the deadline is in principle 60 days, and in practice the time in which the investor can obtain a construction permit is shorter every year. Well, the 2018 legislation also introduced a so-called integrated procedure. This was a result of the European environmental protection legislation. It basically means that the investor is able to obtain two of the most important administrative decisions in order to start building the intended construction. But this only applies to big constructions that may have significant impact on the environment. So these acts are the construction permit and the environmental consent, which have to be issued in order to construct a building that might have significant impact on the environment, such as, let's say, landfills or cleaning stations, and so on. So the 2018 legislation furthermore aimed at strengthening cooperation between the state and the municipalities in order to enable a faster adoption of new and simpler zoning plans, and to clearly establish a proper hierarchy between them. Because, as I said, in the past, there were cases when administrative units just did not know which zoning plan to take into account, or to treat as preferential or being superior to another, which led to confusion also to investors, and the construction permit was sometimes impossible to obtain. So in order to avoid also any future illegal constructions, the 2018 legislation also implemented another change, which represented the elimination of the previously existing administrative burden, and that was the fact that the investor did not have to obtain another administrative decision, but now only has to notify the competent administrative unit that he will start building, and the construction process is going to start, let's say, within 8 days, and that is enough. And the administrative unit on that basis has the option, and the inspectorate, the construction inspectorate of the Republic of Slovenia has the option of supervising the construction and amending it beforehand, and not afterwards when the building is already constructed, because at that time it will once again represent a problem for the state, because now the state will have to do something with the illegal construction. So this all caused an increase in the last few years. At least our law firm has noticed it, in an increase in real estate development projects, and this was most probably also a consequence of the more friendly construction-related legislation, and more clear. But it must be noted that this legislation was not a complete success, because there was a provision that was very disputable from the start, and it referred to illegal constructions. As I said, the intention of the Construction Act was to eliminate, or at least mitigate, the potential for illegal constructions in the past and in the future. However, the new Construction Act introduced a provision that stated that all the use of illegal constructions, or performing commercial activity in illegal constructions, or performing any entries into the land registry, or entering into any legal transactions in relation to illegal constructions, were null and void, and well were forbidden. But all legal transactions concluded in spite of this prohibition were null and void, and that meant that potential investors and even banks were now scared of concluding legal transactions because they did not know whether or not they were null and void, because this provision was so broad and so unclear that different participants in the development process interpreted differently. Some of them interpreted as being enough that the investor or the owner of the land plot was not able to find the construction permit or the fit for use permit, and that meant the construction on the land plot that the investor or the owner was trying to sell was already illegal because he could not prove otherwise. While there were other legal theories that said, no, the provision, that was not the intention of the provision. The intention of the provision was for the inspector, the construction inspector, to issue an appropriate decision, and for this decision to be entered into the land registry. And once it is entered into the publicly accessible land registry, it would be known to all other persons that might want to buy this particular piece of land, real estate. So due to this unclarity, there was a need to amend this, at least this provision or certain provisions of this act. However, the legislator did one better and filed a new bill. This is a bill that is currently in the legislative process. It has the same name. It's the New Construction Act, but it basically seeks to eliminate this obstacle, because this obstacle slowed down the purchase and especially financing of real estate projects, especially by banks, significantly. And this caused and represented a real problem also for some of our clients, because they could not get loans because they could not establish mortgages on the land plot that they were trying to develop. And that's one of the main reasons for this new act being in the legislative process. And this act also would enable potential investors to examine the land registry, basically by limiting the scope of this provision, the disputed provision, only to land plots in relation to which appropriate decisions of the inspector were already issued and entered into the land registry. So the investor would basically just have to examine the land registry. If there was no note saying this land plot or a building on this land plot is illegal, that means that there is no restriction or limit to legal transactions that may be entered in relation to that land plot, and that would enable investors, buyers, and banks to finance the real estate development. This bill also proposes that municipalities play a greater role in the interpretation of their own zoning plans. As I said, in the past, administrative units had their own interpretation because they were not sufficiently staffed or the staff was unqualified. Some of these interpretations were contrary to the interpretations of municipalities who themselves adopted these acts, which caused a lot of problems because the investor did not know whose interpretation to follow, or which one was right and which one was wrong. So this act, as I said, strengthened the position of municipalities. It also envisaged the possibility of the investor starting the construction even immediately after the finality, but before all legal remedies that can be filed against the construction permit have been exhausted. We have a two-tier system in Slovenia, which basically means that the construction permit may be challenged before the administrative unit with an appeal. If that's unsuccessful, you can also file a lawsuit against the construction permit with the administrative court, and this procedure takes a long time, maybe a year or maybe even 2, depending on the workload. And in these 2 years, according to the current legislation, the investor was unable to start constructing his building, even though he might be of the opinion that there is no way the lawsuit is going to be successful, and the construction permit will continue to stand. So now, at the investor's own risk, the investor could start with the construction of the building even before that. However, this bill is still in the legislative phase, and it could be amended. So the final version could be very different, or it can also happen that it does not go through, which means that it's going to be rejected, and that would mean that the current Construction Act will continue to apply. As I said, these acts do not interfere with civil relationships between contractors and investors. This is done by the Code of Obligations and the Public Procurement Act. We have a lot of FIDIC-inspired provisions in these contracts, and these are widely used in all real estate development projects, but maybe more so in the public sector because the provisions of the Public Procurement Act are mandatory by nature. The biggest problems currently in Slovenia are probably the same as some of the colleagues mentioned before me. There is a shortage of materials, of building materials. There's a noticeable increase in prices, and maybe also the fact that the procedures, despite these acts intending to expedite them, are still being too slow. So we are experiencing some issues that are similar to other jurisdictions, but future regulative trends are going in the right direction. As I said, the current legislator did acknowledge the fact that we have some issues and is trying to eliminate potential obstacles of administrative nature. Is trying to achieve the simplification of zoning plans, mainly by focusing on the graphic part and not too much on the textual part, because the textual parts were the one that were, in the opinion of administrative units, too detailed and too complex. It also tries to reduce the burden placed on administrative authorities and to disperse this burden to other participants. And it also encourages digitalization in Slovenia. However, as I said, it's not exactly on the same level as BIM. We hope to see it in the future, but currently this is just apparently not possible or not on the table. So all in all, I think it's safe to say that the legislator has and continues to recognize the issues highlighted by all participants in the real estate development process, is currently again trying to eliminate the issues again in order to increase the competitiveness of our market again. It would be, in my opinion, recommendable to have all these construction-related regulations that are dispersed throughout the legislation to be unified in a single code, but as things stand, I don't think that's possible, because that would require a significant legislative effort on the part of the legislator, which is currently, well, I just don't see it.
Okay, Sasha, thank you for your very broad insights on Slovenia, and we're moving up to Poland, and we have two speakers from Poland. The first one is Dr. Jan Krolek, who is a counsel at Norton Rose Fulbright, Ditkovsky and Partners. He focuses in real estate planning, land development, and construction law, and he represents clients in court administrative proceedings relating to real estate and construction matters. He has authored publication on civil and administrative law concerning real estate issues, and as we already ran out of time and using our time break time, so yeah, I'm just asking you to skip to the time limit we agreed. You are muted, so unmute your microphone, and if you're sharing presentation, please do so.
Hello, everybody. Okay, I will share my presentation quickly. Wait a second. Where is it? sorry, I can't see it.
It's just a green bottom on the bottom of the screen. Yes,
Yeah, I think
already you're sharing your screen and opening your presentation, I see.
Yeah. Sorry for some technical issues. Okay, I hope you can see it right now. Is it fine?
No, we're not seeing it yet.
Now?
No, we're not seeing you sharing your folder, but not presentation. Try one more time.
I'll try to share once again. Now?
Yes, now we see your presentation, Ian, and yeah, you are free to go. Yes.
Okay, so I'm gonna be quick now. I'm a counsel in Norton Rose Fulbright. It's an international law firm based in London, and I'm working in the Warsaw office in the real estate and construction team. I deal both with transactions and administrative law, with all the proceedings connected with obtaining construction permits, zoning decisions, and other necessary documents. I work mainly currently with the industrial and warehouse sector, which is booming in Poland, but I've also worked a lot with residential sector, and also worked a lot for renewables, which is also quite dynamically developing in Poland, both PV and wind farms. Just by way of introduction, I'm not going to say anything or a lot about civil law. We have construction contract regulated in our civil code. The regulation is not very long. There are some specific issues about Polish law in that matter. For example, we have protection of subcontractors. The investor is jointly and severally liable with the contractor for the payment to subcontractors. And also the contractor may demand a payment guarantee, which is, I think, not in every jurisdiction. Besides, it's similar to, I think, all other jurisdictions. We are also using FIDIC contracts, but they are not very common. They are most common in maybe public procurement sector, and on the market which is not using these mandatory rules, they are not commonly used. Okay, and let me just switch to administrative law. We have different legislation acts for different stages of construction process: environmental assessment, special planning, and construction. And some issues, like in Slovenia, that are also regulated in other acts. So specific regulation for agricultural land protection, specific regulation for public roads, for example, to get a traffic connection or exit to a public road. Specific regulations for monument protection, there is a separate act, and sometimes specific permits are needed in order to complete development on such properties. We have water law, we have forest law. So if we're dealing with forest land, or if we're making some water facilities, for example, some kind of somehow connected with rivers or with waters flowing or with lowering retention, then water law also comes in action. So sometimes we can have a lot of permits to be obtained before commencement of construction works. The main legal acts are, however, Construction Law of 1994 and Spatial Planning and Development Act from 2003. And based on that, two major decisions are issued, which I will show later on the diagram. What is interesting and specific about our jurisdiction is that the procedures were very long and time-consuming, and they required a lot of different decisions to be issued, especially for the public purpose investments like motorways, roads, strategic power lines, and other strategic objects. And our legislator invented something which is called a special act. This is some kind of special, very fast procedure in which many stages of construction process are merged in one decision. So instead of issuing independent decisions on plot division, expropriation, location, construction permit, and cutting down the trees, for example, it's all merged in one decision sometimes. And because of that, Poland is able to build, for example, the motorways much faster than it used to be in the past. And these special acts are dedicated to public roads, railways, strategic power lines. There was a special act dedicated for the LNG terminal, Euro 2012 investments, or recently Central Communication Port. It will be a big airport in the middle of Poland, currently in a planning phases. And besides the construction law, special planning law, which are part of administrative law, we have also some general rules mentioned in other acts, like, for example, the wind farm sector is governed by so-called Distance Act, in which there are specific rules for location and construction of wind farms onshore. Okay, this is a simplified scheme of construction process in Poland. First, the brown color is the planning, and the orange is environmental part. Environmental part is only required when the development may have environmental impact. So there is an environmental decision issued by the local commune. It can be preceded with the environmental report, but not necessarily. It depends on the scope of the development. And the zoning can be in two, let's say, legal acts. In general, we should have local special development plans adopted for every commune in Poland. This is done by the level of the commune, and this is a local legislation. So, but unfortunately, 30% of the area of Poland is covered by local special development plans, which consists of graphical part and the written part, like in Slovenia. And if the local special development plan is not in place, then a zoning decision has to be issued. And this is, I think, the most controversial and most difficult part of the construction process, because it gives parameters and functions for the future construction design. And sometimes the zoning decisions are quite controversial, because in the issuance of the decision, the process of issuance of the decision is quite long-lasting. There is an urban planner employed by the commune who prepares an urban analysis, and based on that analysis, he gives parameters for the future construction design. So sometimes it brings really strange results and developments which are quite controversial locally. Before we go with the construction permit, sometimes we need to obtain additional arrangements. Unfortunately, we don't have a electronic system in which we can get approvals and arrangements of the construction design by different authorities. So the architects need to go and get stamps on the construction designs, gather all the necessary agreements. And before construction permit, you also get some additional decisions which are required by specific regulations. So it can be monument preservation, water law, agricultural land protection, public roads, etc. Sometimes in case of public purpose developments, also expropriation. And then we have a stage of construction permit, and construction permit is not always required. There are some minor developments in case of which only notification on commencement of construction works is required. So you notify the relevant authority, and the authority has 21 days to file an opposition against the development. And also in case of very petty developments, even notification is not required. So in our construction law, we have a catalog of developments which don't require construction permit. It is very long, very specific, casuistic. It has a lot of numbers. It's been changed many times, so I never know if there's something smaller to be developed. I never know, and I need to check whether it's on the list or not. Then the next stage is the occupancy permit, or sometimes called use permit as well, or a notification on completion of development. It all depends on the scope of the development. More relevant developments require occupancy permit, and some smaller developments only notification. And what is interesting, all the decisions are dependable on one another. So if one of the decisions gets invalidated in extraordinary procedure, then somebody else may invalidate also all the subsequent decisions, which is difficult for the lawyers, especially in the due diligence process when we find some irregularities. it may occur that the whole construction may be illegal at the end of the day, the construction permit. The authorities noticed that problem, and now construction permit and occupancy permit can be invalidated in extraordinary procedure only within first 5 years from issuance. And after 5 years, the investor is safe, so there is no risk for invalidation. I think in Romania, you don't have this time limitation for this kind of invalidation. And yeah, there is for sure a demand for codification. The main legal acts are subject to many amendments. I just checked, and there were like 130 versions of construction law since 1994. So sometimes there were small changes, like few words only in one article, but sometimes there were big amendments like this year or last year. New ideas are constantly being implemented to the existing laws. So for example, they figure out some landscape protection rules, and this was like included in the Special Planning and Development Act. Also, revitalization regulations were added. And sometimes adding these additional new ideas makes the act difficult to read because it has strange numbers, letters, and it's all quite confusing sometimes. Also, we have a lot of casuistic exceptions in laws, as I mentioned. For example, which developments require or do not require a construction permit. The catalog is quite long and it's been constantly changing. For sure, there is a high demand for complex codification, and there was an attempt to codify the construction code. There was a special commission working on the construction code in Poland. Even a draft was prepared. So if you would like, I can find and circulate the document. The works were carried out under the Ministry of Infrastructure. However, after some time in 2017 or 18, the project was abandoned because it was very difficult and very controversial. It would really have a large impact on local laws and also on how the construction business works. So instead of that, the authorities decided that they will rather try to amend as much as possible the existing laws and try to again make some exceptional laws for those sectors which are like treated especially with some kind of privileges. So for example, they introduced some specific rules for the residential investments, trying to boost this sector in Poland. Frequent issues are related to zoning planning. The main issue is lack of zoning plans. As I said, only 30% of the country has zoning plans, and only 18% are the zoning plans adopted by the recent law from 2003. So some of them are pretty old, and they are not adjusted to the present situation. So if the plan is not in place, zoning decision has to be issued, which really sometimes causes a lot of controversies. The poor spatial planning also results in lack of real properties for new developments, especially within the largest cities. And there is lack of clear and transparent regulation of cooperation between the investor and the local authorities in the stage of zoning. So for example, when there is an investor interested in financing, preparing the zoning plan, we have no clear regulation how to conclude this agreement, whether this agreement is legal or not. While in some other jurisdictions, these kind of agreements are sometimes regulated. So for example, an investor has to build some public purpose investment for the commune in order to realize his own development and so on. In Poland, we have a little bit small part of this kind of regulation in the revitalization part, but it's not general, and it is controversial. It is very common in Poland for the investor to finance the zoning plan, like for example for wind farms somewhere in the rural areas. And still concluding these agreements is not regulated anywhere. And this is, of course, the risk of corruption or some non-transparency of local legislation. And when it comes to issues related to construction process, it is again what my colleagues have discussed before, long-lasting procedures. In Poland, we have 65 days for issuance of construction permit. This is the statutory period. In many cities, this period is kept. After it is not kept, the authority has to pay 500 zloty per each day of delay, a penalty to the higher authority. This is something around 110 euro per each day. And for the zoning decisions, we don't have such a penalty, but we have a statutory deadline, which is 30 days and 60 days in more complicated cases, but usually this is not kept. So I think the weakest point in our administrative construction regulation right now is the zoning. It is the most controversial and the weakest point of the whole system. When it comes to regulative trends, in latest, let's say, changes. So we have a simplification of procedures for certain types of developments, like putting notification instead of construction permit. For example, semi-detached or single-family house can be built only under notification, not under the construction permit, which is favorable to some of individual investors. Also, we have introduced revitalization schemes and landscape protection on the level of local legislation. So landscape protection is more detailed than zoning plans because it regulates, for example, the advertisements, how they are placed, in which places. So it's far more detailed than the zoning plans, which cover only main function and main parameters of the future developments. And this landscape protection, it's not popular. It's an option for the local communes to adopt such rules. In some big cities, such rules are local rules are being adopted right now. The third point is the specific dedicated laws for important and strategic developments, what I already mentioned at the beginning. But on one hand, it makes them it creates the opportunity to complete them much faster than based on the general rules. However, there is a risk. Always there is a risk that there will be some kind of public purpose investment, which is not mentioned in the local zoning documents. So because this specific procedures can be used and the decisions may be issued also contrary to the local zoning plans, there is sometimes a risk that something on the governmental level is being planned, for example, a strategic railway or power line or a gas pipe, and it is not included in the local zoning plans. So there is a threat that such an investment may suddenly appear. Then the fourth point is the new approach to the residential developments. There is a special dedicated legislation enabling the developers to develop land which is not designated clearly for residential purposes, also for agricultural land, also on agricultural land, for example, provided that certain requirements, very detailed, are being fulfilled, like, for example, distance from the bus stop, distance to the school, to the kindergarten, and capacity of the school and local kindergarten, and so on. This is quite a new regulation, and it's not commonly used by the developers. They prefer rather to stick to the general rules, so the zoning plan and zoning decision instead of running this specific procedure. And our legislator also recently limited the possibility of questioning the construction permit and use permit, as I mentioned. So after 5 years, it cannot be questioned. And trends for future, for sure, the integration of all regulations in one code is like, I think, a dream of many real estate lawyers. Our authorities abandoned this way, but I believe that maybe in future we will come back to this idea, because it's definitely worth regulating in one document. Second trend is limitation of number of necessary consents. So most likely some of the decisions will be merged in one, or the demand for the construction permit will be reduced and replaced with notification. Certainly, we can see some kind of focus on sustainability and landscape protection, and these were the main rules to be applied in the construction and urbanism code. These were like the underlying rules of this code. So maybe we will see these rules more envisaged in the coming legislation in future. And also, I think what we need is regulating the agreements between the local communities and the investors, in particular in case of zoning, because this is like a gray field, not regulated, non-transparent, and I think there is a demand of regulation. Thank you very much.
Thank you, Jan, for a very broad presentation of Poland, and it was really interesting to see what kind of regulations do you have in the neighborhood country. And the next presenter from Poland, also Dr. Maciej Kielbowski, who is an attorney at law in the firm Wardiński & Partners, who focuses on administrative and core administrative matters and proceedings. And Maciej, I would ask you to put your presentation in 10 minutes if possible, because we are totally out of time, and the panelist of other sections is already waiting. So what is for you?
Of course, Evaldas, thank you very much, and thank you to the previous speakers at this panel. I will now try to share the presentation. I hope that it will work.
You turned off your camera, Maciej.
Okay, sorry.
You turned off your camera, and we still don't see a presentation.
Okay, sorry. We'll try to do it again.
Maciej, yes, you're trying to share screen now. We see your presentation. We don't see you, but still we see your presentation.
We'll try to. Okay. So, but you hear me well.
Yeah, we hear you well.
Okay. Thank you. So I will try to do it this way because I see that it does not work in the other. So thank you for having me today, and I have the maybe more difficult task that my previous speaker, because it's always a bit more difficult to speak about one jurisdiction after hearing someone other to has already spoken many important issues about it. But I will try to have it short and hope it will be also interesting from your perspective. So as you already know, the construction law in Poland is regulated by quite many legal acts. However, two of them are the most important, the Construction Law and the Zoning and Spacing Act. We do have a lot of other regulations in that regard, as you've already learned from the previous speaker. I will also probably speak a little more about the administrative law issues regarding construction than the civil ones. However, as I also manage quite many disputes regarding construction itself, I believe that the nature of the construction contract and issues connected with it are also quite important to maybe highlight just a little to get know something more about the construction business and construction sector in Poland. As it was also already spoken, we have a lot of legislation which is dedicated to specific sectors of construction, like motorways, like railways, airports, maybe a nuclear power plant in some years, as it is being now quite largely discussed in media and also in other manners. So there are quite many legal acts regulating it, and this is, let's say, a custom of Polish legislature. As I checked from 1960s, we do have the separate act on constructions and separate act on zoning. About zoning, it was already quite much said, but this is the first stage of every investment. So to either obtain an individual zoning decision and to let's say try to design the investment in the way the investor wishes to it, or to fit the investment into the local zoning plan if it's enacted for the area which is dedicated to the investment. Those issues are quite complex and unfortunately take much time. Enacting local zoning plan, which will cover a larger area than a plot or maybe a couple of plots in the neighborhood. For one investment, it takes around 12 to 18 months at least, probably. And getting an individual decision on zoning is also never a swift proceedings, unfortunately. And there are, of course, some issues which needs to be taken into consideration when applying for a individual zoning decision. For example, the neighborhood in which the investment is to take place. So to, let's say, make it an example, that it is very unlikely that within a let's say residential area or of houses or of one or two tiers, an investor could be granted with a zoning permit to make a residential building of, for example, for I don't know, 6 or 7 stories. So this is something also important. When we speak about the construction law in Poland, as already you've learned, there was also an attempt to have this legislation put in one act, the Construction and Urbanistic Code, and it was a huge draft legislation, over 600 articles, and it included mainly 3 issues connected with construction. So the construction law, so the construction, so the process of obtaining building permit or applying for another consent for minor investments to have them in place. The Zoning and Spacing Act was also to be included in the code, And also another important, however, most important from the public authorities view, act was to be implemented there. So the act on real estate acquiring and possible selling. This is a legal act which concerns real estate owned by the public authorities. So it was also to be included in this draft legislation. However, for now the project was abandoned. As I checked some last minor legislative work were done in it in 2018, and for now there is nothing new to be known about having it proceed further. So, to speak maybe about some issues which I think from the perspective of construction business, from the perspective of clients with who I'm working, and from the business as a whole, I think that there are some issues which are more frequently provided in last months or maybe a year or two that they were previously. The issue of somehow incoherence of the regulations of our construction law is one of them. As my previous speaker told you, we have a catalog of minor investments in construction law which does not require a building permit. However, this catalog is changing. I don't know, maybe twice or twice a year, probably. So you need to check it again. And also there is another issue which I think is of concern here, that when you are working on a larger investment, for example, of infrastructural type, but you do not have the special act for such an investment, there are also issues which are being somehow invented during the construction process. For example, I believe that in, I don't know, probably three last months, I opined for one client 2 or 3 issues resulting in the construction process of a large infrastructural investment, and issues which were steps of it. For example, I don't know, providing a waste conveyor for this construction site. Also were unclear whether such a minor investment requires another building permit, or maybe it is covered by the building permit already received. So those are the ambiguities of current construction law, which also take place. When it comes to zoning, it was already said, but I believe that it must be also emphasized that there is a important issue, problem really for investors, which would like to invest in parts of the for example, town which were factories earlier, and now the investor would like to transform it for residential purposes. from my perspective and from my experience, the local authorities are very cautious and very and do not wish to change anything in drastically in such zonings, and there are no clear proceedings how to let's say mediate zoning or how to negotiate zoning with the public authorities. So you need, for example, to go to administrative court and try to somehow quash the local zoning plan if you wish to build something else for the plot you bought, and you cannot receive the decision which on zoning which you would like to have. And from my perspective,
thank you, Matti. Thank you for your insights. And yeah, we believe that these zoning and planning issues, they are very sensitive in all jurisdictions. And as we saw, it's the same in Romania, the same I see in Poland. And the bill the Polish have, which I was surprised that you have special regulations for some industries, for example, road construction, or you have a LNG terminal, then you enact special law on that, and the process goes smoothly. But what about other market participants? And they don't have that smooth process. Is it the same in Romania, Lavina? Is it a possibility to have a smooth process? Because in Lithuania, we have, for example, also enacted a new law from this year. It came into force for huge mega projects. If a mega investor comes, then he has a green line. What about the processes in Romania?
In terms of expropriation, we have a special law for infrastructure projects, which allows a smooth process in the expropriation process, meaning that you cannot really block it. But in terms of construction, not really. There are special regulations in the law 50, but it's not smoother the process. And what I think is very interesting is, I think something that both Jan and Maciej from Poland have pointed out, that they have this unique approval. Romanian legislation is also aiming to get this unique approval for not to go to so many authorities, but we don't have it yet. So I think it's very interesting, the public infrastructure that you need behind it in order to get one approval instead of getting endorsement from so many authorities that are involved. So no, in Romania, we have some facilities for infrastructure projects, like I mentioned, in the expropriation field, but not necessarily in the construction.
And Sasha, you mentioned that you had reforms. I was trying to write down everything, but then it was the last ones in 2018. But I understood correctly that you are trying to make some kind of reform, then you go with small amendments, and then again a new reform and new reform. When those reforms are over, are you again on some reform?
Good question. Nobody knows. We've changed our legislation so frequently that it's impossible to predict, but it does coincide with the change of power, of political power in Slovenia. And currently we have a new government, new ministers, and they're the ones who draft legislative bills. So of course, when a new political party rises to power, it has new ideas. So maybe it's also a consequence of that. It's not just that we like to change laws so much.
Yeah, and Alexandra was mentioning the same, that political stability is very important if you want to have a stability in regulations. But how you feel, Alexandra, in Romania? Will the things change sooner or later? And will you have clear regulations on construction? What you are?
We hope so. We hope so. Unfortunately, the expectations for this year were not met yet. So we are hoping that the changes in the political field shall not affect anymore so much the legislation, because no matter who is the political party taking the government in a certain position, the developers have the same interest: building, observing the laws. But in order to have a smoother construction process, you need to give predictability and stability under the legislation. If you change the legislation each year, a Romanian investor, it's not updated, but a foreign investor, it's blown away. Yes, we hope for this, and we hope that the amendments addressed by the lawyers, by the investors to the politicians shall be considered, because we are participating in meetings, in conferences, and we are addressing our concerns regarding each piece of legislation and requirements. But
we'll see. Time will show.
Hope to have good news sooner than later.
Okay, Maciej, how do you think will Poland will come back to the codification of the construction regulations?
This is a good question, Evaldas, because I believe that this was not the first attempt to codify the construction law. However, it was let's say, the broadest attempt to do it. The act was written down, really, I know it contained around 250 pages, something like that. So it was a huge legal act. So a lot of energy and a lot of ideas were put there in this draft legislation, and I believe that there were, of course, some issues which were very controversial. For example, part of issues regarding disputes between neighbors were to be regulated not by, let's say, administrative proceedings, but only by the common courts. So there was an idea that building residential houses, small houses, were to be without any or maybe without much administrative supervision, and the issues connected therewith are to be disputed in courts. So, okay, there was some controversies, but the idea of having one construction code, I believe that it is something that it may come back. For sure, the pandemics ruined it somehow, and during the pandemics, the construction law was also amended, but in a very narrow way, mostly concerning permit for use of newly erected buildings. But I think that this is something which could be back in line in a couple of months, or maybe not a couple of months, maybe a couple of years.
And Jan, if we go back to the market, how do you feel all administrative institutions, are they in line? Because in Lithuania we have a boom of real estate, and I feel it's all in all the countries, and what was mentioned by Sasha, the lack of materials, increase of the prices, and so on. So it's booming everywhere. Are the institutions, municipal institutions, are prepared for that? And what about administrative capacities? We had these discussions in previous sections. What about Poland? Because you were quite well known, like you can issue the construction permit quite quick, to compare to other countries. So what's the situation in Poland?
I think it hasn't changed a lot. During the pandemic, there was a small slowdown. Some administrative deadlines were suspended by force of law. So in the biggest lockdown last year, there was a problem because the statutory deadlines did not end, and people couldn't get the final decisions, for example, for commencement of construction works or some other decisions. Right now it's getting better. However, we still experience difficulties in staff availability because it is not fully digitalized. Investors and architects often have to appear authorities, and there are difficulties due to the pandemic regime. Sometimes you cannot meet in person with the clerk, and therefore it's not so fast as it used to be. But still, I think the speed in issuance of construction permit is quite good. I have a comparison with Czech Republic because I work for a Czech real estate fund, and they say that Poland is much faster. The construction procedures are much quicker in Poland than in Czech and Slovakia. I have no comparison to other countries because I don't have clients from like Romania or Lithuania, but yeah, I can compare only with Czech.
How do you think what helped to Poland to engage such a good reputation that construction permits are issued quickly? Though you indicated a lot of problems, but well, you have that good reputation. What helps?
I think what helps is the proper approach of the authorities. And many big cities have, for example, investors' desk, and they have like a person dedicated to help the biggest investors or the strategic investors. For example, I don't know, developing office parks in Krakow or in Warsaw. So there are like dedicated persons helping to make some procedures faster, giving contacts, helping to reach out proper persons within the authorities, and I think this may be helpful at some stages and in some locations.
Okay, thank you, Jan, for sharing your insights. Okay, everyone of you, your final couple of sentences just to wrap up our section. So, Sasha, what are your final insights?
Nothing special. Come to Slovenia. It's an investor-friendly environment.
Lavina.
I'm just looking forward to Poland because I hope that we'll get that unique approval as well in Romania. So indeed, as you mentioned, we look up to Poland and we feel that is the queen of this region. So I'm looking forward to having a unique approval instead of 15 endorsements from various authorities.
I understand what you're talking about. Alexandra.
I'm jealous for Poland for that fines applies to the authorities if they are not issuing the building permit in due time. So I'm waiting for such a legal provision also in our laws. Maybe this is an incentive.
Okay, Maciej.
So very kind words of you. However, from our day-to-day perspective, maybe it isn't so green. But I think that it is nice to hear that some of problems we maybe thought are our own in Poland are not only our own. Especially when it comes to zoning, as both ladies said, and also Sasha, I believe that the zoning issues are also still something to be improved in Poland, even if the building permits are going swifter than in Romania. So,
and Jan, your final.
Yeah, I agree with Maciej that zoning is the weakest point of our regulation, but I can see that we have the same and similar problems in our region. So it was very inspiring discussion right now, and really I didn't have an idea that we may be so similar in some points, having some different countries, different jurisdictions, but the same problems. So thank you very much.
Okay, thank you all the panelists of this section, and we are going out to a short break of 7 minutes out of 30 minutes. We have a break only for 7 minutes, and we'll go to other jurisdiction, and we'll continue with regulations in Northwest EU countries. So thank you, all of you.
Thank you.
See you.
Thank you.
Bye-bye.
Hello, everybody. We returned from short break after the last session. We had construction regulations in Central and Eastern EU jurisdictions, and well, it was really interesting to hear what instruments Poland has to accessorize everything and to have smooth construction permit issue processes. But now we are moving to Northwest EU jurisdictions, and we have speakers from Germany, Ireland, and Austria. And I want to start from Professor Winfried Grieger. And Winfried Grieger is a professor at Mykolas University of Applied Sciences and Lithuania University in Lüneburg. He has a long-standing legal work experience and mainly specializes in construction and architectural law. Winfried is an author of various publications and co-author of several books regarding construction law. And Winfried, I see you are muted, so you can unmute your microphone. And if you are sharing with us some presentations, so you are free to do it now. You are still muted.
Yeah, now you can hear me.
Yeah, now okay. We can hear you perfectly.
Wonderful. Thank you very much for your words. Let me in the beginning start with a typical situation in Germany. Our construction law is, some of you, I'm absolutely sure know it, is divided into two sections. We have the public construction law and the civil construction law. On the one hand, one see, okay, there's an official or the public construction law, which is referable to get the permission for the building. But this is not the only task of the public construction law. It also influences the private part, the performance part of the contract. I will show it you in the next moments. Point it out, public construction law regards a permission. To get the right to erect the building project, and you have absolutely follow this permission. If you don't follow it, everything will be stopped, and with the result that the authorities can all what you have built up destruct. That seems at least impossible, but it is absolutely usual auch in Germany and can happen very often because many people don't regard the conditions of such permission. They are regulated in the public construction law, we call it Baugesetzbuch, but they are also regulated in construction decrees and especially in energetic and environmental rules. All these regulations have to be regarded to get the permission, and not only to get the permission, but only with regard to the performance for the building up. For example, the German official, I always say so, the official public construction law regulates the building itself, for example, the roofs, for example, the windows, the side, and especially the building components. They have to have the CE sign. I hope you know it all. And it also says very exactly which energetic and environmental situation you have to look at. And with regard to those components, the permission is a very important rule with regard to the private construction law. The private construction law is regulated in the German civil law. We call it Bürgerliches Gesetzbuch. It exists since 1st January 1900. You see, it's very old, and it is a very long tradition. And at least these paras are only, it's the situation now, 931 to 951. These are the regulations of private construction law in the BGB. These regulations say exactly how the contract will come into existence and which you have to look at, but many things are not regulated in the BGB, in these paras. They at least depend on the contract you have concluded and on the decisions of the BGH and the EUGH, the European Court. If you have that in mind, we have to look which regulations of the BGB are absolutely strong and can't be avoided, and which regulations can be changed. With regard to the regulations, let me say it this way, the stipulations of coming into existence of the contract and of the finalization, that means the acceptance of the building, these regulations are very strong and can't be changed. In between, you will now find, it's the new version of the private construction law, and you now find regulations with regard of changing the building and of changing the time of the building. There we will see regulations how the time of the construction period will be lengthened or not, and how it will be to have paid by the client. Furthermore, you will find regulations with regard to the finalization of the contract. These are also very strong and can't be changed by contract, even with regard to the reasons. And you only find reasons for the client. In German law, the contractor has no right to finalize the contract, only in special, seldom situations. You only find in the 631 folgende BGB regulations for the termination by the client. As I said, at this moment, or at this point, also the permission rules are integrated in the contract by law, so that we also cannot exclude it. They are an essential part of the fulfilling of the contract. Especially besides these regulations, you know that Germany has many technical specifications. They have also to be regarded at, and you will find them in the DIN regulations, I'm sure you know them, also in the EN, European DIN-Vorschriften, the technical Vorschriften of the European of Europe. These two regulations of technical situation are also by law contents of the contract and have to be fulfilled at the moment of the acceptance of the building. But that's not all. The third technical, let me say it this way, the third technical moment is the definition of the BGH, our highest court, civil court, and which you will also find by the decisions of the European Court. It says that the contractor has to regard the best available techniques. They are not defined in law, absolutely not. You will find them nowhere. It's the decisive point to see where is it or what is it, is to regard the science and the practice. It's not decisive that these best available techniques come into existence by regulation. The practice is decisive. That means for companies, engineers, that they have all the time to show, to look in the world, not only in Germany, in the world, which are the best available techniques to realize this building, which we have in contract. That at least has the consequence that it's not easy for companies outside Germany to engage here in constructions. They overtake a high risk to realize it because they don't know what all is part of their fulfillment. And very often I realize that many companies don't see especially the best available techniques, which are very often the decisive point. And many companies have, because of this part, of this finest part of the German construction law, big difficulties to take place and to take part in the German economy. Let me say at this point, I would say the following result with regard to our construction law. It is right, you have always to see two parts, the public construction law and the private one. And of course, we know, okay, public construction law is only decisive for the permission of the building. But that's not all. The conditions of this permission are also influence the contract, the construction contract. They are a heavy part of it, and they are regarded as available techniques, as techniques regulation, which are substantial part for the fulfillment of the contract and for the acceptance of the building itself. And these are points which are decisive not only for the construction company, but also for the engineers. And you know that especially technical regulations, technical experiences are changing every moment. And no one knows exactly what is now the exactly to practice the technique to realize a building. And in German law, the point or the moment which is decisive for that is regulated in the BGB. It's the time of the acceptance of the building. At this time, the building has not only to regard the conditions of the contract, it has also to regard the best technical, the best available techniques at the moment of this point of acceptance, not the point of concluding the contract. That at least also has a consequence that many companies have difficulties to calculate such a contract, especially if it has a duration of more than 2 or 3 years. And that also is very difficult to formulate it in the contract, that there is a balance between client and contractor. Very often there is no balance, especially with regard to that point. That's at least the decisive points I wanted to point out in this small discussion with regard to German law, because any other steps would be very special. If I explain now with you special wishes of the clients, that means additional work, how you have to calculate it, how you have to react. Of course, there are conditions, forcible, very important forcible conditions to to get your claim through. In Germany, let me say this at last, the contractors very often forget to make a sign, hey, client, here is possibly a claim for me. I show it you now, but the explanation for it will come later. It has to be explained at the latest is the point of the acceptance of the contract and the final invoice. If the contractor doesn't do it, doesn't give us a reaction with regard to his possible claims, it may be possible that he loses his claims and has no chance. That means not regarding this form has a consequence to have no claim against the client. Elsewhere, it is really it has really a good background. So that's what I have wanted to point out for you here, to show you the situation at all, and to show you, or to give you a let me say it this way, to give you an impression how complicated at least the German construction law is. I have to thank you very much.
Thank you very much, Winfried. Thank you very much for your presentation. And it just showed me how different the EU countries are. And when you talked, we had a discussion with Scandinavian jurisdictions and Dutch guy, and I felt that I came back to that discussion, because before our this panel we had Eastern EU border countries, and approach to construction law is totally different.
It is.
What I feel, what those North European, Western European countries are talking, they are talking about contracting. They are talking about how contractors should implement their contract and do everything, and to observe the regulations and so on, and even observe the practice of the Supreme Court. Meanwhile, when we are in Eastern part, we talk what public institutions should issue, what kind of regulations, what to regulate more and more and more and more. But listen to other speakers of our section, and I'm inviting Jamie McGee, who is a senior associate in the construction group at McCann Fitzgerald law firm. His recent work involves a mix of dispute and transactional matters, including PPPs, development finance, oil and gas, offshore facilities decommissioning, social housing, pharma, data centers, and waste to energy. Jamie lectures at Trinity College, Diploma in Construction Law, the Law Society's Diploma in Construction Law, UCDS postgraduate health and safety courses, and continues to provide assistance to construction law master's students at King's College London. So Jamie, thank you for joining us. And yeah, I see you already unmuted your microphone, and the stage is yours.
Thank you, Evaldas, and hello everybody from Dublin. I had some slides, Evaldas. I'm not sure if we're going to put them up for the purposes of this talk.
If you have them, just
sure, I have them here. I think it's useful because actually, how I want to talk about the Irish building regulations regime is to actually take a look through history and maybe a couple of photographs, as I think that would be quite instructive as to how we've ended up where we are. So I'm just going to try and share. I don't know if you can see that.
Yeah, we can see you're sharing your screen, and you put the slide.
Perfect.
Show. No, just put the slideshow. You didn't push the button because we see the whole.
Oh, it says I am sharing.
Yeah, you're sharing, and now slideshow. Yeah, now everything is perfect.
Perfect, great. Okay, well, thank you. So I suppose I'm going to begin the journey on rather tragically on Valentine's Day in 1981. And the picture you see before you there is of a nightclub, the aftermath of a fire in a nightclub. And in effect, what happened, there was apparently an electrical fault that led to a fire that spread through the ceiling space. There was a suspended ceiling between the dance hall and the roof, and there was no compartmentalization of the ceiling space. The fire spread, became extremely hot, melted the ceiling. It came down upon, it was 800 people in the dance hall at the time. The electricity was not stopped working as a result of the fire. Panic ensued. People tried to run to the exits. When they ran to the exits, they realized that the exits had been chained shut so that other people outside couldn't sneak into the disco for free. Some people ran to what they thought was the main entrance, which transpired to be the gents' toilets. And in the aftermath, 48 people died. 214 people were injured, many seriously, and a number of them suffered life-threatening injuries. And we have had inquiries ongoing in Ireland to this day since 1981. And that is known as the Stardust tragedy, which took place in 1981. So moving to what the regulatory background was at the time, prior to 1990, Ireland had what we called bylaws. And these were made by the local authorities. And there were some 31 local authorities in Ireland. There was no common standards between the local authorities. So you could have one particular building standard, say in Cork or in Kerry, and you could have a very different standard in Dublin. Also at the time, the local authorities had a function of inspecting and supervising. So they were involved in the building process and ultimately on signing off at certain stages. So two things primarily influenced changes to the regulatory regime. The first was the Stardust tragedy that I mentioned there, and a political need to codify and provide minimum standards for building in Ireland. And the second came about because of a shift in law in England and Wales. And I should say, unlike colleagues presenting here, we are a common law jurisdiction. So a lot of our law is case-made law, but we do also have statutes as well where the law is codified. But in England, two cases, Annes and Merton, and there was another one called Dutton and Bognor Regis, effectively placed liability on local authorities where there were building defects. And Ireland looked at that and wanted to remove liability for local authorities so that they wouldn't be liable in damages if there were problems with buildings. So that, combined with the Stardust tragedy, led to what is our modern legislation. And the primary piece of legislation is the Building Control Act 1990. And the vast majority of all building codes, building control, building regulations are made under the Building Control Act 1990. It centralized everything under one piece of legislation, and it empowered the minister to make building regulations, which are effectively the standards by which buildings must be completed to, and also empowered the minister to make building control regulations, which is how compliance with building regulations is implemented in Ireland. And some of the relevant features of the Building Control Acts were it applies to owners, builders, and designers. So it's a self-certification regime. It removed the local authority and the inspectors from the process and pushed all of those obligations onto those building, designing, and procuring the building design of buildings. Some of the other features are there's an authority for the inspectors to enter into a site or a building. If there's a problem with health and safety, they can do emergency works. They can restrict people's access to the building. They can issue enforcement notices. So if you have a problem with the building, which is non-compliant with building regulations, the Building Control Authority can issue an enforcement notice anytime up to 5 years after the building is completed. But once that 5 years has passed, no enforcement notice can issue. And then in terms of what the actual teeth of the legislation is, we have penalties for what we call minor breaches of up to €5,000 per offence and 6 months imprisonment, or for significant breaches, €50,000 per offence and up to 2 years imprisonment. I should say that the Act also provides for personal liability for people, so it's not just companies who can be prosecuted. If a director, manager, or secretary of a company, through its act or connivance, has consented or authorized to a breach of building regulations, they can be held personally liable. So the Building Control Act is the primary piece of legislation. And under that, then we have the building regulations. And these are in effect our building code. It's what building operations must do and what standards building must achieve when they are finished. And that is all set out in the second schedule to our building regulations, which put forward those minimum standards. It is made up of 12 parts. Some of them are related to structure, fire safety, sound ventilation, etc. And how it looks is it's a schedule to the back of the building regulations. It's fairly short in terms of what actually must be done, but then the minister is empowered to issue what's known as technical guidance documentation. And that technical guidance documentation effectively provides more detail around how the standards in the building regulations can be achieved. You are not completely bound by what's in the technical guidance documents. It is saying you must achieve this, and here is a way you might do that. But equally, if you can achieve it by another means, that is acceptable as well. But if you are being prosecuted for a breach of building regulations, it will be in the first instance a defense to show that you have complied with the technical guidance documentation. And that's just a photograph of what the relevant part of the building regulations in relation to materials and workmanship looks like. And there's the corresponding, just the front cover of the booklet issued by the minister, which is the technical guidance documentation for complying with materials and workmanship. So I mentioned Building Control Acts, which are the primary piece of legislation, the building regulations, which is the code made under it, and then also made under the Building Control Act are the building control regulations. So how is compliance with building regulations enforced? And I want to look at that in two periods of time. One is post-1992, pre-1994, and the regime under the building control regulations was if you were starting a construction project, you needed to issue what was known as a commencement notice, and that needed to be lodged with the local authority. And your commencement notice stated that you intended to start works within 28 days of the notice, and it also would have attached some documentation, so plans, drawings, specifications, etc. But by the standards today, that documentation was fairly thin compared to what is now required. Another feature of the building control regulations was you required a fire safety certificate, which before construction started, you provided plans and drawings to the local authority. They looked at it and said, yes, if you build in accordance with what you say you're going to do, the building will be compliant with fire safety requirements and equally with disability access requirements. However, no certification was required on completion for anybody. So all the commencement notice and the fire safety certificates I've mentioned are all done at commencement stage. There is actually nothing required during construction or prior to completion. A practice developed, not a legal requirement, but a practice developed in Ireland that when a building was finished, an architect or an engineer would issue an opinion on compliance, which could say something like, I've looked at the building and it seems to comply with building regulations. So it could be a very light type of opinion, but it wasn't a statutory requirement. So then we had two very infamous incidences in Ireland. The picture on the left is an apartment block known as Priory Hall. It was built in 2007 during what was called the Irish Celtic Tiger, when Ireland's economy was booming and there was a property bubble which ultimately crashed. But the building on your left, you see, was built during that. And when it was inspected in 2011, the inspector discovered there was effectively no fire partitioning in the building, and it was hugely short of the standards that were required. And the High Court ordered that 187 apartments were evacuated. So, and 187 people had bought apartments, paid for them, had taken out mortgages, and all of a sudden they found themselves on the street as a result of this. Priory Hall has now been rebuilt, but there was national outrage that, first of all, this was allowed to happen, and secondly, that when it did happen, there was very little recourse to anybody who had been involved in the construction, because the developer had become insolvent after the thing was built. And one of the things reported in the paper was, how can we have a system which doesn't require anybody to inspect or certify a building before it is accepted as being complete? And the second picture is another development that we had a similar problem. I should say the government ended up paying out 15 million euro from state funds to remedy defects in the Priory Hall building. So we introduced then the Building Control Amendment Regulations 2013, and this was an enhanced statutory scheme which required at the beginning the appointee of somebody to certify the building, somebody to certify the design, a number of undertakings to be provided, more diligence to be done on the documentation that was provided with the commencement notice, and then an inspection framework to be implemented during construction to give comfort that people were actually looking at what was going on and signing off at each point. And then the key bit of the 2014 regulations is what we call a certificate of compliance on completion. And that is signed by the assigned certifier on completion. And in round terms, it says the building complies with building regulations and I am certifying that it does. And until that certificate is provided to the local authority, and then the local authority register it on a central registration system, the building cannot be open, used or occupied. So in any sort of commercial transaction, whether there's a bank or anybody who's being advised, they will not accept a building until it's been entered on the register. So this forces that requirement for greater vigilance, more inspection, and more diligence to be done during the construction period. There are other legislation that is relevant in Ireland. It doesn't all fall under the building regulations and the building control regulations. We have health and safety regulations which specify buildings must be built so that they can be operated and maintained without risk to health and safety of people. We have separate health and safety construction regulations which provide for information that needs to be gathered up on the building. So if you are selling your building, if you own a block of apartments, you're selling them, you must have a bundle of information that tells you how to operate and maintain the building and shows all the drawings, etc. So the next purchaser can come in and operate the building free from health and safety. So having been through all of that, you would think everything is better, isn't it? We should be all fine at this point. Well, that's November 15, 2021. They are people out on the streets in Dublin protesting. We have currently an estimated 5,000 houses in the northwest of Ireland where mica, or I think it's related to pyrite, has infected 5,000 houses, has made many of them uninhabitable. Some of them are soon to be uninhabitable. And again, people are saying this has been a failure of the building control regime, that the inspection regime isn't correct, the certification regime isn't correct, and that as long as it is left up to developers and those appointed by developers to implement the certification regime, that this thing is always bound to happen. And ultimately, where people are insolvent and can't meet their liabilities consequent upon breaches of building regulations, it either falls to the homeowner or the person who's bought it, or perhaps cynically, where there is enough people who are affected, suddenly there's political pressure and it falls to the government to step in and pay for it. So thank you. That's just a very, very brief overview of the Irish building control and building regulation regime.
Thank you, Jamie, for your presentation. And we in Lithuania, we have almost the same discussions all the time, because we say, well, administrative burden is so huge. We have to ease some things and maybe introduce new easements in regulating the construction processes. And some of them are done. For example, the buildings are categorized by special buildings, non-special, and just simple easy buildings. And for those non-special buildings, you can finish construction by certification of the developer that I implemented the technical design and all normative rules. So what I hear, it didn't work in Ireland, but we don't have this rule for special buildings, which are like if the building where at the one moment 100 people can gather, and buildings of 5 and more floors and so on. So it was really nice to hear your presentation and learn that, yes, the developers, the contractors, they always want easements, but not necessarily these easements should be given to the market, because self-regulation is important, but it doesn't work all the time. So Jamie, thanks for your presentation. And the next speaker is Klaus Pfeiffer. He's a partner at law firm Weber & Co. And his specialization is real estate transaction, real estate development, and construction law. And he has published various publications on real estate and construction law in Austria. And Klaus, we are ready to hear your insights on Austrian regulations. And I see you already unmuted your phone, and I hear some scratches. So, hi, do you hear?
Hi, good afternoon. So, hi from Austria. So, hopefully you can hear me today. We had some technical problems yesterday. I have prepared some PowerPoint presentations, so just wait a moment and you should see it in a second.
Yes, we see it. Yes, we see it. Yeah, perfect.
Here we go. So we've heard about Germany, which seems to be quite a complicated country, and Ireland, where people are on the streets. So speaking about Austria, I think we're quite simple now. Nobody's on the street and everybody's quite happy, except for me, obviously. So I'm pointing out several problems we've got in Austria. Starting with Austria. So Austria, in a way, is quite a complicated country. We've got the federal state and the regions. So basically, it's 9 regions in Austria. And the competencies are distributed among the federal state and the 9 regions. So, for example, if we are talking about construction laws, zoning laws, or the protection of nature, you have to look into regional laws. So, for example, if you want to build a building in Vienna, Vienna is not just the capital city, but also region, you have to comply with the Vienna Construction Code. There is no federal construction code in Austria, even though we are quite a small country with just 9 million people. There are 9 different construction codes. There are also 9 different zoning laws. So, for example, the zoning in Vienna is very different to zoning in Vorarlberg, which is the region in the west. So bear this in mind. On the other hand, you've got federal matters. So, for example, in the beginning for Germany, we heard about the BGB. We have a similar code, the civil code, which was set in force in 1811. And the civil law is federal. So there is just one civil law and not regional laws. And of course, we've got monument protection, which again is federal, and public procurement usually is federal, but it depends on the matter at hand. So this is actual law. Apart from that, we also have standards. We call them Austrian standards or ÖNorm, which is comparable to Germany with DIN and Switzerland C, and I would assume every country has certain norms. These standards can be technical, and I would say 99.9% are technical standards, but there is one standard which is actually on contracts, which is the standard B2110, which gives guidelines on how to make a turnkey agreement. So it's just guidelines, it's not mandatory, but it's a standard in Austria, and most construction companies usually opt in. It's not mandatory, but you can opt in. It's also possible to make a partial opting in. So you can say, I want to have clause 12, for example, but not the other ones. It's completely voluntary. We have some additional technical norms, which are OIB, European standards, of course, and international standards. It's basically the same as in every country, so I will skip it. So, for example, if we go to a complex construction work, you would usually have certain questions on zoning, rezoning, and urban development. This is regional. So if you want, for example, to make an urban development agreement with the community, That's regional law, so 9 different jurisdictions. Construction permit, again, regional. Operation permit, which is the permit for the site from a trade law perspective, again, it's federal. Water, federal, and monument protection, federal. And then we've got the turnkey agreements and standards. So this makes it quite tricky because there's one problem in Austria. We don't have concentrated proceedings. So there's not just one application, and the authority deals with construction law, zoning, water, and monument protection, for example, but it's various and different authorities dealing with these issues. So if you apply for, or if you want to construct a building, you have to obtain various different decrees, various different decisions. This makes it more complicated and sometimes also time consuming, because I would assume, as in your countries as well, neighbors have certain rights and they can delay proceedings. So about construction, what we can say about construction in all of Austria, we've got a 3-tier system. So basically, the most important construction works need a construction permit. It's actually an official document. And then we have got a construction notification. So these are less important construction works where the authorities think it's not necessary to actually apply for a construction permit, but it's just sufficient to notify the authorities about the construction works. And if the authorities don't respond within usually 4 weeks, you can just carry out your construction works. And certain measures don't require anything at all. We have been having liberalization, and also an issue which we just had with the other 2 countries. It's something we call notification of practical completion. So basically, by the end of the day, when the construction works are finished, you don't need to obtain another permit or authorization, but a civil engineer issues an expert opinion on the completion, and in essence says these construction works are in compliance with the construction permits. So it's liberalization, and as far as liability is concerned, it's the civil engineer's liability, of course. So if the civil engineer says something wrong, he or she is liable, and they need to carry out liability insurance. Well, most recent changes we had so far in this year, temporary buildings because of COVID-19, energy efficiency, parking spaces, e-mobility. I would assume you had the same issues in your countries. We are dealing with them and are probably dealing with them in the next 10 years, especially energy efficiency, e-mobility. So what are the legal challenges we have? I just pick one, I would say, which is affordable living. We've had a population increase of about 40,000 people every year in Austria. So of course, 40,000 new people means we need to have a lot of new apartments, buildings, and construction works. And as in every country, prices skyrocketed. So every region, because we're talking about construction law here, tried to implement certain laws on how to make construction affordable again. Especially Vienna is quite attractive. They made a cap on the acquisition cost. So a developer is not allowed to pay more than a certain euro amount for the construction plot, so the plot of land, in order to make living more affordable. It's what we call in the German-speaking countries the Vienna model. So basically, Vienna is quite famous for having affordable living, lower prices compared to, say, Munich, Hamburg, or Berlin, or Zurich. And also the city of Vienna offers a lot of living. So basically the city of Vienna is one of the most important landlords in Austria, and they own a lot of real estate, which keeps prices lower. One issue you always have to deal with is UNESCO and, of course, monument protection. So it's more difficult to actually obtain the construction permits because you need to be in line with these laws. And just to give you an idea, well, we are complicated when it comes to leases. In Austria, you've got the Tenancy Act, and it limits a rent for all the buildings. All the buildings for us are buildings with a construction permit dated before 1953. So basically, most of the inner cities you can see in Austria. And in Vienna, for example, rent is capped, the net rent is capped with €5.84 per square meter per month. And now you can see that Vienna actually is quite affordable. But it makes it quite difficult for a developer to actually develop something and then rent out for €5.84 or a similar amount, because of course you need to have a return, and as you all know, the prices skyrocketed. So that's quite tricky and keeps us busy. Other trends, we have urban development agreements. It started in the region of Salzburg, and now we have them in every city. In Vienna, especially for the skyscrapers or high-rise buildings. So usually they include penalties, contribution to construction, to infrastructure works, and similar clauses. One of the current topics is to get a standard on it, because basically every community could ask you to agree on this specific urban development agreement. There's no common standard for urban development agreements in Austria. We have seen a lot of digitalization the last years, especially in the city of Vienna and Graz. So, for example, the applications can be electronically, and so you just send the applications to the authorities and will actually get access to all the documents in an electronic form. So that's quite good. Other challenges, well, I think you all know them, and COVID-19, of course, kept us busy as well. Maybe one point, real estate prices increased by 10% in 2020 and 2021. So if you were lucky enough to have real estate, say in 2019, more or less your real estate is now worth 20% more. So it's good for landowners, but not so good for tenants. So that's quite difficult for certain people, and that's the reason why affordable living in construction laws is a topic. Personal evaluation, and that's why I said I'm not always happy. We need to be more federal. I think it's wrong to have all the regions in place. We should have more unification. For example, as Germany shows, there should be one construction code, more unification, because it makes it a lot easier. We have certain standards, but they're only voluntary, so we should work on this. Proceedings should be more concentrated, because it's quite costly and expensive to obtain certain permits and various permits. And of course, we need to have more digital proceedings and fewer neighbors, because I've seen many proceedings where neighbors delay the proceedings, which is a massive damage for investors and developers. So altogether, thank you very much. And hopefully you have some questions on Austria, and I made it more attractive for you to actually invest in Austria and do something in Austria. So yeah, thank you very much.
Okay, Klaus, thank you. But it was really interesting to hear that there are 9 different, I should say, like regulations in Austria. It's considerably a small country, and you don't have unified code for the whole country. It's really strange. So why is it so? How historically did it develop such a situation?
Well, our constitution is from 1919, and before we used to be a very large country, and we were always a federal country. Suddenly we were reduced to Austria, meaning German-speaking Austria, but we kept the federal system, like in Switzerland, for example. But our federal system is very regional. So in construction, it's regional, and once you install the system, it's quite difficult to modify, because you need the consent of all the 9 regions. And in German, we always call them the regional emperors. So they decide what they want to be and what they want to have, and you need their approval. And once somebody has rights, they never, waive or renounce the rights.
Winfried, how Germans agree and various lands agree on that, national regulations and changes on those national regulations? It's much more bigger country than Austria, and still you have all these national regulations.
maybe we are more opinionated. We have more opinions. So sorry.
What's your insight on that?
But let me say something very interesting. We have to differentiate between public construction law and civil construction law. The civil construction law is unit for the whole German country. The public construction law differentiates not with regard to the Baugesetzbuch, but sometimes some, let me say, country laws have certain influence. That may be, but the official construction law is, besides some specialties of the area, absolutely also unit. So that at least the Bundesverwaltungsgericht and the BGH decides about both parts of law for the whole country. The only difference is maybe with regard to, let me say, building in Bayern, in the country in Bayern, a house, maybe may have some differences with regard to building a house in Düsseldorf. It depends on the region itself, but the situation of the buildings, of the agriculture, and so on. That is also regulated in the Baugesetzbuch, so that at least we have unit regulations, so that everyone from elsewhere can see, okay, I have to do that and then that to get the permission. And on the other hand, I have to do that and that to perform the permission. And to repeat it with regard to the other discussions, I have to point out that the permission which you get by the authorities is also proved, of course, at the end. But the authorities have no liability. If they say it's okay, that doesn't mean with regard to the liability of the contractor, nothing. If it may be the result, and that's the newest development of European law, if it comes to the result that the permission was wrong because of a mistake of the authority has no liability. But the engineer and the contractor, he's liable. And that you should bear in mind. No permission gives you a relief from your liability, nothing. You overtake the full liability, even if it says it's okay. That's European law, not only German law. And I have to point it out for all of you.
Yeah, in Lithuania, we have a quite strict court practice that the institutions are liable for construction permits, actually. Because if, we have a very strict and long procedure to receive construction permit, and institutions checked everything in that design documentation, they are liable that the construction permit is legal. But it concerns only legality from the perspective of legal regulation, zoning and planning, and so on. But if the construction is built and it collapses somehow, then everyone looks why it happened. And then liability goes to contractor usually or designer, who were responsible to exact implementation and design documentation or while performing the construction works, because they were those subjects who were responsible. So I feel that, well, we have to make a clear distinction, as you're saying, public law and private law. But public institutions in Lithuania, they are also liable because they are participating in that construction permit issue process. And they participating in acceptance to use process because they approve acceptance to use act, which is signed by various institutions, checked by construction inspectorate, and signed also by the contractor and designer. And then court evaluates every time. So whose responsibility is that? Are they subsidiary liable or not? In whose fault some damage happened?
May I respond? Yeah. In my opinion, you shouldn't forget that there's a big change in the European law. And that has also changes our German law. Because at least if you look at certain regulation, European regulations about acting of authorities, the responsibility is reduced nearly to zero. And if there is a damage, let me say it this way, and the usual answer of the contractor is, oh, I have regarded the permission, it's not my fault, you know. And it may be that's not the fault of the contractor, but it may be that some products, building products, are not correct because it's not allowed to use them now there. But the science has realized it after the realization of that building. Who is responsible then? The authority is not responsible. They said, okay, we shouldn't have given the permission, but that's all. The responsibility remains by the contractor because at the moment of the permission or acceptance, it's the acceptance by the client, he has to declare and he has concludently explain, it's concludent explanation, that this regards all technical conditions. And if in that small time the conditions have changed and would have at the end the result that the permission is not guilty, is not in no, okay, sorry. And no, the permission has to take back, it doesn't change the responsibility of the contractor. You can say, okay, the authority also have not only they have the duty, not only the right to prove everything, but they only sit at the desk.
Okay, but Winfried, so tell me, what for we have that construction permit procedure, acceptance to use procedure, if authorities are not liable for anything, and at the final stage, the designer and contractor is liable. So maybe we should just give up with all of those official public procedures.
So let me say it this way, the task of the authority is at least to look at the people who are doing their work, they do it in the right way. But it's not the Leviathan who has to do everything for the people. He says, okay, do it so, but you have the responsible for that. The decision of the authority is at least to have a similar development in the whole of the country. That's at least the task of the authority. But what is happening in the individual case, it's individual responsibility, not authority responsibility. That's at least the thinking behind it. And that's not my thinking, at least. It's at least the thinking of the European community. And if you look at it, you see the change in their jurisdiction. You see it very clearly.
Okay, can I ask you something? We were always talking about construction permits, and there is some sort of notification of practical completion. So let's say the building was erected in or built in 1980, everything was fine, everything was good. So since, as Jamie has shown us, since 1980, a lot has happened. So technical requirements, of course, are different. The question is the authority entitled to say, dear homeowner, dear owner, since 1980, a lot has changed. Technical standards are different, usually they are higher. You have to do something with your building. So basically you have to improve, you have to refurbish. And the second question, if they have such a right, do they have an obligation to say so? Because this again is the question on liability by the authorities. So for example, if they see a half-destroyed building somewhere, do they have to act? And if they don't, will they be liable? In Germany, for example, or Ireland.
You think of the R, the R situation, for example. Oh, excuse me. Can you hear me? Okay. You have the situation at the R. You have seen the pictures, and this water has destroyed the streets and really distinguished many people. I'm very sorry about that. Who is responsible for it? It is a good question. This is quite different from building in building houses. building factories. It's now building of infrastructure. It's quite different to look at, not the same. If you look at that, and then I have to say something more. If you look at that, of course, the responsibility stays with the authorities. And here is also something in work which says, has the authority who regards all the water situation, hasn't it could foreseen this situation? As it had, for example, in some regions, has had to react much earlier than it has now, than it is doing now, much earlier, because some situation could have been foreseen. And that is now discussed and will be discussed not only in parliaments, but also in courts. With regard to changing of regulations in the published construction law, after permission, that means there you have your house. And look at your windows, everything is okay, the roof is okay, and now it changes. After 10 years, the public regulations change with regard which windows you have to install in your building. This has no consequence for the owner of the elder building, because, okay, it's a new situation, but his situation now he has is sheltered by the law, because at former times it was correct. He has built it in the correct way, and he has not the obligation to change it. It has changed in that way that now we have an energetic regulation. Of course, we all the time we are seeing for regulations. That's typical German. We have now an energetic regulation which says now, okay, but if it is 10 years ago, and it's look at CO2, we all know the discussion, climate discussion. Now they say, okay, after 10 years, you have to look at it, and then you have the obligation to change all the windows if you try to change your building more than 10%. It's that's also a typical situation of public German construction law. It has nothing to do with private construction law, okay? And therefore, it's very difficult for someone who doesn't know the German law, it's very difficult to change. What is that? What is that? Which consequences has changing of official construction law and private construction law? And if you see only the official construction law with regard to shoving owner to build ownerships, it's a different situation as to build a factory, to build a house, and in between, from start till the end of the construction, we have a change. And this period is the responsibility of the contractor.
Which is funny because it's the other way around in Austria. So if the technical standards rise between the date of the construction permit and completion, it usually has no effect. You have to comply with the building permit and not the technical standards at the time of completion. However, if there are changes in the technical requirements, technical standards after completion, the authorities usually can't issue a new decree saying you have to improve. That's what they can't do, except there are certain risks. Then they are obliged to do so. If they don't do this, they will be liable. And the last point, as a homeowner, as an owner, if I don't comply with the current technical standards, there is civil liability and criminal liability. So for example, if I own a house with 20 apartments, I lease them out, rent them out, and somebody falls and there is an injury. Me as an owner, I can be liable under civil law, so damages, and criminal law because of hurting somebody by not making improvements.
I have to interrupt at this moment. We have the same, but we have to differentiate between fire regulations, or let me say it this way, public regulations to shelter health and life. these points all the time have to be regarded by the owner. And if he doesn't do it, of course, we have all consequences you have just declared. That's the same in Germany. What I was referring at are the normal building, windows, roof, and so on, not health and life, okay? And then, of course, we have the same regulations as you have.
Yeah, Klaus, when you were explaining it, I had nothing to add because the same we have in Lithuania, exactly the same situation. Jamie, what are your insights on this discussion?
Yeah, sure. So just to go on the last point, we are similar again. That the applicable code, the applicable building regulations, are those that are in force at the date of the commencement notice, which is the date that the construction is going to start. If something changes during construction, that new standard does not retrospectively apply. So I think Klaus would be very similar, and Winfried, again, similar to you. There is certain things in the public health and the fire safety sphere which might need to be done to make something safe, but generally speaking, your windows, your structure, your standards, etc., are what applied at the time of construction. What I had spoken about really was, and you made an interesting distinction, Winfried, was I had spoken about implementing the permission. That's what the building regulations are. The actual permissions itself is effectively planning permission, is what we call it in Ireland. And there's an application saying, I want to build something. There's a drawing. It's a rough outline, really. It's the skeleton of what you might do rather than the flesh on the bones. And the authority will say, yes, we give you planning permission to do that. But there is no responsibility for the local authority if in implementing that planning permission, whatever you do gives rise to damage, injury, loss, non-compliance, etc. Be that on the head of the developer or the contractor or whoever it is. And just to pick up two interesting points. In the building regulations we have, the standard is for materials is that they are fit for the purpose for which they were intended in the conditions they are used. So Winfried, when you mentioned there about some sort of foreseeability, so if a technical standard changed, or actually if a product suddenly was found not to be appropriate to be used in a certain circumstance, in Ireland, assuming that's the contractor's responsibility, which 99 times out of 100 it would be, the contractor is on the hook there because the contractor has not put materials into a building or a construction that are fit for the purpose for which they are intended. There is no foreseeability element to that. And in then moving slightly to say a homeowner and the standards that might be applied, say, versus, so the standards are common between public and private. There isn't that distinction. There are certain things that the public local authorities will do, or the state will do, that is different than what a private homeowner will do. But whether you're the owner of a motorway, which might be the public authority, or whether you're the owner of an apartment block, the types of law that apply are the same, in that, you know, there is, there's contract, so those with whom you have a contract with, but to members of tort, and that responds to foreseeability. So if somebody is injured, say for a defective footpath, then in order to prove liability, you need to show a few things, one of which is that it was reasonably foreseeable that if my footpath is defective, somebody might get injured. And there's another number of criteria, but it sounds like we are similar, save Evaldas, we don't have that, and we're similar to Germany. The local authorities are not liable for signing off, certification, permissions, implementation of the permission, and it is very much a case of, and it's a conscious decision the government has taken here in Ireland, which is to wash their hands of liability and say that is on the parties implementing the building, and that's the developer, not the public purse.
Jamie, your example, there was this, well, the constructor built the building, and I understand the constructor was insolvent, or at least there was no more money. Would it be possible for me as an apartment owner to actually claim the monies from the constructor and not just, you know, my direct contracting party, which means the vendor? Is it possible to have a direct claim because the insolvent company, it doesn't really help you.
I'm going to give you a slightly long answer, and hopefully it might answer questions to that. There is a real problem in Ireland for a purchaser of a house or an apartment. We have the Latin principle caveat emptor, which is buyer beware. So if you are buying even a new house, what you will get is a contract for sale that has a building agreement in it. In the building agreement, there are a number of exclusions of liability, and your agreement is only with the party who's provided you with the building agreement. You have no contractual relationship with anybody else. What has developed here is there is a structural guarantee, not to be confused with decennial insurance or latent defects insurance that you see possibly in your countries and on the continent, which I understand is a very good product. The structural guarantee in Ireland is quite a limited one. It's only for certain defects. For example, it might not respond to defective design. It might not respond to certain defective materials used in the construction process. And there are a number of limitations as to how you might bring that. So if you're the apartment owner, your building is defective, you look to sue your contractor, but they're only a company worth €2, so that's not worth doing. You look at your latent or your structural defects policy, and that says defective design isn't covered, so you've got nowhere to go then. You then might look at the certificates produced where somebody says, yes, this is good. If that is the case, you may have a claim in tort, but it's a difficult claim to bring about. There are a number of things that you have to prove, and it's not ideal. So like the pictures I was showing you, those homeowners were left with no redress. It was, I won't say fortunate because it's the wrong term to use in such circumstances, but had that have been you as an individual house owner, that would be your tough luck. It was the fact that there was so many people affected by this that they were able to bring to bear political pressure, that suddenly it was a discussion at government level, and Ireland, perhaps maybe being the way it is, the government stepped in and said, right, we will put a redress scheme in there to help those individuals out, and the government then stepped in. But that was only because the people affected had reached a critical mass that were able to actually bring that pressure.
One more point. When we come to the quality assurance, is there a mandatory civil liability or any other insurance, kind of insurance, which may give more security for homeowners and later owners of other buildings? Is there any mandatory, obligatory insurance requirement under the law?
In Ireland, the only mandatory insurance is this that touches upon the construction process is that your car that you drive is insured. All risk policy, public liability insurance, employers liability insurance, professional indemnity insurance, which is what your civil engineers would have in your countries, and other specialists like non-negligence insurance, things like that. They are all creatures of contract. I want you to have this because it protects me, not mandated by legislation.
Okay, so legislator is not regulating these issues in Ireland. What about Austria and Germany?
Well, we are not hippies, so of course we have a lot of laws in place, especially professional liability. There needs to be liability in place, and for civil engineers, for example, at least it needs to be 400,000 euros for civil engineer companies. It's a lot more, it's about 2 million, and so forth. So for every trade, for every person, certain amounts apply. And just one point which you mentioned, Jamie, for example, with new projects in Austria, so you buy the apartment whilst it is still under construction, you can ask for assignment of the damage claim of the seller towards the constructor if something happens with the seller. So for example, the selling company is insolvent, of course you won't get any money from the insolvent company, so you can ask the company to actually assign this claim to you as a purchaser, and then you have a direct contract claim to the contractor, which you initially had no contract with. So that's quite good, because otherwise we would have the problem of having no direct claim and certain people would lose money by the end of the day.
In Germany, In many things, we are absolutely in the same organization as Austria. We have the same insurances, the liability insurances of the technicians, of the companies, of course. But we have this point you have pointed out, but we have it for companies who build inclusive planning, living houses. Then you have a security of 7%, and which you can hold till 5 years after finishing. But that's all. Nothing else is possible. And then you have, if you want to get more, you have to go to Loor, England, and you can assure much more. But that's not typical, let me say very clearly.
I should just point out, just in case anybody thinks it's like the Wild West here in Ireland.
No.
Every construction project that I've been involved with in the last 20 years, there will be professional, and all those insurances that we have spoken about will be in place. For example, if you're an architect or an engineer or a building surveyor, your professional body that you're accredited to requires you to have that insurance. So it's not mandated by legislation, but it is mandated by virtue of your membership to your professional organization. And equally, on any project where there is bank funding or any level of a sophisticated purchaser, you won't get away with not having all of the required insurance.
To point out, I know that absolutely, it's absolutely clear. But that was only the answer with regard to insurances, and many things can't be insured. That's the thing. That's at least a result of economy. You can't assure everything.
Yeah, Winfried, therefore, despite the insurances which are obligatory by law, what we see the new trend in the construction industry market is that the developers, the owners, they insure the whole project, and all participants, designers, contractors, technical supervisors, they try to insure the whole project and receive the normal insurance policy.
But it's only a liability insurance. I have to point it out.
And
it's not a defect insurance.
Civil liability and plus property insurance.
Yeah, then if at least you can get a warranty assurance, you can get it, the whole insurance. It has also the warranty period in it. But to say it once more, it's a liability insurance. It's not an insurance with regard of the situation. There must be a liability situation, a liable situation. Only in that case, you can go to the insurance, not in other cases. That one should always bear in mind. If there is no one reliable, no insurance will pay.
Okay, and final thoughts and final remarks. So, Jamie.
Oh, it's very interesting. I have to say, Winfried, best available techniques is a very interesting concept.
Yeah, is it?
From an Irish perspective, yes, it would be how would you prove it, and also and I'm sure this is the same in all of your countries. There is a tension between the developer wants the gold taps, the contractor wants to go and install the cheap taps down the road because it wants to make money, and I just find the best available. It's the minimum. You're either in breach or you're not in breach in Ireland of your building contract. So the best available techniques is an interesting concept. And equally, Klaus, we had the issue about the multiple the local authorities and all their building bylaws and it being disparate and not centralized and whatever. I'm not saying that it's any better or it's any worse. But it's just it's interesting that still subsists, which I imagine can make having to provide a piece of advice quite tricky in terms of having to root through all the various different codes and what may or may not apply in different places. So that is very interesting.
Thank you, Jamie. Winfried, your final thoughts.
My final is, it was a very great pleasure for me to discuss with you all, and my aim is at least to get regulations which we can realize in every country, just with regard to the construction industry. They need it absolutely. That can't be only in one country, it must be internationally. organized. I'm sure about that, just with regard to the future. And that's my biggest wish I have with regard to all.
I totally agree with you, Winfried. I think for every one of us, it would be much easier if we have the same regulations all over EU. Klaus, your final word.
Well, it was great pressure for me as well. I would pick, I found it really interesting, especially in Germany, that which standard applies when you build a building, and that you might have that a lot is mandatory and you might have to comply with a higher standard than initially assumed. So that's quite interesting. I wouldn't say it's correct or wrong, it's just a different approach. And I found it really interesting because by the end of the day, it's always the question about liability then and which standard you have to comply with. So really, really interesting. And thank you very much.
Thank you all the panelists for the Western Europe countries. And we are leaving for a 15 minutes time break, and then we'll go to South jurisdictions. Thank you all once again. And
thank you. Bye. Thank you very much. Best greetings to all.
Thank you all. Bye-bye.
Bye.
Welcome everyone who came back from the last coffee break, and we have the final 5th section where we'll discuss the construction regulations across South EU jurisdictions. And there we're gonna have presenters from Portugal, 2 presenters from Italy, Greece, and Spain. And I want to introduce Andrea Mozinho, who is a partner of public law practice at law firm PLMG, and she specializes in urban and rural planning, and she has extensive experience in public and administrative law, urban development, environmental law, tourism, which is very actually in Portugal, real estate and construction. Andrea works closely with the real estate and construction, international projects, corporate M&A, private equity, and privatization teams to provide legal support in complex transactions in Portugal involving planning and licensing issues. So, Andrea, welcome. If you're sharing some presentations, so you are welcome to do that. And I still see that you are muted, so you can unmute your microphone already. And yeah, we see you are sharing your screen.
I think now I'm sharing my presentation.
Your presentation.
Yes.
Perfectly.
Perfect. Good afternoon, all. First, I would like to thank today for the invitation addressed to PLNJ to participate in this discussion, which is personally dear to me. And back in 2003, when I started my training period, still far from imagining that I would become a planning lawyer, the Law School of Coimbra, one of the most prestigious Portuguese law schools, promoted a cycle of conferences with the same theme, an urban planning code for Portugal. This shows that this issue has been debated for several years and by various governments, but so far with no outcome. I don't know why we have not given more steps towards the harmonization of the different laws, but one thing I'm sure, the reality is far ahead of the applicable legislation, and this may lead to the birth of a code condemned to an early updating, which is something that everyone would like to avoid. But let's see how things stand in Portugal. I'll start to do a brief general framework on how things work in my country. Construction laws go hand in hand with use planning legislation and urban planning legislation, and thus we find several layers of rules. At the first, more macro level, we find the planning rules. This indicates the strategic options for occupation and use of the territory. Planning rules establish the use and occupation of the land, but also the rules for the construction thereof. The planning instruments determine for every piece of land with great detail the fundamental purpose of land, the activities that may be carried thereon, the types of constructions allowed, and the urbanistic parameters such as height, number of floors, footprint areas, construction areas, and even construction materials and others. On a second level, we find the urbanistic licensing rules, that is to say, the rules applicable to land transformation operations, urban infrastructure works, and construction works. As a general rule, the execution of the works on a certain property depends on the prior obtaining of a construction licensing issued by the municipality or a prior communication of the works. The choice between these two procedures depends on the type of works and the location of the works. The licensing process is more complex and lengthier than the prior communication. The licensing construction procedure is intended to confirm whether the applicable planning instruments as well as the applicable technical construction rules are complied with by the projected construction. If the constructions do not comply with the rules, for example, for not being allowed in the area, a construction license will not be issued. The prior communication procedure is a procedure where the developer submits the project, architectural engineering projects, a set of documents signed by the technical teams, liability declarations, confirming that everything is in accordance with the applicable law, pay the fees and start the construction. This is what is established in the law. In real life is quite different because the municipalities sometimes issue some decisions on this. Finally, we have the construction rules. The construction rules establish the technical requirements that the construction works must abide, aiming to ensure safety, healthy, efficiency of the buildings. So in Portugal, we don't have a single code, but several laws, and several laws that have been frequently amended. We have a general regulation on urban construction dated 1951, amended 15 times, and we have multiple provisions regarding technical requirements: fire safety, electricity, energy efficiency, urban rehabilitation, etc., etc., etc. We have a land law that is related with planning and urban laws. The land law established the fundamental principles and rules of the public policies for the land use, planning, and zoning regulations. We have, on the planning perspective, a legal framework of the zoning plans, which establishes the rules of preparation and approval of the planning instruments, such as national, sectoral, special programs and regional programs, prepared by the Portuguese state, and which lay down fundamental objectives and general rules to be abided by the municipalities when preparing and approving their planning instruments. Which planning instruments? Master zoning plans, urban zoning plans, detailed zoning plans prepared by the municipalities, and each municipality has a master plan and can have multiple urbanization plans and detailed plans. And sometimes the detailed plan change the master plan, the urbanization plan change the master plan, a big mess. But in each municipality, we have different planning rules. From the urban planning perspective, we have a legal framework for urban planning and building, which establishes the rules applicable to the land transformation operations, construction operations, etc. This is the law where we find the procedure that each developer must comply with in order to obtain the title to start the construction and to use the construction, not only to start, but to execute and to use at the end of the day. So we still have environmental laws, culture and heritage laws, agricultural laws, etc., that have rules related with planning, urban, and sometimes even with construction requirements. So the existence of several laws competing amongst themselves bring us daily several issues. Just to mention some of the frequent issues that we are faced, and sometimes we, and even the authorities, do not have proper response. I could say we have a never-ending list of applicable laws and regulations, a never-ending list of required documents, information to submit to the public bodies. We have the lack of stability in the application of the general urban planning rules to their frequent amendments. We used to change the applicable procedures before those procedures are duly implemented. We have outdated municipal planning rules, notably master plans in force since the 90s, with no correspondence at all with the reality, and that can jeopardize new projects and investments. We have contradictory and incompatible solutions. For instance, we have one entity that needs to issue two opinions within different deadlines on the same project, but regarding different areas. And we have also different deadlines for similar projects. As one can easily understand, this is a situation that leads to inefficiencies and costs that could be avoided if we would have a single law or code. But I also know that the single law or code is not a solution without issues or problems, and we can't anticipate some of the challenges that we will for sure be faced. But before speaking about the challenges, let me be positive and list some of the benefits of this solution. Benefits. I think we could have a consolidated and stable legislative framework, transparency and legal certainty for economic operators. We could update existing outdated solutions. I always remember one rule that is in the diploma dated 1951 that requires that each resi unit must have a bathtub and a bidet. In Portugal, no one uses the bidet, and why not a shower and not a bathtub? And we also could review the contradictory compatible solutions that we have. Now the challenges. I think we have to deal with the European Union law, the challenge of the more and more technical regulations. It is very bureaucratic to have the transposition of that legislation, and sometimes different countries require different solutions, mainly when we are talking about technical solutions, constructive technical solutions. We have the current decentralization and the concentration of powers in Portugal. This means that one situation has different solutions. One rule has multiple interpretations. And mostly, I think we should have to deal with adequate training of technical staff from public bodies, because it's very easy to find, for instance, a municipality without a technician able to analyze the compliance with certain technical requirements. Of course, we cannot yet anticipate the balance between benefits and challenges, and also the timing to have this legal revolution concluded and more importantly implemented is a challenge by itself. In any case, we understand that this is a trend, and we can already see some baby steps in Portugal which are quite positive and really hope. I have the land law, which has condensed 4 legal regimes from the 90s regarding licensing and private constructions, land division operation, embargoes, etc. I have the legal regime of access and exercise of activities and commerce, services and restaurants that not only includes or refers to the applicable regimes in a single diploma, but also creates standard procedures for the majority of these commerce and services activities. We also have the legal regime of the, responsible industry system that consolidates in a single diploma matters relating with the exercise of the industrial activity, the installation of the new responsible enterprise zones, and the accreditation of entities within the scope of industrial licensing. We have a single environmental licensing which harmonize and articulate various local licensing procedure regimes in what respects environmental. So baby steps that show that we do have capacity to set coherent rules, easily understandable for several professionals involved, which gives me hope that my problem of having to carry with me to meetings, dozens of documents with multiple laws can be solved in the future. Just hope so for my benefits, for my back benefits. Finally, I could not conclude my presentation without sharing some of the market trends that I believe will need to be addressed and that any code should accommodate. Privatization and contracts versus liability of the developers and its technical teams. Planning flexibility to accommodate new and innovative projects and investments. And this is a very sensitive issue because we need to have a balance between this and the stability. But we need some dynamic that allow us this flexibility. The right to housing in current crisis scenario. This is a hot matter in Portugal right now. Urban mobility, co-living built-to-rent products. Everyone has this now. Investors can, how can I do this? And the master plan doesn't allow, sorry, it's not an answer. Ecological compensation and funds, and more if I would have the time. So in summary, I can say that the existence of a code is an open question in Portugal. Although this could be a very hard task, I strongly believe that this may be the future. I'm not sure if we should have if we should demand for one single code. At the end of the day, it could be a code with more pages than Tolstoy or this. So at least we should demand for 2 or 3 codes with coherent set of rules that at least would avoid the current roller coaster feeling that every developer faces when licensing the project. I do not anticipate that Portuguese government can deal with this on a short period of time. However, I do believe that we should keep studying this possibility and insisting in its implementation. I think it's the future with this kind of conferences, very helpful, and I strongly believe in this. Many thanks, and that's Portugal.
Thank you, Andrea, for your insights from Portugal. And yeah, I totally agree with you that sharing the ideas and those new trends from each country helps us to broaden out our, thinking. Helps us to get new ideas, share in our own market afterwards, and it causes better changes. And that's why we are doing this. We want better change for all our countries. Thanks for Andrea, and we're moving from Portugal to Italy, and the first presenter from Italy is Dr. Roberto Panetta. Roberto, you are ready to
share?
Yeah, you are here. Great,
yes,
and you can start sharing your slides if you have them. And
yeah, sure.
Roberto is a partner at Panetta Law Firm. He has been a lecturer in civil law at the Luigi Bocconi University in Milan since 2013, and lecturer of civil law at the Luis Guido Carli University in Rome since 2016. Roberto, since 2020, has been Vice Chairman of the European Society of Construction Law, a permanent member of the Council, and Secretary General of the Italian Society of Construction Law. Roberto is the author and co-author of numerous works on civil law and arbitration. He regularly speaks at conferences and seminars in Italy and abroad on matters pertaining to civil law, arbitration, and dispute courts. Yes, Roberto, we see your presentation. You can put like a slideshow now. And yeah, exactly. And,
yeah, can you see now?
Yes, and we hear you perfectly. 15 minutes are yours.
Thank you very much. Thank you very much for your kind invitation. I'm very pleased to be tonight to share the Italian state of art in terms of building law or building code. This is a good alternative that we have in our jurisdiction. But let me start from 1942, when our legislator decided to opt for a code. So for private works, let me start by saying that in 1942, the Italian legislator decided to adopt a code. And such code also comprises some provisions regarding building and the construction contracts in particular. So as of today, after 70 years, we have still the same code. So the first assumption that we must have is that actually no repeal took place in the meantime, and we have the same set of rules that have been enacted in 1942. And you can easily imagine that it is quite difficult to govern, to regulate a construction contract, but I must confess any kind of contract with a set of rules that have been enacted 70 years ago. But this is the situation, so we have to play this kind of joke. We have to govern our contract by making reference to this kind of code. And in particular, we must make reference to articles 1655, 1677 of the Italian Civil Code, that is the set of rules dedicated especially to construction contracts. And where no major legislative changes have been made to the original rules, case law on one hand and legal scholars, or if you prefer doctrine, have contributed to updating these rules because in our daily life we experienced the need to update such rules without making any kind of repeal, but only by interpreting the same rules that we have in our jurisdiction. And when I say that we have an old code on one hand and we have a different experience on the other hand, I make reference to the fact that in the meantime, so from 1942 to today, the construction industry has hugely developed, and the approach of the original legislators appears from time to time too far removed from the expectations of the parties. So the first question that clients, but also any kind of a person who is called to deal with this kind of provision is to say, but can we derogate from these specific provisions, or we have to comply with them? And this is the most important question that we are called to reply to, and sometimes it is not too easy to make a good answer. And when I say again that the current code is too old for the current expectation, I make reference, for instance, just a few examples to make more concrete my speech. Is to Article 1655 of the Italian Civil Code, where according to the old Civil Code, the builder is required to dispose of the capital necessary to execute the works. In my experience, no builder disposes of the needed capital to execute the works. And nowadays, any builder is free, but I must also specify that any builder is required to avail himself of a loan granted by banks. And another example can be also the same article as an implied term, say that the construction contract can be stipulated in any form, even orally. Actually, in our experience, we do not have any case where the construction contract is stipulated in an oral form. All contracts that we have experienced so far are in a written form. And this for proof, for sure, for proof on one end, but even because there are other rules that implies that, for instance, all cost for health and safety must be provided in writing, and so provide that health and safety cost must be provided in writing. How can I have an oral contract? It is impossible. This means that finally, the entire contract must be concluded in a written form. But even if we consider the project, even the project, we cannot imagine a project that is not in a writing in a written form. Therefore, as the project is an annex to the main contract, we cannot imagine a contract that is in an oral form. And Article 1657 of the Italian Civil Code, the construction contract is still valid even in the event that the parties have not fixed the price. I don't know if you have experience of a contract without a price. Such provision is never used, provided that the price includes certain costs that must be provided in advance under penalty of nullity. And again, Article 1665 of the Italian Civil Code provides that the builder is entitled to be paid at the end of the works upon acceptance of such works. And then I ask to all other participants, do you have experience of contracts that provides for a payment only at the end of the works? I have no experience in this regard. So even this provision is too old. This provision is only justified in a different period of our history. It's justified 70 years ago, when perhaps construction contracts were strictly related to small projects. So the payment could be executed at the end of the works. And we also experience some gaps. Under the Italian Civil Code, there is no specific rule for contracts for services that should be governed by the same rules provided for construction of works. In other terms, we apply the same rules to a service contract, same rules that have been provided by the legislator for construction of works. And such gap implies that contracts for services are governed by the rules provided for construction works or supply contracts and general principle of law. So there is a combination of many sources of law in order to regulate a service contract. No reference is made to dispute avoidance mechanism legislation that was only enacted in September 2010 in order to overcome difficulties caused by the COVID-19 pandemic. And such gap entails that any project usually takes a long time to be completed. So even the entire code that is composed of more than 2,000 articles does not provide any provision for the dispute avoidance mechanism, and we are all aware of the importance of such mechanism. So, in my view, there is no demand for codification, because as this is the experience, we have no demand for codification, or moreover, there is no need to codify. The parties are exercising the right to better regulate their contract without making any reference to the existing statutory rules. So we are experiencing that the parties are trying to regulate their contractual relationship without making any reference to the statutory rules, and by applying the rules that they imagine are able to govern their relationship. So in other words, contractual autonomy prevails over any rules that are not mandatory. And even the judge or the arbitrator is mostly in favor of recognizing the contract as the sole law of the parties and to interpret their will without any external reference. This is a common law approach, as you can imagine, as you know much better than me. So it is the approach, is the positive approach, the approach to look at the contract and full stop, no more than the contract. Frequent issues, and I am going to the end, whether the parties, the frequent issues or the frequent questions, as I have already anticipated, is whether the parties may derogate from the applicable regulation, and the answer, as it is the case more often, is it depends. It depends on what? It depends on the surrounding interest. It depends on the fact that if the interest is up to the parties or it is over the parties. Which are the relevant sources capable of supplementing the contract? And in this case, we look at the role of non-legislative sources of law. For instance, the price list of the Chamber of Commerce in the event that the parties were not able to decide which is the price of the contract, or the recourse to a lex mercatoria. Finally, we have no experience in Italy in terms of pre-drafted contract. I'm used to apply FIDI contracts in my activity. FIDI contracts are not considered a good point of reference under the Italian jurisdiction. So there is no widespread adoption of international standard forms of contract in Italy. So the parties are called to draft clause by clause their contractual relationship. So the tendency is a tendency to decodification. There is a tendency to open the door to contractual autonomy within the framework provided by the general principles of law and by the mandatory rules that normally, but not exclusively, regulate public works. And there is also a tendency to better regulate the ADR mechanism. For instance, as I have already said, the reference to the Collegio Consultivo Tecnico, that is the Italian version of the dispute board that has just been enacted just 1 year ago in the Italian legal system. Before that, no experience of ADR mechanism specifically for construction. Many thanks for your attention, and I hope to have satisfied your expectations.
Roberto, thank you so much for the perfect presentation, and I totally agree with you. If the legislator is a little bit lazy and is not amending the law, or maybe Italy is a big country and to agree on new rules is quite difficult, and I totally understand that. For us, for Lithuania, we are a small country. It's easier to agree in the parliament on new rules. For you in Italy, we'll see, and it's cultural difference. Therefore, scholars have a lot of work, and then case law has a lot of law to implement with new rules those gaps which are needed to be filled in. And again, this conference showed me how different we are and what we had in the Nordic discussion when they have those forms and standard forms and they are using it. And now Italy is saying, well, even FIDIC is not a very good form and you have to know local law and make your own contracts. And when it comes to Eastern Europe, then FIDIC is totally fine because they won't catch up with, best practices from Western Europe and so on. So it's just show how different and similar we are at some points. Thank you a lot, Roberto, and I hope we have small discussion afterwards. And now I invite Francesco Castoldi. Francesco, do we have you? Yes. Hi. We hear you perfectly, and if you're having your slides, you can start sharing it. And Francesco is a counsel at law firm Legans in Italy, and he specializes in administrative, real estate, and environmental law. During his professional career, he has given advice on numerous complex transactions in relation to various real estate assets with different designated uses, both of real estate properties and development areas. He is regularly involved in analysis of urban construction and environmental aspects of various developments. So, Francesco, the stage is yours, and we see your slides.
Okay, thank you very much for inviting me to this important conference. My speech, in fact, aims to draw a very synthetic picture of the Italian legislative building regime and territorial framework and planning framework from the perspective of a public lawyer. My colleague speaks from the perspective, obviously, of a civil lawyer and contracts. I will speak from the perspective of a public lawyer, so I will deal mainly with level of governments, public procedures for the building permits, and allowed building interventions. Therefore, I will draw a very synthetic picture of the building regime from which the reason of a potential push towards a new codification in fact emerged. Following this, I will provide some insights into some of the ways in which the legislation has evolved in some terms in Italy to benefit private operators, some ideas of what could be improved, and some steps that have been taken in this direction. So the time is short, and we'll start immediately. Main steps in the construction regulation in Italy. We have the first town planning law dates back to 1932 and introduced at national level for the first time the building titles, which are the titles that are required for the building interventions in the territory, and the town planning instruments from a town planning perspective, such as the general zoning plan, the implementing zoning plan, which are the main plans that are used, obviously, to regulate the municipal territory. Important, very important amendments have been provided during the 60s, between 67 and 68, with some laws that regulated the building parameters, regulated the town planning zones of the town, subdividing the municipal territory between the town planning zones such as zone E for the residential, B for expansion, for example, zone D for industrial use, E for agricultural. And most important, they introduced the public equipment. Public equipment are some public, such as green areas and public parking lots, which have mandatorily to be retrieved when a building interventions is carried out in the territory, because such building intervention increases the zoning burden, and the zoning burden must be compensated with the public equipment and standards. This particular regulation was introduced during the 60s. Afterwards, several building laws occurred between the 70s and the 80s, but it is in 2001, between 2001 and 2003, that a national building legislation unified such laws, building laws, in a code which included several building texts and legislation occurred during the 70s and the 80s. This building law, which we called in Italy testo unico, a unique test which unify some corpus of building laws occurred during the previous years, entered into force in 2003 and is currently in force in Italy. Law about encumbrances is provided by a code issued in 2004, which with respect to landscape encumbrances and cultural goods mainly. And then there is the regional legislation, which obviously in Italy is an important step because every territory has its legislation, its plans, its qualifications, and I will try to explain very short in the next slides. But first of all, let's define some principles. National legislation defines some principles, or try to do that. First principle is the use of the town planning instruments for the regulation of the territory. The territory must be regulated by some specific instruments, such as the general zoning plan and implementing zoning plan. And this is the first principle. The second principle is the qualification of the main building interventions in order also to identify which building interventions are onerous. So they need the payment of the zoning fees for the authorization of the building interventions. The main building interventions are new building construction, building refurbishment, restore, extraordinary and ordinary maintenance. Then another principle is the building titles, which allow interventions. There is a dichotomy between building authorization and self-declarations. Self-declarations can be filed with the municipality by the private operators for the allowing the building interventions without the obtainment of a specific administrative authorization. And this is quite important in order to shorten the timing of the procedure. Then another principle at the legislation stage is the regulation of the building parameters. One of the most important is the distances between buildings. The distance between buildings cannot be more than 10 meters because it is a general principle in order to avoid for hygienic reasons. But obviously the region also tried to derogate this important principle in any kind. No, in fact, not understanding the building law, sometimes a lack of coordination, sometimes is optimistic. In any case, there is a lack of coordination between national and regional legislation and regional and local legislation regulation. There is a big fragmentation in the Italian territory. Why? First of all, because the building code in force in some cases allows the region to extend or reduce the regulation of the national rules. For example, identify further building interventions which are subject to simplified procedure by, for example, filing a simple self-declarations in the form of a CILA of a SCIA. Or in some cases, also with respect to building parameters in case of town planning reorganization of the territory. The building law says that when the municipality wants to reorganize the territory, in some cases can derogate the distances, and this create a great lack of coordination between the different level of governments. In fact, as a result, in some cases, regional and national law legislation may not be coordinating at all. For example, Emilia-Romagna introduced some cases in which the self-declaration is mandatory. The self-declaration is not mandatory, it's a faculty provided by the national law, but it's not mandatory. So regional law in Emilia-Romagna, and which is a region in Italy, and the national law are in conflict in this respect. Lack of coordination may also occur between regional and local level. For example, in case of the application of some rules related to the regeneration of dismissed building in the territory. In Italy, the law is trying to reduce the consumption of the soil and enhance the regeneration of the dismissed building. And in this case, also incentives are provided to the private operator for such regeneration procedure. But obviously, there are some lack of coordination between the different level of governments, between in particular local and regional, about the application of these specific provisions. Therefore, some amendment might be provided to the national legislation in order to improve the coordination between the different level of governments. Before reviewing the tentative in this respect, I would like also to be positive. I'll try to be positive in order to summarize some good things that has been done in Italy in the building law in order to make the world operator easier, if possible, and more immediate. The first one is the simplification of building procedures, mainly by identifying increased interventions which are subject to self-declaration. Obviously, the filing of a simple self-declaration with the municipality is easier than carry out a procedure for obtaining an express building permit, which can take time, involve several authorities. It is quite hard to carry out. In fact, the interventions authorized by a SCIA is simpler. The problem is that it is not clear, definitely, when I can file or for what interventions I can file self-declarations, and for what intervention I need to have the building permit. In Italy, in fact, you can very often, almost always, file self-declaration, but in some specific cases. In any case, this particular kind of procedure should be better clarified. Another good thing that has been done is clarification on measures aiming at identifying the building authorized status. When I have to ask a building permit, I have to provide the municipality with a building authorized status. I have to provide the building permit for the main construction, the building permit for the other building interventions carried out in the property. And in 2020, the national legislation has been implemented in order to clarify to the operators which building titles shall be taken into consideration in order to present to the municipality the authorized status. Also, other simplification rules on public works procedures and improvement of administrative capacity have been done in the last years, in particular for the construction and public procurement side. It is important also, in my opinion, the regional step, because in the town planning and building law, the base is the territory. And the territory has its rules, specific rules. So also the praxis of the regional and of the territory are very important. And in this view, I think that one important change in the last years has been the application for regional unified modules. Regional unified modules have the aim to provide to the private operators in the region a unique module which is clear and can be filed and filled in order to allow building interventions, but at the same for all the municipalities, all the territorial stage. And this is important in order to avoid confusion. Another important thing is the tentative to unify at regional level the main rules of the local building regulations. In Italy, we have local regulations which are very difficult to understand sometimes, and there is a large autonomy in reading such building regulations. So if one building regulation is different from another in a different town, for the private operators it's difficult to understand and to know all the applicable rules. And one of the most important changes has been, in fact, the unification at the regional level of the main rules. In fact, some rules keep on being applied at the municipality stage. For example, in my town, the municipality of Milan introduced a specific procedure for the verification of the static and seismic of the buildings, which is not provided by the national law. And so it is a specific procedure. You have to obtain a specific certification which is not provided by the national law, and you have to file it and to produce to the municipality if requested. And if you do not produce, the fit for use is revoked. it's quite most. Obviously, the frequent issues, there are some issues which have to be faced in order to improve the activity of the building operators and in the light of more efficient regulation of the territory. The coordination between the local level of governments, we already said, the simplification in the administrative procedures for the obtainment of the building titles, we already said, in particular with respect of the need to clarify timing and procedures for the obtaining of the specific administrative authorization and by the municipality. Moreover, precise legal qualification of building interventions have to be improved, because sometimes it's difficult to understand which are the onerous interventions for the private operator, which are the onerous building interventions which imply the payment of zoning fees, and which are not onerous. And this can create some problems during the different stage of life of the building and of the building interventions. Also, the sanction to be applied at the criminal and administrative stage should be better clarified, because we have only the demolition, some fines. The criminal sanction is very, very large. You can apply even in any case there is a lack of compliance with the public law. In the light one, the hard one only in case of important irregularity, but the light one can be applied to almost everything, and this is not acceptable for the private operators because there is it is not so clear which are the sanctions applied to the specific building irregularities. Moreover, public encumbrances and technical regulation, the procedures related to public encumbrances such as cultural goods, landscape encumbrances, and technical regulation with respect to the seismic procedures should be clarified better, because for the private operators it's very difficult in some cases to apply these specific technical provisions. What has been done? But recently, there is a procedure in January 2020 started for the approval of a new build of a national building code, which had the aim to update and revise the category of building interventions in a tentative of distinguish with better clarify intervention on existing buildings and interventions which transform developed land, and to define which interventions are onerous and require the payment of zoning fees and which are not. Simplified administrative procedure, also the amnesty procedures, which are carried out in order to regularize building irregularities. Redefine the system of sanction and fines, as we said before, in order to create a specific sanction for the specific irregularities. We cannot have only the demolition, some fines, and a large application of a criminal law, which is provided by one provision in the building law. It's the law, the application of sanction must be better clarified, and provide also for the revision of the seismic authorization process in a way of simplification and efficiency. Another important, in my opinion, specific regulative trend regards the regeneration. The regeneration is a trend in Italy which tries to reduce the soil consumption and the regenerate dismissal buildings. And in these cases, the private operators have also incentives, volumetric incentives, in order more volume are allowed by the municipality in order to enhance such regeneration and such regeneration process. The problem is that, as I said before, there are fights between local and regional level of governments in the application of this legislation, and obviously in the definition of the volumetric incentives. So a bill on regeneration is being studied in Italy, which aims at introducing national regulation applicable to regeneration procedures and the related incentives, to the constitution of a national program for town planning and regeneration and the related national fund, a national control room on interministerial composition for urban policies, and the local town planning instruments for the detection of the area to use to regeneration. But such town planning instruments are provided at the national level, not at the territorial one, because if it is provided at the territorial one, every municipality will do what it wants. My speech is over. Thank you.
Thank you, Francesco, for your presentation. I really enjoyed all those, trends you mentioned, and all that new legislation which is coming in. And well, we also heard again similarities and differences of EU countries. And in the morning, we heard from the presenter from Finland that they are introducing new legislation to encourage carbon print issues and so on, to reduce carbon effect and climate change matters. In Lithuania, we also made the same changes in the beginning of this year. You're also mentioning bill of regeneration, which also is related to that, because we have to build more in a brown field, not in a green field investments. And You mentioned law on infrastructure. We have the same from this year in Lithuania. So we see that those trends are going all over Europe. So thank you so much, Francesco. And we are moving to Greece now, and we have Professor Eugenia Diaconia. Eugenia, are you here? Yes, we see you already. You can start sharing your presentation. And she's professor of civil law at Athens University. She is member of UNIDROIT Governing Council of the European Group on Tour Law, of various foreign and Hellenic law associations, and of various European and international research groups, delegate of Greece at various conferences, and Eugenia is the author of 5 books and of more than 60 articles, chapters, and collective books, and commentaries on course decisions, book reviews in Greek, English, and French. She's also a member of the Athens Bar and has acted as arbitrator in Greek and ICC arbitration. So, Eugenia, it is a real pleasure to have you here. And if you're having your slides, you may start sharing them.
Good afternoon. Thank you very much, Evaldas, for your kind words, and also I thank WALLESS and Mykolas Romeris for the kind invitation to participate in this conference, which enabled us to travel all over Europe. In 2008, I had the opportunity in the frame of the Erasmus Academic Exchange to visit Vilnius and Mykolas Romeris after an invitation of Professor Simona Drukteinen. And I gave some lectures in tort law, and I keep the best of souvenirs. So thank you for that. So coming to our topic, I will start with the historical developments of building regulations in Greece. After the creation of the Greek state in 1830, a royal decree was issued in 1836 for the implementation of the plan of the city of Athens, which was later extended to the other towns and Dutch villages in Greece. A first general building regulation was introduced in 1929, followed by other 2 in 1955 and also in 1973. After the 7 years dictatorship, 1967 to 1974, a new constitution was adopted in Greece, which provided in Article 24 that the protection of the natural and cultural environment constitutes a duty of the state, and that the master plan of the country and the arrangement, development, urbanization, and expansion of towns and residential areas in general shall be under the regulatory authority and the control of the state, in the aim of serving the functionality and the development of inhabited areas and of securing the best possible living conditions. In order to implement the Greek constitution, the General Building Regulation of 1985 was enacted. Its aim was to define the terms, restrictions, and conditions for the execution of any construction inside or outside approved urban plans in order to protect the natural, residential, and cultural environment, as well as to serve the social interest. The General Building Regulation of 1985, as amended several times, was finally abolished and replaced with the Law 4067 of 2012, which is now the new building regulation and is now in force, also amended several times till today, 3 times the last year. Apart from and in parallel from this building regulation, we have also special laws, the ones you can see at the slide, on special planning and environment, on residential areas, on the expansion of urban plans, and so on.
Eugenia, I'm sorry, we are not seeing your slides.
You cannot see it?
Yes, so could you start, just try to share the screen?
I did it before. I will try again. Share screen. Why doesn't work? I'm sorry about that, but Does it work now?
No, unfortunately, we don't see it.
Just a moment, I will try to see. But do you have it? Can you share it? I have sent it to you, if it's possible.
Wait a moment.
I don't know why it doesn't work. What is that piece? Oh.
Yes, now we see it, Eugenia.
Can you see it now?
Yeah, we can see it now. You can proceed.
Can you hear me as well?
Yes, we hear you as well.
All right. So in relation to the legal, shall I start again? No, I just continue. Just I have presented the
yeah, you just continue. Just continue.
Pieces of legislation. So I wanted to present some related decisions of the Council of the State. Council of the State is the Greek Court of Cassation in administrative matters, and some decisions related to the building regulation and to the other pieces of legislation. So the Council of the State, in a decision of 1986, held that the long-term vision of urban planning and land reallotment that was provided in Law 947 needs a procedural system that will govern the preparation of urban planning study, and no such procedural provisions are contained in this law, but this has as a consequence that the urban land reallotment cannot be applied. Nevertheless, according to the Council of the State, this does not cause a gap in the urban planning legislation because the law contains relevant transitional provisions. Another decision held that the building restrictions that were imposed at the island of Zakynthos for the protection of the turbid Kareta were held legal, though there was no general special plan of the country ready. That nevertheless, it was considered that a decree imposing building restrictions for the protection of the environment before the preparation of a general special plan is allowed. Also, the Presidential Decree of 1983, which provided that the minimum plot surface must not be less than 2 hectares in certain areas in Attica, does not exceed the limits of the legislative authorization, as the Presidential Decree prevented further development of dense construction in Attica, protected the environment. There was no contradiction to Article 17 of the Constitution for the protection of ownership. Thus, it was held constitutional and it could be applicable. Coming back to the pieces of legislation, what after the 2000, in the 21st century, we have 2 laws, in 2013 and in 2017, dealing with illegal construction, which exists, of course, in Greece, and with the control and protection of the built environment. The aim is to create an innovative and comprehensive system of rules and principles, trying to solve the dysfunctions of the past and lead to the upgrading of the residential environment and the improvement of living conditions. The law of 2017 provides for the electronic identity of buildings, for the building identity certificate. That means that all buildings, for all buildings, will have a record of the current condition. We can monitor and control their changes during their lives, and an electronic file is going to be created with all information related to each building. This will have 3 phases. First, the registration of the plot of land, then the registration of the ownership, and then the issuance of the building identity certificate, which will have its own authenticity key and exclusive identification code. Of course, as you can understand, the application of the law has been postponed till the end of this year, and I think there will be a postponement again. That means that it has not started to be in force. Has not started to be in force. Coming back, I wanted to come back a little bit before presenting the features of the 2012 new building regulation. Coming back to the general building regulation of 1985 and why it needed to be also amended, to mention some decisions again of the Council of the State that deal with the anti-constitutionality of certain articles of this general building regulation. So the Council of the State in 1988 held that Articles 8 and 9 of the 1985 General Building Regulation were anti-constitutional in contradiction with the constitutional provisions of Article 24 about the protection of the natural and cultural environment and the improvement of the living conditions. What did these articles provide? They increased by 30% the permitted outline of the buildings, and they gave to the owner the freedom to place the building up to the lateral and rear boundaries of its plot. And the court considered that this reduced the free of course uncovered spaces, rendered the conditions of lighting, ventilation, etc. of all built plots more unfavorable, and it held these provisions unconstitutional. As the court stated, the common legislator may amend the existing urban planning regulations, but only for further improvement of the living conditions of the residents and not in order to deteriorate them. Also, another decision of 1988 considered that Article 14 of the building regulation was contrary to the constitutional provisions. And what did this article provide for? It allowed the owner of a residential building with maximum height of 8.50 meters, which it was called according to the regulation low building. It allowed the owner of these buildings to place these low buildings freely on the plot. This also was considered as leading to the degradation of the environment, and thus this provision was held as anti-constitutional. Let's speak now about the main features of the new building regulation of 2012. What are the aims of this regulation? To protect the architectural and natural heritage, to not to allow servitudes that have as a consequence the restriction of the possibility of constructing or expanding a building. It introduces incentives for the environmental upgrade and the amelioration of the quality of life in dense and urban areas. It limits, as a general rule, the outline of a building to 60% of the plot surface, imposes landscaping, welcomes planted roofs. Constructions allowed over the maximum height of a building must comply with its architectural aspect. Constructions in public common areas of an inhabited area are allowed only for certain reasons. It introduces incentives for the creation of buildings of minimum energy consumption. It provides that new buildings must ensure the accessibility without barriers for persons with disabilities. It doesn't take advantage, though, of the BIM technology. In general, only the geographic information system is used for the cadastral Greece and for the monitoring of urban plans and local building restrictions. Apart from those regulations, I want to mention also the earthquake resistance regulations. Greece is a country that suffers from earthquakes, and in an effort to avoid the catastrophic effects of these earthquakes, Greece implemented as early as 1959 the earthquake resistance regulation after large destructive earthquakes that took place in several parts of Greece during the 5-year period between 1953 and 1957. Earthquakes of a magnitude ranging from 6.8 to 7.5 on the Richter scale. The main objectives of this regulation was to limit or even avoid financial losses in case of earthquakes of moderate intensities, and also to protect the human life in case of high intensities earthquakes. Of course, now we have also the Eurocode 8 on the design of structures for earthquake resistance that you all know. It was approved in 2004 by the European Committee for Standardization and aims as well at ensuring that in the event of an earthquake, the protection of human life will be provided, damage will be limited, and the structures that are important for civil protection will remain operational even after the occurrence of the seismic event. Coming now to the general conclusion. The existence of many pieces of legislation since 1929 till today, with a lot of amendments, shows that though there has been an effort of innovation and of giving solutions to the existing problems, the latter, of course, remain. What are the reasons for that? The provisions are very complicated. There are constant amendments. The provisions provide for a need of presidential decrees for their implementation, which are sometimes late issued or they are never issued. There are a lot of exceptions to the introduced rules. All these have as a result that no uniformity can be achieved. Other additional reasons for the problems: non-adequate control of the Urban Planning Office, acceptance of illegalities in construction, difficulties to demolish existing construction after many years of their existence, because we have a status quo that has been created, and this is reflected in a decision of the Council of the State of 2015, where it is mentioned that taking into account the package of measures enacted in 2015 in the law that I mentioned of 2015, to prevent the continuation of illegal constructions. So by this law, we have introduction of package of measures enacted to prevent continuation of illegal construction activity for the future. The court held that the relevant regulations of this law, which allow the continuation of existence and the non-demolition of illegally built constructions of the past, are constitutionally tolerated in order not to change all the status quo that in between has happened. What are the proposals? The proposal is, according to my view, that we have to have a simpler building regulation, a regulation that will not introduce exceptions, that it will not give bonuses, that will focus at the protection of the environment and at having viable and aesthetic cities without looking at small interests. This is almost the end of my presentation, but I wanted to go, it is special just for if of interest to tort lawyers, to try to, before closing, to answer a question that could be of interest. The question is, can the violation of a building regulation generate an application for damages? According to our Greek Court of Cassation, Arios Pagos, which is the Court of Cassation for civil now and penal cases, if a private interest has been violated, a right for damages exists only if the provision of law that has been violated expressly or according to the intention of the legislator protects or is also meant to protect the said private interest. From the provision of Article 24 of the Greek Constitution for the protection of the natural and cultural environment, the court held that it clearly derives that the provisions of the General Building Regulation, regulating the height of a building, the distances from the side and rear boundaries of the plots of land, etc., have not been enacted exclusively and only for the protection of the general interest. They are also meant to protect the private interest of the owners of the adjacent immovables. Accordingly, according to the court, if a building has less sun, light, and air, and the living conditions of its tenants deteriorated because the neighbors built directly on the boundary between the two plots of land, in violation of the General Building Regulation, which requires a distance of 3 meters from the joint boundary, the persons affected have a claim for damages. Same applies, according to the court, if the building which has been constructed without a permit obstructs the view to the sea of the adjacent buildings. I think this is all for the moment, and I thank you for your attention.
Thank you, Evgenia, for your presentation. And again, we see a lot of similarities and differences. For example, the proposals to simplify building regulations, which you mentioned in your last slide, they are connected with the creation of rules without exceptions or without bonuses. But what we heard from the speakers from Poland, they emphasize differently that, well, the building code's creation is stuck in the country. Therefore, what they are doing, they enacted exceptional rules for different industries as constructing the roads or constructing a LNG terminal and so on. So different countries have their different approaches. And Evgenia, thank you for your very broad presentation. And we have the last speaker here is Daniel Tienda, and he will present us the regulations in Spain. And he is partner in cases in La Cambra in Spain. His practice is focused on real estate. Daniel advice in real estate matters extends to the public law aspects of urban matters, planning and permitting, concessions and licensing with the public administration. Daniel has been listed by Legal 500 and Chambers Europe directories. And yes, Daniel, we are seeing your slides and you can put them on presentation mode.
Good afternoon to everyone. Thank you. Special thank you to the university for this interesting presentation. Mykolas University, and I think it's very interesting to bring together the different jurisdictions in Europe who have been, let's say, sharing with us the different views of the regulation of the building and construction law in their countries. The good point, or the good aspect to be the last one speaking, is that now I can tell you that in Spain is very similar to the rest of the jurisdictions that have been already introduced. No? But basically, I think you can see the presentation now, right?
Yes, we can see your presentation. Everything is there.
So I can say that in Spain, we have a civil code, like many other countries, that in some of the articles, they regulate the construction provisions and the contracts under the building and construction law. But we don't have a specific code, a part of what is called the technical construction code. That this is a very technical code referred to how the building parameters and the building processes needs to be done, but it's more technical than purely legal. And then we have a very relevant act that was passed in 1999 that is called the Spanish Building Act. It's, I can say, and according to some cross-border transactions that we are doing with foreign investors in Spain, I can say that it surprised to many jurisdictions how protective the Spanish Building Act is with the final purchaser of the final construction, not even if it's a residential unit or if it's a hotel or whatever it is. Basically, the Spanish Building Act has been granted on some principles, like, for example, the protection of the consumer, and also the publicity and protection of the amounts that the final purchaser are advancing during the process of a development, for example. Our jurisdiction has gone so far that we have a ruling from the Supreme Court that has been very, very relevant 5 years ago, stating that in all cases of development of residential in Spain, when the purchaser had planned, that this is a very typical way of acquisition in Spain, the developer needs to guarantee to deposit in a financial institution, in a bank, the amounts that the purchaser are paying in different installments through the process of development. This ruling is very relevant because when the crisis came in Spain and all Europe in 2008, basically some of the developers were not, they could not afford the return of some of the amounts that many projects and developments were already deposited by the final customer, and the Supreme Court obliged the banks to pay on behalf of the developers that amount. So this is all based in this Spanish Building Act that is, let's say, a very guaranteed in terms of the protection of the final consumer when a process of development is launched. I'm explaining this because most of the construction regulation in Spain is based on the principles stated in that Spanish Building Act. And then we have what we call other regulations that in Spain are a little bit complex because the different regions, they have a lot of competencies that are transferred from the central government, specifically in terms of urban planning and in terms of what is called housing policy or housing regulation. The urban planning law is different in the 17 regions of Spain. I can say that in principle, most of them are pretty similar in the main aspects, but they have particularities. So it's very important to choose the region where you are working or where you are launching the project in order to see how the process is gonna work. And then, and I think this is very similar to other countries, you have the municipal urban planning, different urban plannings according to the municipalities in every town hall that has the competence to specifically launch particular plans for urbanization of the different areas of the municipality. No? I can say that this has been a problem or an issue during many years because in my opinion, the more complex the regulation is, the less efficient the construction is. And at the same time, I can see that for a foreign investor, that is something that I'm very focused on my work, the simple or the more simple that the process of building is, the more attractive results, because normally it takes shorter time if the regulation is a little bit more complex. No? In this direction, several regions in Spain, like Madrid, like Andalusia in the south of Spain, or like the Balear Islands, Ibiza, and the most, let's say, explosive and more developing regions in terms of new infrastructure, new construction, some mechanisms to substitute some, for example, licenses or administrative permissions or permits that were requested in order to be able to build. In one of them, let's say, better examples is in relation with Madrid, that has recently last year launched it under the situation with COVID umbrella, but it's in force due to that, but it's going to be still in force. Significant reduction in terms of building licenses. Now, the developer, of course, has to submit a technical project to the municipality architect, but you don't need to wait for the permission, but just to fulfill a formulary, and only if the administration see that there is a defect or that needs some clarification in relation to some type of information, they will request further information. But this is something very useful because at the same time, when the project is finished, an architect will certify that it's according to the project that was submitted, but you don't need to wait again for the administration to launch what is called before a license of occupancy that was delaying the delivery of the projects strongly, and also the financing of the banks and the financial institutes, and because they were waiting for these permits in order to give green light to the financing of the different developments, specifically when talking about commercial development and some hospitality development as well. And this is something that has improved a lot the interest of the investment in the region, and also the simplifying of the process, what I think is something that was required, and it was very useful. Also, one of the new, let's say, measures that has been adopted in Spain is the consolidation of several town planning in many of the main cities of Spain. This has again provoked, as a result of the compilation, a more easy access to the regulation in force and a decrease of the bureaucracy, what is something important, and specifically, and this is something that is a frequent issue in the process of development and construction in Spain. That is what I said before, the multi-regulation at a different level of administration, what provokes a lot of misunderstanding, even sometimes like a problem of competencies that goes to the Supreme Court, to the Constitutional Court, to allow certain clearness about which administration has the main, let's say, has to regulate certain issues or certain matters. For example, environmental matters. For example, when it's something about housing, which percentage of housing related to protection housing should be addressed in every project. Some municipalities have been acting very politically, and they have been improving or decreasing the levels of percentage. For example, this is just an example of social housing in each project that has started in their municipality. And what has happened is that basically they didn't have any competence, according to our constitution, to regulate such elements in the construction process. So after several times, the court has ruled that this regulation is not possible to be enforced, and it's against the constitution. So we are seeing a little bit of, let's say, some tensions in terms of the competition of every administration in Spain in that regard. Okay. What I can say also is that we have been seeing during the last 2-3 years, and specifically during the last one, and again, thanks to COVID, if there is something that we have to say thanks, the effort to adapt the regulation in terms of construction to the new industrial models. For example, several regions have recently legislated in relation with the co-living, also in relation with the build to rent, also in relation with what is called the industrial kitchens, and certain figures that in the real estate sector, they have been more and more, let's say, frequent, and that the absence of a specific regulation in terms of these new models of developing and construction have made necessary to introduce new regulation, and not in the way to hyper-regulate, that I'm completely against, but more in a way that to clarify which type of contract you can address the new models of construction in order to give protection to the investor and to the final consumer and to the company who is developing, so that everything is quite clear. And I think this is something relevant. Again, and it has been mentioned before by some of you, the European Union efforts to base it on Agenda 2030 and also in the green funds that are already launched or in the way to be launched to most of the countries of the European Union, have also an impact on the construction regulation, because they aim to make a more green regulation and a more environmental friendly regulation with the construction has allowed the different administrations in Spain to launch new measures and new regulation to help, let's say, the construction process to be more efficient and to be, let's say, to attract more investment in the case of Spain. I think this is part of the essential changes that we are seeing in Spain, together with something that is very relevant, that is the tax-friendly measures. Spain is a country with a heavy taxation, specifically in real estate. It's not very, how can I say, friendly in a way that in some regions, specifically in others no, the tax related to the real estate is quite heavy. The aim of most of the regions who are trying to simplify the bureaucracy, as I said before, during the urban planning and urban processes, they are trying to make an effort with the taxation. And again, for example, the stamp duty, the transfer tax, or the real estate tax, which are competence to different levels of the administration in Spain, have been suffering a significant reduction during the last 1 or 2 years in order to simplify again the real estate tax, what I think is something very important. And not only that, also the assignment of public land to develop in cities which are quite, let's say, hot in terms of construction, and they are overbuilt, or let's say there is an over demand, then the administrations, the public administration, are assigning public plot for free under a tender procurement to the developers to build new offer under a specific or against an exchange of a specific rewards to the public administration, for example, like to build a sport rotation center, or to address a big percentage of the resulting houses or units to social housing, or to facilitate the access to living or housing to the young people or unemployed people. What I think is something very important to do, at least in Spain, we have a problem of accessibility to the housing for the young generation, and this is something that the regions, the administration, and the private sector is really working on that to see how can be sorted out. I think this is one of the main points. Also, as I said when I started the presentation, the consumer protection is something that the regulation in Spain has achieved, and thanks basically to this Building Act that established the obligations and liability of every part of the process of construction. Also established the guarantees for the construction, 1 year, 3 years, and 10 years in case of structural matters that can affect to the construction. And I think, as I said before, it's well understood by the sector and the final consumer, and brings security to the system and also stability to the regulation that has not been changed since 1999 in that aspect that I said about the construction process. Well, that's all, and I'm open for any questions that you may have.
Thank you, Daniel, for your very detailed presentation on the situation in Spain. And again, we see that some regions, they have lots of in similar and lots of in common, and we can notice those things here as well in the Southern Europe region, in those old democracies, which are facing the problems how to change the laws, how to adopt them. And yes, sometimes those old regulations, they stop us, but what I see that COVID situation, and I believe that this real estate bubble goes everywhere now, and well, it should encourage public sector to revise the present regulations. And what I see again, carbon economy issues are raised in Spain, energy efficiency, which also was mentioned by Evgenia and other presenters. And I just want to come back to all of you because we are already short in time, and just share your final thoughts, what you also heard from your colleagues. So, Andrea, what would your impressions and your final thoughts?
Can you hear me? I'm sorry.
Yes, yes, we hear you.
Because my webcam is. Can you please repeat your question, Evaldas? I didn't.
What are your final thoughts when you heard the presentations of your colleagues?
Okay.
And what do you think? Are we facing the same problems, and what will be the next trends and regulations of construction law?
It was great to hear my colleagues. It was great to feel that Portugal is not alone in some challenges. Italy and Spain have a lot of, we have the same structure and the same challenges, I believe. I think we all want something simpler, we all want something stable, and we all want something flexible, which can, it seems not make sense, but I think at the end of the day, we need to find the sugar point of this. So, and I think we all agree, maybe not Eugenia, that a code or more, but not so many laws are necessary. I think we are all in the same page at the end of the day.
And thank you, Andrea. Evgenia, would you reflect to that, and what are your final thoughts?
Thank you very much, Evaldas. I didn't say that I'm not, my view is not that we have to have a lot of laws, and it is not that we don't need a code, but in order to have a code, you have to arrive at the final point and to be sure that what you are codifying, it's going to be enforced for a long period. So if you have not arrived at this stage, you cannot ask for a code. And at least in Greece, and as I heard from all other countries as well, I don't think that we have arrived at the stage that we can codify at this moment. Of course, a lot of steps have been taken, and others have to be taken. But I think also that in this we are living now. We live in a digitalized era, and this helps a lot also in terms of gaining time. For example, in Greece, the last 2 years now, all documents are submitted electronically in order to get a permit. So also, for example, in order to have the controller for the certificate of completion, again, we submit electronically. So all this can help, and at the end, we might arrive to a code if we manage to find the bottom line.
And what was said in the North West Europe panel, maybe one day we'll have the European Code on construction. So maybe there was such a wish said, but of course, in a lot of fields we're on the same page, but the countries are so different. But Roberto, Napoleon gave to Europe his civil code, and almost in all Europe we have almost the same civil law rules. And how do you believe, is it possible to have the whole European construction code, which is it possible in the future?
Actually, in my view, it is possible. I'm not sure that I wish a new code. In particular, if we conceive such code as all laws that we have considered all together today, because at the end of this conference we can conclude that construction law is a matter only for good lawyers, in the sense that you must be very, very specialized in this field in order to be able to manage all these levels of norms and levels and many sources of obligations and rights for the parties. So we know that in the past we had many experience in terms of the European Code, for instance, the draft common frame of reference in 2009. But at the end of the day, it seems to be only a doctrinal effort, just an effort to try to imagine something that it is quite difficult to constitute, even because we have very different traditions at the base. So actually, my wish is to have to facilitate the job of the construction lawyers and the people who are involved in such projects by asking the parties to much better discipline their contract, and by also minimizing the participation of the law to the contract. If this can be by a European code, it is okay. Otherwise, I would like just to facilitate by repealing many laws that are not so important so far.
Roberto, I agree with you at some point, and also I believe that colleagues from the Nordic jurisdictions would agree with you when we were talking about the changes of construction rules. The tradition, the importance of tradition was mentioned, and what I see in all the democracies, it is really very important, and those young democracies, they still have to learn a lot, that respect of the tradition, and to understand that every participant of the process, it bears its liability and is liable for the society on what he is doing. Francesco, you presented that Italy made a lot of the recent changes and is going to do more. How do you feel? In which way Italy is moving, and what's your final thoughts would be?
I think that Italy, from a public law perspective, needs to simplify the different level of governments. Italy needs clear national guidelines in order to guide the private operators in the activity of everyday activity for the filing of the titles for the building permits they have to obtain. The point is that the territory cannot be so different one to another. And they need simple guidelines, which obviously have to respect the territorial authority, but have also to guide the authority in the territory in order to implement the activity of the operators. If it is no needed a code, even some guidelines are needed, I think, at a national level in this respect.
Francesco, totally agree with you. And well, the presenter from Austria would also agree with you. When Austria, it looks like a small country for us, yeah, only 9 million inhabitants, but they are a federal country and they have different rules in different lands. So yeah, so those unified rules, at least from the central institutions, from federal institutions, they are necessary just to make the whole process much clearer for all participants. And Daniel, what are your final thoughts on hearing what Greece?
Well, thank you, Evaldas. I'm following my colleagues' statements. I completely agree with their position. I think not only the administration needs to simplify the processes or the procedures for construction and development, but also the authorities need to be guided, as Francesco has said, in order to implement that simplification correctly and allow the private sector and the interest of the public one to, let's say, to simplify the processes and make more accessible for the developers and for the final consumers and for all the parties who intervene in the construction, experts, professionals, and everyone to be able to go and see faster processes and simplify them. And in relation with BALTIcs and European Code of Construction, to be honest, I'm not very optimistic. I think first we need to simplify other things, like, for example, the corporate tax in the European Union, that so far is pretty close, but not yet, and another many important topics. No? The construction European code, I think, is going to be difficult to see. It's very linked, as you said, Evaldas, to tradition in many countries and the costume. So, as I said, it's not the same costume in the south of Spain than in Bergen, for example. So it's going to be difficult to see that harmonization, in my opinion.
Thank you, Daniel, and a huge thank you for all the presenters of today and this our final section. And I wanted to make a short wrap up, and but we made it in every section, at the end of every section, and what I see that conclusions are almost the same. We have a lot of problems in regulations in zoning and planning, and terms are very long, and sometimes there are too many rules in zoning and planning. When it comes to construction, public authorities should behave better and should think how to make the process much more smoother, as Poland has, and they have this, investors table or investors window when they give consultations, and therefore they have smoother processes, which Romania was jealous of having such regulations there. And when it comes to Nordic, all the standard contracts are so important, keeping in mind all the regulations. And when we go back to East, those all technical regulations and normative rules are so important. And yes, we are all very different, but at the same time, we face the same challenges, and we want clear regulation, which would be a little bit simpler, and to make that regulations more consumer friendly. So thank you all of you once again, and see you in other venues and events. Have a good evening, everyone.
Good evening.
Good evening.
Bye-bye. Good evening.
Bye.